Proceeding. Adjournments. Page wise. Page 1, cell number 1 to 4. Page 2, cell number 5 to 11. Page 3, cell number 12 to 22. Page 4, cell number 23 to 30. Page 5, cell number 31 to 37. Page 6, cell number 38 to 42. Page 7, cell number 43. Fraudus, cell number 1, KV Narasimhan, Prakash T. Hebbar.
Matter is settled. We have filed the compromise petition. The plaintiff, my lord, is in appeal. In a suit for declaration and recovery of possession, my lord, the defendant is conceding to our right. In turn, my lord, we have agreed to pay an amount of 50 lakh, 27,000.
Not even compromise, but we say that this compromise binds only you.
Yes, please.
Any third party interest, because these urban litigations, we are scared to record the compromises. ಯಾರಿಗೋ ಇನ್ಯಾರಿಗೋ ಸೇಲ್ ಮಾಡಿರ್ತಾರೆ, ಇನ್ಯಾರಿಗೋ ಒಂದು ಅಗ್ರಿಮೆಂಟ್ ಬರೆದು ಕೊಟ್ಟಿರ್ತಾರೆ. ಅದನ್ನ ಡಿಪ್ರೈ ಮಾಡೋದಕ್ಕೆ ಇಲ್ಲಿ ಬಂದು ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೊಳ್ತಾ ಇದೆ. ವಾಂಟ್ ಅ ಸೀಲ್. We are not reference to this case.
Please.
GY ಮುನೇಶ್ವರ.
ಮುನೇಶ್ವರ್ ಸರ್.
ಅವರಿಲ್ಲ. ಅವ್ರದ್ದು ಇದೆಯಾ ಏನಾದ್ರು?
Present parties.
Both of you are appearing. Aadhaar card, any identity proof?
Yes, my lord. I'll file it.
Copy ಕೊಡಿ. Copy ಕೊಡಿ.
Yes, pass on.
ವಾಪಸ್ ಕೊಡ್ತೀನಿ.
ನೋಡ್ಕೊಳ್ಳಿ ಸ್ವಲ್ಪ ಟ್ಯಾಲಿ ಆಗುತ್ತಾ ಇಲ್ವಾ ಅಂತ. Don't mistake us.
No, ma'am, please.
Because you will encounter the similar situation in some other cases. ಅಷ್ಟೇನೆ.
Yes.
The GY Muneshwar and respondent Sarvapalli Babu Bhaskar.
GPA holder.
His GPA holder.
Whether he is a lineal descendant of Radhakrishna. And the respective GPA holder.
Is a GPA holder.
GPA holder of
Power of attorney holder of the respondent.
GPA ಹಾಕಿದ್ದೀರಾ?
ಹೌದು.
ಎಲ್ಲಿ? Along with this petition or?
ವಕಾಲತ್ತು. Along with the ವಕಾಲತ್.
Original ಎಲ್ಲಿದೆ ಅದ್ರದ್ದು? Original GPA.
Original.
Appeal file ಮಾಡುವಾಗ ಅವರು they had filed it through the party only.
Original.
ಅಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ.
Original.
ಸರಿ ನೋಡ್ಕೊಂಡು original ಇಲ್ಲ ಅಲ್ಲಿದೆ ಅವ್ರ ಹತ್ರ ಕೊಡ್ತೀನಿ.
Original ಅಲ್ಲಿದೆ. ಇಲ್ಲಿ the photocopy, my lord, I have produced along with them.
Photocopy of it.
Yes, madam, please.
What is his name? This is Francis Reddy.
Yes, Francis.
How is he connected to that person? Ivaru real estate navare. This Francis Reddy.
My uncle. He's my uncle.
Francis Reddy and Sarvapalli Bhaskar, na? They are from
Andhra.
no, Woodlawn Cottage. Sarvapalli Venkaya. Care of Pastor Naveen Kumar. Suit ಹಾಕೋ ಅಷ್ಟೊತ್ತಿಗೆ care of ಇದ್ರ ಇವರು? No. In the suit, his address was given a Venkatapura extension, Koramangala.
That has been cancelled.
But appeal is filed by you only. You have given the address,
Yes.
Andhra address.
Please.
He's ಅವ್ರ ಹೆಸರು ಬರ್ಕೊಳ್ತಾ ಇದ್ವಲ್ಲ ಮತ್ತೆ. Appellant, ಆಮೇಲೆ the power of attorney holder of the respondent and the respective counsel are present. Power of attorney ಗೂ ವಕಾಲತ್ ಹಾಕಿದಾರಲ್ಲ, power of attorney ಗೆ
ಹೌದು.
the parties are duly identified by the counsel. The respondent has produced the copy of the power of attorney and he also submitted to the court the original power of attorney for verification. Registry ಅವರೇ ವೆರಿಫೈ ಮಾಡಿ ನೋಡಿ.
Power of attorney ಇದೆ. Original.
This is executed on which date? 23/6/2019.
13, my lord. 2013.
ಎರಡೆರಡು ಡೇಟ್ ಇದೆ ಅಲ್ಲಿ, ಒಂದು 3/6/2013 ಅಂತ ಇದೆ.
Consistent.
23/6/2013 ಕರೆಕ್ಟ್ ಅದು.
Yes.
ಬರ್ದದ್ 9
Please.
17.
ಬೇರೆ ಪೇಜ್ ಅಲ್ಲಿ. The registrar has placed the compromise petition filed by the parties. Appellant and the respondent. Appellant and the power of the respondent admit that they have voluntarily entered into the said compromise petition and the terms of the same. The copies of the other cards of the parties are also taken.
ಆಮೇಲೆ ಕೊಡಿ.
ಏನಂತ ಒಪ್ಕೊಂಡಿದ್ದೀರಾ?
My lord, the defendant is conceding.
ಅವ್ರಿಗೆ ಕೇಳ್ತೀವಿ,
sorry.
ನೀವಲ್ಲ.
I'm sorry.
ಏನಂತ ಕನ್ನಡ ಬರುತ್ತಾ ಇಲ್ವಾ ಅವ್ರಿಗೆ? ಏನಂತ ಒಪ್ಕೊಂಡಿದ್ದೀರಾ ನೀವು?
ಇವಾಗ ownership ನಮ್ಗೆ ಕೊಡ್ತಾ ಇಲ್ಲ.
Mic ಹತ್ರ.
ಜೋರಾಗಿ. ನಮಸ್ಕಾರ ಮೇಡಮ್, ಅವರ ಓನರ್ಶಿಪ್ ನಾವೇ ಅಂತ ಅವರು ಇವಾಗ ನಮ್ಗೆ ಒಪ್ಕೊಂತ ಇದ್ದಾರೆ. ನಾವು ಅವ್ರಿಗೆ ಅದಕ್ಕೆ ನಲ್ಲಿ 50 ಲಕ್ಷ ಚಿಲ್ಲರೆ ಕೊಡ್ತಾ ಇದೀವಿ ಅಮೌಂಟ್ ಅವ್ರಿಗೆ.
ನೀವು ಕೊಡ್ತಾ ಇದ್ದೀರಾ, ಅವ್ರು ಕೊಡ್ತಾ ಇದಾರೆ?
ಇಲ್ಲ, ನಾವು ಕೊಡ್ತಾ ಇದೀವಿ.
ಅಪೆಲೆಂಟ್ ಇನ್ ವ್ಯೂ ಆಫ್ ದ ಬುಕ್ agrees to pay.
Yes.
ಅಲ್ಲ, ಅದೇನೋ ಇಬ್ರು ಸೇರಿ ಸೇಲ್ ಡೀಡ್ ಬರೆದು ಕೊಡ್ಬೇಕು ಅಂತ ಏನೋ ಇತ್ತಲ್ಲ ಇದು.
Please.
Lord, the plaintiff
Okay,
would,
the said amount
execute
is agreed to be paid by the appellant to the respondent at the time of execution of the above said sale deeds. He has already entered into agreements with several persons.
yes.
ಯಾರ್ಯಾರ ಹತ್ರ agreement of sale ಮಾಡ್ಕೊಂಡಿದ್ದೀರಿ?
That also have.
ಅವ್ರು ಹೇಳ್ಬೇಕಲ್ಲ.
Lord, what happened is, plaintiff was agreed to,
ಅವ್ರು ಹೇಳಿಲ್ರಿ, ರಾಜಿ ಮಾಡ್ಕೊಂಡಿರೋ ನೀವ್ರ ಅವ್ರ?
ಒಟ್ಟು 6 ಜನ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡಿ.
ಯಾರ್ಯಾರು ಅವ್ರ ಹೆಸರೇನು?
ಹೆಸರು ಮಾಡ್ಕೊಂಡಿದ್ದೀನಿ.
ಇದೆಲ್ಲ ರಿಯಲ್ ಎಸ್ಟೇಟ್ ಇದನ್ನೇ ಇದೆ.
compromise petition ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ.
ಅದು ಗೊತ್ತಿದೆ, ನಾವು ಓದಿದೀವಿ ಅದನ್ನ.
ಸುರೇಶ್ ಬಾಬು.
ಸರಿ, ಸರಿ.
ಅವ್ರಿಗೆ ತೋರಿಸಿ ಹೇಳೋದು.
ಸುರೇಶ್ ಬಾಬು ಮೇಡಮ್.
ಮಾಡ್ಕೊಂಡಿದ್ರ ಅಂತ ನಿಮಗ್ ಗೊತ್ತಿರೋದಿಲ್ವಾ?
ಸುರೇಶ್ ಬಾಬು ಅಂತ ಒಬ್ಬರು. ಇನ್ನೊಂದು-
So many people, we are feeling that this person is a real estate man.
ಬಾಬು ರೆಡ್ಡಿ ಅಂತ ಇನ್ನೊಬ್ರು. ಇನ್ನೊಬ್ರು
We'll say that this
ಕೃಷ್ಣಮೂರ್ತಿ ಇನ್ನೊಬ್ರದಕ್ಕೆ.
Pardon, Lord.
binds only the party.
ಕೃಷ್ಣಮೂರ್ತಿ ಅಂತ ಇನ್ನೊಬ್ರು.
It doesn't bind any third party interest.
No, my lord, no.
Heard on the compromise petition. Satisfied that the claim is admissible. Admissible. Therefore, admissible under law. Therefore. ನೋಡಿ, ಬಹಳ ಹಳೆ ಟ್ರಾನ್ಸಾಕ್ಷನ್ಸ್ ಇದೆ. ಬಹಳ ಹಳೆ ಸಿನಾಪ್ಸಿಸ್ ಇವ್ರಿಗೆ ಮಾರ್ತಾ ಇದಾರೆ ಅವರು. ಮತ್ತೆ ಇದೇ ಹೊತ್ತಿಗೆ ಇನ್ಯಾರ್ಗಾರ ಮಾರಿದ್ರೆ ಗೊತ್ತಿರೋದಿಲ್ಲ. Admissible under law so far as the interest of the parties involved is concerned. Therefore, the compromise is recorded. The suit dismiss ಆಗಿತ್ತಲ್ಲ ನಿಮ್ದು?
Suit is dismissed.
The informed judgment in order dated 30/11/2001 in OS number 986 of 2001 passed by the Principal Senior Civil Judge, Bangalore Rural District, is hereby set aside. The suit of the appellant plaintiff is declared in terms of the compromise petition. It is made clear that the compromise decree binds only the parties to the suit and the persons claiming under them. Draw decree accordingly. ಇನ್ನು ಎಷ್ಟು ಕೋಟಿ fee ಕೊಟ್ಟಿದ್ದಾರೆ?
2 lakhs.
Refund the
23,000.
refund the court fee to the appellant.
Great.
ಈಗ ಫುಲ್ ಹೋಗುತ್ತೆ. ರಿಫಂಡ್ ಎಲ್ಲ ಅವರು ಒಂದು ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ತಾ ಇದಾರೆ, ಹಂಗೆ ಹೇಳಿದ್ರೆ ಅಲ್ಲಿ ಕೊಡ್ತಾನೆ ಇಲ್ಲ ಅಂತ ಹೇಳಿ. In accordance with.
Great.
ಹಾ,
Party sign on ಮಾಡಿಸ್ಬಿಡಿ.
ಅದೇ ಹೇಳಿ.
Order sheet.
Compare ಮಾಡಿ ಒಂದ್ಸರಿ ಕಂಪೇರ್ ಮಾಡಿ ಹೊಲ್ಕೊಡ್ತಾರೆ.
I will provide the xerox copy.
We'll return it, just ಅದ್ರದ್ದು xerox copy ಕೊಡಿ.
Yes, ma'am.
Old litigation compromise ಮಾಡ್ಕೊಂಡ್ರೆ it is good, but the thing is the way we are seeing the litigations.
Lord, in fact, the apprehension may be true, but the thing is that it will not bind any third parties because parties to the,
But we have made it still
yes,
a note of caution.
yes. Great. ಅವ್ರಿಗೆ ಕೊಡ್ಲಾ?
Next.
The party
Bill number
signature.
2, Ramesh P. Kulkarni, P.S. Mali Patil.
Taken paper,
Signature
I
ತಗೊಳ್ಳಿ.
have taken paper publication, your lordship permits me, I will file it here.
ಅಲ್ಲಿ
is-
ಚೆಕ್
it is-
ಮಾಡ್ತಾರಲ್ರಿ, ನೀವು ಅಲ್ಲಿ ಆಫೀಸಲ್ಲಿ ಫೈಲ್ ಮಾಡಿ. ನಾವು-
Date of appearance, date of appearance is today, my lord.
ಅದೇ ಇರ್ಲಿ, ನಾವು ಹೇಳ್ತೀವಿ ಯಾರ ಇದಾರ ಅಂತ ನೀವು ಫೈಲ್ ಅಥವಾ ನೀವು ಟೆಂಡರ್ ಮಾಡ್ತೀರಿ, ಯಾಕಂದ್ರೆ ಅದು ಕರೆಕ್ಟ್ ಅಪೀಲ್ ನಂಬರ್ ಇತ್ತಾ ನಾವೇ
I will file it.
ಮಾಡ್ಕೊಳ್ಳೋಣ.
I will do the needful. It is published on 31/1 only.
Seeks to produce the copy of the paper publication.
I will file it today, my lord.
The same needs to be verified, therefore the same shall be submitted in the registry. None appears for the respondents. List on. Date next week. The next list in the next week. Appearance. ಅದಕ್ಕೆ ನನ್ನ ಅಪಿಯರ್ಸ್ ಅಂತ ಬರ್ತೀವಿ. ಜನರಲಿ ಅವ್ರು ಬಂದಿರ್ತಾರಲ್ಲ ಇದ್ರೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ ಎಷ್ಟು 3.
R3.
ಬಿಕಾಸ್ ಅಲ್ಲಿ ನೋಟಿಸ್ ಅಲ್ಲಿ ಏನಿರುತ್ತೆ ಅಂದ್ರೆ ಯು ಹ್ಯಾವ್ ಟು ಇನ್ ಅಡ್ರೆಸ್. ಯಾಕಂದ್ರೆ ವೆರಿಫೈ ಮಾಡಿ ಬರ್ಲಿ, ನನ್ನ ಅಪಿಯರ್ಸ್ ಅಂತ ಅದಕ್ಕೆ ಬರ್ತೀವಿ. ಲಿಸ್ಟ್ ಆನ್ ಡೇಟ್ ಕೊಡಿ, ಯಾಕಂದ್ರೆ ಅಪಿಯರೆನ್ಸ್ ಇರೋದ್ರಿಂದ ಅಪಿಯರೆನ್ಸ್
12/3.
12/3.
Bill number 3, Vasant Raj.
I appear for the apparent in this matter, my lords. I filed memo for withdrawal of appeal.
You have filed memo.
Yes, my lord.
Memo file ಮಾಡಿದ್ದೀರಾ?
Why? What was the decree passed?
It was the
So 10 lakhs maintenance was awarded.
respondent's appeal. The settled between the parties and now she is considering to
Decree for divorce was granted subject to the payment of
10 lakhs.
10 lakhs maintenance.
Yes, my lord. Now she is considering for the decree. She want to withdraw the appeal.
But allegations ಉಳ್ಕೊಳತ್ತಲ್ಲ.
ಹಾಗೇನೆ ಹಾಕುದು.
Of realty and desertion, are you aware of the implication of the same? Party is here.
He is not present today.
ಮಾಡಿದ್ರೆ she subjected him to cruelty ಅನ್ನೋದು ಅದೆಲ್ಲ ಉಳಿಯುತ್ತಲ್ಲ findings. Even if she is ready for a divorce, it is up to you. ನೀವೇನ್ ಮಾಡ್ಬೇಕು ನಿಮ್ಗೆ ಬಿಟ್ಟಿದ್ದು, but are you aware of the implication of this?
How I communicated the same. She wants to withdraw.
She has signed it.
She has signed it.
Why don't you get her before the court?
Kindly have it on Monday. I will.
The appellant is not present. Further counsel for the appellant seeks time to keep her present. List on, you want it on Monday? This is from which court? Gramantara Jille, Bengaluru. Okay.
4/3. Bill number 4, B.C. Shivannegowda.
Mutual consent ಮಾಡಿ ಕರ್ಕೊಂಡ್ಬರ್ಬೇಕು.
Appearing for the appellate.
He served Andhra present. Like compliance station ಇದೆ.
Execution attachment warrant.
Awaiting service of notice in respect of.
Respondents.
Stay ಕೊಟ್ಟಿರ್ಲಿಲ್ವಾ ನಿಮ್ಗೆ ಹಿಂದೆ? ಡಿಲೇ ಇದೆ ಅಂತನಾ?
ಹೌದು. Unauthorized passenger traveling in a goods vehicle.
Necessary process. Couldn't stay subject to deposit. Now counsel for the appellant submits that the respondents claimants have taken execution against the appellant in attachment warrant issue ಆಗಿದೆ.
ಹೌದು.
And attachment warrant is issued against the appellant. Considering the same. Considering the same, under circumstances, interim stay of execution of the impugned award till next hearing date, subject to the appellant depositing 50% of the award amount before the tribunal within 4 weeks from the date of the received copy of this order. Please, Tom.
5-4. Cell number 5, B. Pradeep.
This case, my lord, the company name, my lord, IFCO Tokyo, TOKIO, TOKYO ಅಂತ ಬರ್ದ್ಬಿಟ್ಟಿದ್ದಾರೆ. That is the objection.
Because in the name of appellant stated in the cause title. Cause title in if
TOKIO is the insurance company name.
ಅಲ್ಲಿ ಜಡ್ಜ್
ವೈವೋ ಅಂತ ಆಗ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ಲಿ ವೈವೋ ಅಂತ ಆಗಿದೆ.
ವೈವೋ ಅಂತ. That is the only objection.
Oh, it is. One petition is there. Respondents ಒಂದೇ claimant 13. Okay. ನಾವ್ ಹೇಳ್ತೀವಿ ಹಗ್ಲೆಲ್ಲ ಹೇಳ್ತಿರ್ತೀವಿ ಅಲ್ಲಿ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಅವ್ರು ಹಾಗೆ ಬರ್ಕೊಂಡಿರ್ತಾರೆ, ಅಲ್ಲಿ ನೀವು ಕರೆಕ್ಷನ್ ಮಾಡಿಸ್ಕೊಳ್ಳೋದಿಲ್ಲ. ಇಲ್ಲಿ ಬಂದು
ಅದು ಅಬ್ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಸರ್, ನಾನು ಇಲ್ಲಿ ನೋಡುವಾಗ.
ನಾಳೆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲಿ ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ ಇದು ಹೀಗಿದ್ರೆ.
ಹೌದು.
ಏನು ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಕೊಳ್ಳೋದು. ಅಕ್ಸೆಪ್ಟಿಂಗ್ ದ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಷನ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇಸ್ ಓವರ್ ರೂಲ್ಡ್. ಏನೀಗ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾ? ಏನ್ ವಾಟ್ ಇಸ್ ದ ಪಾಯಿಂಟ್ ಇನ್ವಾಲ್ವ್ಡ್?
ಇದರಲ್ಲಿ ರೇವಾ ಕಾರ್ ವಿಚ್ ಇಸ್ ಎಲೆಕ್ಟ್ರಿಕಲ್ ವೆಹಿಕಲ್ ಮಿಲಾಡ್ ಅಪಾರ್ಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಪ್ಲಗಿಂಗ್ ಮಾಡಿ ನಿಲ್ಲಿಸಿದಾಗ ಶಾರ್ಟ್ ಸರ್ಕ್ಯೂಟ್ ಆಗಿ ಫೈರ್ ಆಗುತ್ತೆ. ಅವ್ರು ಫಸ್ಟ್ ಫ್ಲೋರ್ ಬಂದ್ಬಿಟ್ಟು ಫೈರ್ ಆಗಿದೆ ಅಂತ ಕೆಳಗಡೆ ಬಂದ್ಬಿಟ್ಟು ಸಫಕೇಶನ್ ಆಗಿ ಸತ್ತೋಗಿದೆ. ದೇರ್ ಇಸ್ ನೋ ಇನ್ವಾಲ್ವ್ಮೆಂಟ್ ಆಫ್ ವೆಹಿಕಲ್. ಇನ್ನು ಅಪಾರ್ಟ್ಮೆಂಟ್ ಫುಲ್ ಕಂಪ್ಲೀಷನ್ ಆಗಿಲ್ಲ, ಅಲ್ಲಿ ಪ್ರೊವಿಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
So many cases ಅಲ್ಲ, ಎಷ್ಟೊಂದ್ ಜನ ಕೇಸ್ ಆಗಿದೆ.
3 ಕೇಸ್ ಇದೆ. ಅದರಲ್ಲಿ ಮದರ್ ಇನ್ ಲಾ ಮತ್ತೆ ವೈಫ್ ಹಸ್ಬೆಂಡ್ ತೀರ್ಕೊಂತಾರೆ, ಮಗುಗೆ ಇಂಜುರೀಸ್ ಆಗಿದೆ. 1 crore ಮೇಲೆ 1 crore 56 lakhs. ಇಟ್ಸ್ ಅ ಲ್ಯಾಕ್ ಆಫ್ ಸೇಫ್ಟಿ ಮೆಜರ್ಸ್ ಮಾಡಿದಿರಾ ಪೊಸಿಷನ್ ಕೊಟ್ಟಿರೋದು ಅಪಾರ್ಟ್ಮೆಂಟ್ ಪೂರ್ವ ಪನೋರಮ ಅಪಾರ್ಟ್ಮೆಂಟ್ ನವ್ರ ನೆಗ್ಲಿಜೆನ್ಸ್.
ಈಗ ಅವ್ರೇನ್ ಹೇಳಿದ್ದಾರೆ ಪಿಟಿಷನ್ ಅಲ್ಲಿ? ಇಟ್ ವಾಸ್ ಇನ್ ಯೂಸ್, ವೆಹಿಕಲ್ ವಾಸ್ ಇನ್ ಯೂಸ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಅದೇ ಪ್ಲಗ್ಗಿಂಗ್ ಮಾಡಿದ್ರು, ಅದು ಫೈರ್ ಆಯ್ತು. ಅಲ್ಲಿ ಪೇಂಟ್ ಆರ್ಟಿಕಲ್ಸ್ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲೆಲ್ಲ ಇದೆ ಸ್ವಾಮಿ. ಅದು ವಾಷಿಂಗು ಹಾಕಿದ್ರು ಅವರು, ಓನರ್ ಆಫ್ ದ ಕಾರು ಮತ್ತೆ ಡ್ರೈವರ್. 279 ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ವಾಶ್ ಮಾಡಿದ್ದಾರೆ ರಿಟ್ಟಲ್ಲಿ. ಓನ್ಲಿ ಡ್ರೈವರ್ ವಾಶ್ ಮಾಡಿದ್ದಾರೆ, ಓನರ್ಗೆ ಕಂಟೆಸ್ಟ್ ಮಾಡಿ ಇದು ಮಾಡಿ.
Who was the owner of the vehicle?
ಓನರ್ ಆಫ್ ದ ವೆಹಿಕಲ್ ಇಸ್ ವೈಫ್ ಆಫ್ ದ ಡ್ರೈವರ್. ವೈಫ್ ಆಫ್ ದ ಡ್ರೈವರ್.
Wife of that.
ಹೌದು, ಎಂಟಿ ಹೆಸರಲ್ಲಿ ಇದೆ ಕಾರ್.
Okay.
ಅಲ್ಲಿ ಆಪರೇಟ್ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ ಇದು ವೆಹಿಕಲ್.
Delay ಇದೆಯಾ?
ಅಲ್ಲಿ ತಿನ್ನರು
Notice to
ಪೇಂಟ್
this.
ಬಾಕ್ಸಸ್ ಎಲ್ಲ ಇಟ್ಟಿದ್ರು,
Delay.
ಅದರಿಂದ
Delay ಇದೆ.
7 days.
Permission notice to transfer, service mail. Okay, next day, interest rate. You are now only substantial amount ಇದ್ರಲ್ಲಿ ಮಾತ್ರ ಅಪೀಲ್ ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ, ಎಲ್ಲದ್ರಲ್ಲೂ ಹಾಕಿದ್ದೀನಿ.
ಬೇರೇನು ಇದೆ?
ಇದೆ ಸಿಂಗಲ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಇದೆ.
ಸಿಂಗಲ್ ಬೆಂಚ್. ಮತ್ತೆ ಇದು ಕಾಮನ್ ಕ್ವಶನ್ ಆಫ್
ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್, ಐ ವಿಲ್
ಕನೆಕ್ಟ್ ಮಾಡಬಹುದಲ್ಲ?
ಮಾಡಬಹುದು. ಅದು ಗಿದೆ ಡೀಟೇಲ್ಸ್ ಆಫ್ ದಟ್ ಕೇಸ್. ಅದು ಎಫ್ಆರ್ ಅಲ್ಲಿ ಇತ್ತು, ಅದಕ್ಕೋಸ್ಕರ
ಎಫ್ಆರ್ ಅಲ್ಲಿ ಇದೆಯಾ?
ಅದಕ್ಕೋಸ್ಕರ ಬೇಡ ಅಂತ.
ಇಂಟರ್ಮ್ ಸ್ಟೇ ಆಫ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಆಫ್ ಇಂಪ್ಯೂನ್ಡ್ ಅವಾರ್ಡ್ ಎಷ್ಟು ಕಟ್ತೀರಿ ಇದ್ರಲ್ಲಿ ಈಗ?
1 crore 56 lakhs 4,000. ನನ್ನ ಮೇಲೆ ಲೈಬಿಲಿಟಿನೇ ಬರಲ್ಲ ಆಕ್ಚುಲಿ ಇದ್ರಲ್ಲಿ. ಅವರು ಕಂಟೆಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಪನೋರಮದವರು. ಅದು ಇನ್ನು ಪೂರ್ತಿ ಆಕ್ಯುಪೆನ್ಸಿನೇ ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ. 750.
What is the name of that apartment?
ಪೂರ್ಣ ಪನೋರಮ.
ಯಾವ ಏರಿಯಾ?
ಅದು
PT ರಾಜನ್ ಸಲೈ KK, ಅದು ಚೆನ್ನೈ ಅಂತ ಇದೆ.
ಎನ್ ಬ್ಲಾಕ್ ಮಿಲಾರ್ಡ್ ಇವರು ರೆಸಿಡೆನ್ಸ್ ಕೊಟ್ಟಿದ್ದು ಎನ್ ಬ್ಲಾಕ್.
ಪಿಟಿಷನರ್ಸ್ ಹೆಸರು USC ಅಂತೆಲ್ಲ ತೋರಿಸಿದ್ದಾರೆ. ಈ ಕೇಸ್ this arises out of 5326.
ಹೌದು.
5326 ಅಲ್ಲಿ ನೋಡಿ, ರೆಸಿಡೆಂಟ್ ಆಫ್ USA ಅಂತ ತೋರಿಸಿದ್ದಾರೆ ಕ್ಲೇಮೆಂಟ್ ಮುತ್ತುಸ್ವಾಮಿ. ನ್ಯಾಚುರಲ್ ಗಾರ್ಡಿಯನ್ ಅನುರಾಧ, ಲ್ಯಾಂಡ್ಮಾರ್ಕ್ ಅಪಾರ್ಟ್ಮೆಂಟ್ PT ರಾಜನ್ ಸಲೈ KK ನಗರ್ ಚೆನ್ನೈ.
ಚೆನ್ನೈನಲ್ಲಿ ಅವ್ರು ವಾಸಕ್ಕಿದ್ದಾರೆ. ಇಲ್ಲಿದ್ದು ಹೆಂಡತಿ, ಮಗು ಮತ್ತೆ ಮದರ್ ಇಲ್ಲ, ಫಾದರ್ ಇಲ್ಲ.
Subject to the deposit, subject to the appellant deposit 40%. 25% of the award amount. We have granted only till next hearing. Before the tribunal, within 4 weeks from the date of the receipt of copy of this order. List one after
94. Hearing on IA, cell number 6, HS Shankar.
Appearing for, my lord, apparent in this
See
case.
the name of the apartment.
My lord, appearing for apparent in this case.
Yes,
Apparent is, my lord, wife, my lord. The case is, my lord, case was dismissed on 9/3/2023, my lord. I have filed invoice vakalat along with the present application, your lordship.
23.
The trial court, my lord, granted decree in favor of respondent by husband, my lord. The same was challenged before this honorable court, my lord. The earlier counsel, my lord, did not,
Order.
please, my lord,
Appeal is filed in 2022. ಅಲ್ಲಿವರೆಗೂ comply ಮಾಡಿರ್ಲಿಲ್ಲ.
please, my lord, that was also, my lord, not informed to the petitioner, my lord, appellant. It is, my lord, stated in the affidavit,
We are also getting fire alert. What is this?
please.
See, Pradeep ಅವ್ರ case in ನಿನ್ನೆಲ್ಲಿ. ಏನ್ ಹೇಳಿದೀರಿ reason?
Please, my lord, the reason is, tell, my lord, earlier advocate did not, my lord, inform.
ಮಾಡ್ತಾರ್ರಿ ನೀವು ಬೇರೆ ಏನ by how can you make allegations against?
No, my lord, the very,
We
it
have
is, my lord,
this
true facts, my lord, the petition, my lord, very much appellant present, please,
judgment ಇದೆ.
please.
Otherwise you have to file an affidavit behind their back. You cannot in one Supreme Court ನಾವು ಹಿಂದೆ ಯಾವುದೇ ಕೇಸ್ ರೆಫರ್ ಮಾಡಿದ್ವಿ. You cannot make such allegations behind the back of a person like that. Who is there to whether it is true or not ಅಂತ ಹೇಳೋರು ಯಾರು? And invariably we see in several cases, sometimes parties themselves commit default. ನಾಳೆ ನಿಮ್ಮ ಮೇಲೆ ಇದೇ ರೀತಿ allegations ಮಾಡ್ಕೊಂಡು ಬರ್ತಾರೆ.
No, my lord, she is very much present before lordship, the appellant. The true facts, my lord, he did not, my lord, inform the dismissal order.
ಹಾಗಾದ್ರೆ ಅವ್ರದ್ದೊಂದು affidavit ಹಾಕ್ಸಿ ನೋಡೋಣ. ಕರ್ಕೊಂಡ್ ಬನ್ನಿ ಅವ್ರನ್ನ advocate ನ. We cannot accept that. Otherwise you file a better affidavit, we'll consider it.
Please,
ಹಿಂದೆ ಯಾವುದೋ ಒಂದು ಕೇಸಲ್ಲಿ ನಾವು ರೆಫರ್ ಮಾಡಿದ್ವಿ ಸಾಂಗ್ ಬ್ಯಾಕ್ ಹಂಗಿದ್ರೆ ಅವ್ರು ಏನಾದ್ರೂ ಆಕ್ಷನ್ ತಗೊಂಡಿದಾರ ಅವ್ರ ಮೇಲೆ ಅಂತ. ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ಅಪೆಲೆಂಟ್ seeks time to file better affidavit. Better affidavit in support of IA number 1 and 2. 1 of 2022. So list 24. List on
13-4, 13-3.
Please.
Cell number 7, Ravisha MG.
I am for the respondent, my lords, in this case.
The petitioner, the divorce petition is filed by the wife. The husband in written statement itself made a serious adultery allegation. But unfortunately, that's
in the 2022 petition 2020 ನಮ್ಮ ಹತ್ರ ಇನ್ನು 2014-15 ಅಂತ ಮ್ಯಾಟ್ರಿಮೋನಿಯಲ್ ಕೇಸಸ್ ನಡೀತಾ ಇದಾವೆ.
some hurdles are still going, turning.
What is going on?
Some harassment and hurdles is.
ನೀವು ಪೊಲೀಸ್ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ ತಾನೆ? ಈಗ you are
ಪೊಲೀಸ್ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ರೆ ಪೊಲೀಸ್ನವರು ನೀವು ಇಲ್ಲ ಅದು ಕೋರ್ಟು ನಿಮ್ಮ ಕೇಸ್ ವಜಾ ಆಗಿದೆ ನೀವು ಹೋಗಿ
injunction ತಗೊಳ್ಳಿ ಅವ್ರ ಮೇಲೆ.
like instead of that it is resolve this dispute it is
Correct. When the marriage had taken, even before the trial court, your case was of the year 2020. Urgent ಏನಿದೆ ಇದರಲ್ಲಿ? 2010 marriage. There is one daughter.
one daughter is there.
Petitioner filed police complaint in Chandrayapatna town police station. ಏನ್ ಅರ್ಜೆನ್ಸಿ ಅಂತ ನಾವು ಗ್ರೌಂಡ್ ಹೇಳಿ ಏನ್ ಅರ್ಜೆನ್ಸಿ ಅಂತ?
ಮಗು ಇದೆ ಬಂದು frequent ಆಗಿ ಬಂದು harassment ಮಾಡಿದ್ರೆ it's a serious impact to the child.
If that is the
That
case,
is a false allegation has been made, my lord. It's a false allegation has been made. No documents are substantiated. So,
Their allegation itself is an adultery against his wife. But
you have
opposite,
accusations of adultery ಅಂತ ಹೇಳ್ತಾರಲ್ಲ.
ಅದ್ರಲ್ಲಿ ನೋಡಿ ಅವ್ರ admission ಇದೆ ಅವ್ರದ್ದು ನೋಡ್ಬೋದು. She is red-handedly caught, took to the police station. The admission is there.
in their written statement from parent number 8 to 10.
Whether you have filed any application for custody of the child. If you say
Hello?
your wife is living in adultery, have you taken any care of your child?
My lords, in the presence of the mother of the petitioner, she caught red-handedly. That evidence is there. I don't want to read in the
Correct.
open court.
What is
Yes, my lord. It may be posted for
No.
any hearing anytime, my lords.
Why you say she is living adulterous life? You admit that child is
No.
your child.
My lords, not a adulterous life, my lords. She caught red-handed with a person.
ಮತ್ ನೀವ್ ಮೊದಲು ಹೇಳಿದ್ರೆ adultery allegation.
Alla, that's a, she caught red, internal page 9 of the trial court judgment.
Bhagat, our question was, you admit that child is your child. You admit.
That, my lords, may not be my lords, because this is a second marriage.
ಅಲ್ಲ ಅವ್ರು ಏನ್ ಹೇಳ್ತಾ ಇದಾರೆ ಅಂದ್ರೆ, what he is saying is, in the guise of meeting the child, you are coming and you are harassing her.
My lords, I am also not sure whether this child belongs to me. It's a second marriage, my lords.
For both of you.
Yes, my lords.
No.
Yes, my lords. For my client, this is a second marriage. First wife died in the execution.
Wife is a first marriage.
For him, it was a second marriage.
Yes, my lord.
Then.
I'm not knowing you. I'm not sure
the
whether
first
this
wife
child
died.
belongs to. Just I will check out, my lord.
ಅಲ್ಲಿವರೆಗೂ
Because this was once dismissed for default, I returned the file.
We'll do one thing. ಅಲ್ಲಿವರೆಗೂ
ma'am.
ನೀವು ಹೋಗ್ಬಾರ್ದು ಅಂತ ಹೇಳ್ತೀವಿ ಅಷ್ಟೇ. You should not.
We are not going,
but
my lords. I only filed a petition for divorce. Why I will go there, my lords?
You
I
have
only
not
filed a
filed.
petition for divorce.
Because she filed it and her petition is dismissed.
No, my lord. This is my petition. Allowed.
No? ಹಾಗಾದ್ರೆ ನೀವು ಬೇರೆ ಯಾವ್ದೋ ಫೈಲ್ ಇಟ್ಕೊಂಡು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇದೀರಾ ಇರ್ಬೇಕು.
Yes, my lord. Yes, my lord. Yes, my lord. No, sir.
ಬೇರೆ ಫೈಲ್ ಇಟ್ಕೊಂಡು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ
No,
ಇದೀರಾ?
because I have not served with a copy. It was dismissed for default. I have returned the file. Only I have given the IA, my lords. A date may be fixed, my lords.
Leonard Cons. Orders and I ಎಷ್ಟಿದು? 2024.
Still number 7.
This matter is of the year 2022. Several other matters of 2014-15, family court matters of 2014-15 are pending for final hearing. Learned counsel for the appellant submits that the respondent made the allegations of adultery against the appellant. And now in the guise of meeting the child, he comes home and harassing her. ಅವರು ಅಲಿಗೇಷನ್ ಮಾಡಿದ್ದಾರೆ, he is alcoholic etc. ಅಂತ. Only on that ground this matter cannot be given preference. Leaving the other matters, Shri Venkatesh Bhagat, learned counsel, submits that ನೀವು ಹೋಗೋದಿಲ್ಲ ಅಂತ ರೆಕಾರ್ಡ್ ಮಾಡನ್ವಾ, ನೀವು ಅವ್ರ ಮನೆಗೆ ಹೋಗ್ತಾ
ಮಾಡಿ
ಇಲ್ಲ
ಸರ್,
ಅಂತ?
ಮಾಡಿ, ತೊಂದರೆ ಇಲ್ಲ.
The respondent is not visiting the house of the appellant. The said undertaking submission. Submission ಬೇಡ, undertaking ಅಂತ ಬರ್ಕೊಳ್ತೀವಿ.
ಅಲ್ಲ, ನಾನು ಅಂಡರ್ಟೇಕಿಂಗ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರುದಿಲ್ಲ. ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬೋದು. ನಾನು ಪಾರ್ಟಿ ಇರ್ಬೇಕಾದ್ರೆ ಅಂಡರ್ಟೇಕಿಂಗ್
ಹಾಗಾದ್ರೆ ನಾವು
ಹಾಕ್ತೀನಿ,
ಆರ್ಡರೇ ಮಾಡ್ತೀವಿ.
ಹಾಕ್ಬೋದು. ಯಾಕಂದ್ರೆ ನಾನು ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಟ್ರೆ ನನ್ ತಪ್ಪಾಗ್ತದೆ ಕಡೆಗೆ, ನಾನ್ ಕೊಟ್ರೆ. ಹೌದು ಹೌದು
You are right.
ಹೌದು.
Under the aforesaid circumstances.
ಅಲ್ಲ, ಪಾರ್ಟಿಗೆ ಹಾಜರಿಟ್ಬಿಡ್ತೀನಿ ಸ್ವಾಮಿ, ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ. ಒಂದು ಪಾರ್ಟಿ
ಡೇಟ್ ವರೆಗೂ ಮಾಡ್ತೀವಿ, ಆಮೇಲೆ
ಆಗ್ಬೋದು.
ಕರ್ಕೊಂಡು ಬನ್ನಿ ಅವ್ರನ್ನ.
ಆಗ್ಬೋದು ಆಗ್ಬೋದು.
Directed not to visit the house of the appellant till next hearing date. In any guise, till next hearing date. List after 2 weeks. IA 1 of 2024 is disposed of accordingly.
Date may be.
2 ವಾರ ಬಿಟ್ಟು ಒಂದು ಡೇಟ್ ಕೊಡಿ.
21.
Both shall be present before the court.
21 ಬೇಡ ಸ್ವಾಮಿ, ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಕೊಡಿ ಅಥವಾ 26 ನಂತರ ಕೊಡಿ ಸರ್.
Both parties shall be present before the court in the next hearing date. List on
27-3.
ಆಗ್ಬೋದು ಸರ್, ಮಚ್ ಅಪ್ಲೈಸ್.
IA 1 of 2024 is disposed of. Next.
Cell number 8, K. Vani, B. Pradeep for R2.
Waiting for the second respondent.
Waiting TCR.
117 days delay, I have no objection. Maybe condone.
Days are delay because due to the accident, he met with an accident and he is bedridden, spinal appellant. Hence delay.
117 is
Maybe condone.
Delay.
It's a case of injury, no?
Injury case. Even the additional document.
Accepting the submission, accepting the grounds assigned for condonation of delay of 117 days in filing the appeal is condoned in the interest of justice. IA number 1 of 2022 is disposed of accordingly. Records ಬಂದಿದೆ. ಈಗ partly ಅದು ರಿಲೀಸ್ ಆಗಿದೆ ಅಲ್ಲ, ಈಗ ಮೊದಲಾಗಿರೋದಿಲ್ಲ. Whatever is awarded, it is released to you.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅವಾರ್ಡ್ ಸ್ಯಾಟಿಸ್ಫೈ ಆಗಿದೆಯಾ ಅಂತ?
They are not satisfied, my lord, because there they have considered 78% in 50%.
No, whatever is awarded, they have deposited, no?
He has not collected.
Collect ಮಾಡ್ಕೊ ಅಂತ ಹೇಳ್ರಿ. Post for final hearing after 2 weeks.
And also another application is there for additional document.
Be considered along with the main matter. Has served the copy on him.
ಇಲ್ಲ.
22 shall be.
Copies ಕೊಟ್ಟಿದ್ದೀರಾ ಕೇಳ್ತೀರಾ?
Noti.
ಆಯ್ತು, ತೊಂದ್ರೆ ಇಲ್ಲ, ಕೊಡಿ.
Admit.
ಅದು further treatment to documents ಅಷ್ಟೇ.
22 shall be.
And why it was not produced before the trial court, in the sense it is after the,
After 2
after
weeks.
passing of the judgment.
Copy ಕೊಟ್ಟಿದ್ದೀರಲ್ವಾ?
Yes.
Objection ಏನಾರ ಇದ್ರೆ ಹಾಕ್ತಾರೆ.
Yes.
Cell number 9, Kashinath JD.
There is a delay in filing of appeal, my lords. Initially, there was a ex parte order against the appellant, my lords. After that, my lords, he had filed the recall application and
Serial number 9, 8162.
please, my lords.
You are in
I am up here for the appeal.
ex parte order. Oh,
Initially,
owner,
my lords.
owners.
Owner. He sold the vehicle to the respondent number 2, my lords. Liability
passed.
fixed on the appellant, my lords.
Final. Why did you remain ex parte?
Yeah, address for service was not mentioned correctly, my lords. That's what it's. After that, my lords, I have filed the
So whether-
miscellaneous application for recalling the order of the tribunal, my lords. After that, my lords, order was recalled and subsequent order was passed, my lords.
Fine.
In that, my lords,
Now the present order is no more ex parte order.
no more
After
expert.
hearing you, it is granted.
Please, my lords.
Why it was, why insurer was exonerated? ಏನಾದ್ರು ಅವ್ರು
the-
execution file ಮಾಡಿದಾರಾ?
No, my lords, no.
Then we'll
execution.
issue emergent notice. Issue emergent notice to, issue emergent notice of IAS and appeal to the respondents. Based on insurer ಯಾರಿದ್ದಾರೆ ಬೇಕಂದ್ರೆ ಅವ್ರಿಗೊಬ್ಬರಿಗೆ ಇಲ್ಲ.
Shriram General
Shriram.
Insurance.
General manager ಶ್ರೀರಾಮ ಜನರಲ್.
Srirama General.
BC ಶಿವಣ್ಣೇಗೌಡ, ಪ್ರದೀಪ್.
ಒಬ್ಬರಿಗೆ ನೋಟಿಸ್ ತಗೊಳಕ್ ಬೇಕು ಗೊತ್ತಾ? ಶಿವಣ್ಣೇಗೌಡ, ಪ್ರದೀಪ್ ಮತ್ತೆ
ಓ ಮಹೇಶ್, ಎನ್ ಕೃಷ್ಣಸ್ವಾಮಿ, ನಾಲ್ಕು.
ಯಾರಿದ್ದಾರೆ? ಈಗ ಯಾರು ಇಲ್ಲ ಇಲ್ಲಿ? ಶ್ರೀ ವಿ.
ಪ್ರದೀಪ್ ಇದ್ದಾರೆ.
ಇದ್ದಾರೆ. Shri V. Pradeep, Learned Standing Council, correspond number 5 is requested to accept notice corresponding. ಉಳಿದಿದ್ದೆಲ್ಲ ಹಾಕೊಳ್ಳಿ.
ಶ್ರೀರಾಮ್ ಜನರಲ್.
Issue emergent notice to response 1 to 4. List on 22-4.
22,
Topic ಕೊಡಿ ಅವ್ರಿಗೆ.
please, 22-3. Cell number 10, Gopal KB, Richi Ashok.
Concerning the delay in filing the MFA, please.
Have you any objection for that? You have any objection for condonation of delay?
No, if it has got merits, I have no objection for it to be allowed, my lord. It's, I leave it to the court to do that.
ಏನ್ ಹೇಳಿದ್ರು? It was a contested case. Dismiss.
Dismissed. Wife petition.
ಏನ್ ರೀಸನ್ ಹೇಳಿದ್ರು ಕಂಡೋನೇಷನ್ಗೆ? What is the cause for the delay? Suffering from old. My parents are suffering from old age ailments. Accepting the reasons assigned to explain the delay. Delay of 37 days in filing the appeal is condoned in the interest of justice. IA 1 of 2023 is discussed of accordingly. In admit and call for the records. Admit records, call for ಮಾಡೋಣ.
Call for records.
Admit, call for TCR. List after the receipt of TCR.
Cell number 11,
ಇವ್ರಿಗೆ urgent.
Kashinath JD.
Appeal for the appellant, my lords. So GNWC proceedings, my lords. I'm the father of the child, my lords. There is a delay, my lords. After GNWC order, my lords, I have filed the review petition, my lords.
ಇದು ರಿಜೆಕ್ಟ್ ಆಗಿದೆ ಅಂತ ಬರ್ದಿದ್ದೀರಲ್ಲ.
Sorry.
That is also rejected. Review petition is also rejected.
That is also rejected, madam.
We'll issue notice.
Please.
Issue notice. Issue notice of away. 2/24 to the respondent. List on
5-4. Still number 12, SV Hegde Mulkan, Syed Abdul Sabur.
I am for respondent 1 and 2, my lord. So file IA for withdrawal of the amount.
is in negative.
Can be submitted.
Release one. Orders and any one of 24. Awaiting service of notice of R3 and
Owner of the vehicle.
ಯಾಕೆ liability dispute ಅಲ್ಲಿ ಇದೆಯಾ? Liability dispute.
Yes.
ಮತ್ತೆ release
Liability and the sense my lord ಅದು ಮುಂದೆ ಅವನ is pending at.
ಅಂದ್ರೆ pay and recover ಆಗ್ಬೇಕು ಅಂತನಾ? ಈಗ directly it's fastened to you. ಏನಿಲ್ಲ ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್.
Regarding driving license.
ನಾನು ಕನ್ಸಿಡರ್ appellant concedes for release of the amount in deposit. Therefore, ಇಲ್ಲಿ ಆಗಿದೆ ಟ್ರಿಬ್ಯುನಲ್ ಅಲ್ಲಿ ಆಗಿದೆ.
Pardon madam.
Deposit
For
is
the tribunal already ordered madam. 50% already ordered.
tribunal shall release the amount in deposit to the claimants in terms of its award. ಅಂದ್ರೆ ಅದರಲ್ಲಿ ಮೈನರ್ಸ್ ಇರ್ಬೇಕಲ್ಲ. ಮೈನರ್ ಇದೆ ಮಕ್ಕಳು ಮೈನರ್ in terms of award. In terms of award.
21 years madam.
16,42,000 has been awarded.
Deposit to the claimants digitally in terms of its award regarding the ratio and investment. I1 of 2024 is disposed of accordingly. List after the ಯಾವತ್ತಿದು ಇನ್ನು ಯಾವಾಗ ಹೋಗಿತ್ತು ನೋಟಿಸ್? ನೋಟಿಸ್ ವಾಸ್
13th ಒಂದಲ್ಲಿ ಹೋಗಿದೆ.
ತುಂಬಾ ದಿವಸ ಆಗಿದೆ ನೋಟಿಸ್ ಆಗಿ. ಲಿಸ್ಟ್ ಆಫ್ಟರ್ 2 weeks. 2 weeks ಆದ್ಮೇಲೆ.
Number 13, Srinivasaya MY.
13, my lord, is in, I am appear for the appellant. The case of injury, my lord, the amputation of below knee, my lord, there is a delay. And my lord, the the tribunal, my lord, they are already satisfied. The respondent number 2 is my lord, HDFC, my lord, the B Pradeep is kindly take notice and refer to local law, my lord.
Mr. Pradeep, HDFC ergo. ಅವರು ಲೋಕದಲ್ಲಿ ರೆಫರ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಕೇಸ್ ಆಫ್ ಇಂಜುರಿ.
Yes, my lord, amputation of below knee, my lord.
ಮಾಡ್ಕೊಳ್ತೀರಾ?
And also, my lord, one more connected also, my lord, in his other, my lord, his mother, my lord, kindly connected, my lord, that also, my lord, refer to local law.
ಈಗ ಮೊದಲು ಇದನ್ನ ಮಾಡನ್ವಾ ಏನ್ ಎರಡು ಕನೆಕ್ಟ್ ಆದ್ಮೇಲೆ ಮಾಡನ್ವಾ?
ಅದನ್ನು ಕನೆಕ್ಟ್ ಮಾಡಿ ಒಂದೇ ಸಲ ಅದನ್ನ ಕಳಿಸ್ಬಿಟ್ರೆ ಎರಡು ಮಾಡ್ಕೊಂತೀವಿ.
It is submitted that this matter is connected to MFA number. Number ಹೇಳಿ ಅದು ಯಾವ್ದು MFA ಅಂತ?
7881 of 23.
7881 of 2023. Connected to sir. Please both the matters together. Shri P. Pradeep, learner standing counsel for respondent number 2 is requested to accept notice for respondent number 2. ಉಳಿದದೆಲ್ಲ ಹಾಕೊಳ್ಳಿ. As requested, matters are referred to ಲೋಕದಲ್ಲಿ.
Please, madam. 63 days delay is there, ma'am.
ಅಲ್ಲ ಅದು ಇನ್ನೊಬ್ರಿಗೆ ಸರ್ವಿಸ್ ಆಗಿಲ್ಲಲ್ಲ, ಡಿಲೇ ಕಂಡೋನ್ ಮಾಡೋದಕ್ಕೆ ಇವರೊಬ್ಬರೇ ನೋಟಿಸ್ ತಗೊಂಡಿದ್ದಾರೆ. ನೀವು ನೋಟಿಸ್ ಡಿಸ್ಪೆನ್ಸೇಷನ್ಗೂ ಹಾಕೊಂಡಿಲ್ಲ ಮತ್ತೆ ಇನ್ನೊಬ್ಬರಿಗೆ.
I will file, my lord, in the office, my lord. Kindly dispense with me. I will file in the office, ma'am.
ಎಕ್ಸ್ಪರ್ಟ್ ಇಲ್ಲ ಅರ್ಧ
Expert, ma'am. Expert.
ಸೊ ಅಂಡ್ ಸೊ accepts notice ಆಯ್ತಲ್ಲ, ಅದಾದ್ಮೇಲೆ ನಾವು ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ಅಪ್ಲೈಂಟ್ ಸಬ್ಮಿಟ್ಸ್ ಮೆಮೋ ಫಾರ್ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಆಫ್ ನೋಟಿಸ್ ಟು ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 1. The records show that respondent number 1 had not contested the matter before the tribunal. Under the impugned award, the liability is fastened to the insurer. Therefore, notice to respondent number 1 is dispensed with as paid for. As requested, the matters are referred to local.
Achha,
Delay ಅಂತ ಹೇಳಿಲ್ಲ. ಡಿಲೇ ಕಂಡೋನೇಷನ್
63 days.
ಯಾವಾಗ ಬಂದು ಕೊಡ್ತೀರಿ ನೀವು ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಲಾಕ್ಡ್ ಔಟ್?
My lord, I will file Monday, my lord.
ನೀವು ಫೈಲ್ ಮಾಡ್ಬೇಕಲ್ಲ ಲೋಕ ಅದಾಲತ್ಗೆ ಹೋಗ್ಬೇಕು ಅಂದ್ರೆ.
ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ, ನಾನು ಮಂಡೇ ಕೊಟ್ಬಿಡ್ತೀನಿ.
ಹಂಗಂದ್ರೆ ನಮ್ಮ ಆರ್ಡರ್ ಮಂಡೇನೆ ಹೋಗುತ್ತೆ ಬಿಡಿ.
ಪೋಸ್ಟ್ ಅಲ್ಲಂಗಿತ್ತು ಅಂತ ಮಂಡೆಗೆ ಹಾಕೊಳ್ಳಿ ಸ್ವಾಮಿ, ಅವತ್ತು ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಹೋಗ್ತೀನಿ.
ಎಷ್ಟು ಸರಿ ಕೆಲಸ ಮಾಡಿಸ್ತಾರೆ ನಮ್ಮ ಹತ್ರ.
ಅಲ್ಲ, ಯಾಕಂದ್ರೆ ಅದ್ರಲ್ಲಿ ಏನಿದೆ ಅಂತ ನೋಡ್ಬೇಕಾಗುತ್ತೆ. ಸುಮ್ನೆ
ಲೋಕದಾಲತ್ಗೆ ರೆಫರ್ ಆದ್ರೆ ಅವ್ರೇನ್ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಕೇಳೋದಿಲ್ಲ.
ಲಿಸ್ಟ್ ಇಟ್ ಆನ್ ಮಂಡೇ. both the matters. List both the matters together.
ಅದ್ರಲ್ಲಿ ಮತ್ತೆ ಡಿಸ್ಪೆನ್ಸೇಷನ್
ಹಾಕಿರಿ ಮತ್ತೆ ಅವತ್ತೊಂದು ದಿವಸ ಹೇಳಬೇಕು. ಏನು ಕಂಡೌನ್ ಮಾಡಿ, if that is the case we can condone delay.
ಅಲ್ಲ, ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲಿ ಅದು ಮತ್ತೆ ಆರ್ಡರ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ ಕ್ಲಬ್ ಆಗಿ ಎರಡು ಒಟ್ಟೋಗ್ಬಿಟ್ರೆ ಅದು ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಡಿಲೇ ಅದೆಲ್ಲ ಇರುತ್ತೆ.
ಅದಕ್ಕೆ
4-3. Seal number 14, Syed Abdul Sabur.
high speed so as to endanger. Yes.
My lord, is the case of death, my lord. Petitioner sons expired.
59-20.
I am filing dispensation for R1.
Sabur or ಯಾವಾಗಲೂ ಹೇಗೆ he comes every
United India is the insurance.
ಯಾರಿದ್ದಾರೆ ಯುನೈಟೆಡ್ ಇಂಡಿಯಾ ಲೇಡೀಸ್ ಇದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ.
Ladies Geeta Raj, Manjula Pedestrian,
ಗೊತ್ತಾಗಿದ್ದಾರೆ.
N. Shrikant Rao, Jwala Kumar, Navishwini, PCC Sharam Rao.
ಶ್ರೀ ಯಾರಿಗೆ ಕೂಡ ನೋಡೋಷ್ಟರಲ್ಲಿ ಯಾರು ಮಂಜುಳಾ ತಿಳಿಸಿ ರಿಕ್ವೆಸ್ಟೆಡ್ ಟು ಅಕ್ಸೆಪ್ಟ್. ಇಲ್ಲೇ ಇದಾರಲ್ಲ ಅಕ್ಸೆಪ್ಟ್ ನೋಟಿಸ್ ಫಾರ್ ರೆಸ್ಪಾಂಡ್ ಉಳಿದಿದ್ದೆಲ್ಲ ಬರ್ಕೊಳ್ಳೋದ್ರಲ್ಲಿ. ನಾನು ಕೌನ್ಸಿಲ್ ಫಾರ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಸಬ್ಮಿಟ್ಸ್ ಮೆಮೋ ಫಾರ್ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಆಫ್ ನೋಟಿಸ್ ಟು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1. ಓನರ್ ಆಫ್ ದ ವೆಹಿಕಲ್ ಅಂತಷ್ಟೇ ಬರೆದಿದ್ದಾರೆ. ಜಡ್ಜ್ಮೆಂಟ್ ಎಕ್ಸ್ಪರ್ಟ್. The records show that respondent overall did not contest the matter before the tribunal. So, under the impugned award, the liability is passed to respondent over to the insurer. Therefore, notice to respondent overall is dispensed with as paid for. Then ಲೋಕದಲ್ಲಿ ಹೋಗ್ಬೇಕಾ? ಇಲ್ಲ ಲೋಕದಲ್ಲಿ ಹೇಳಿದ್ರಾ? Wanted to be referred to ಲೋಕದಲ್ಲಿ.
My lord, TCR may be needed because the enhancement of
In
salary,
case of injury, na?
death, my lord. He is working in MESCOM.
ಒಬ್ಬರೇ ಕ್ಲೈಮೆಂಟ್ ಇದ್ದಾರೆ.
1 crore 32 lakhs.
Reported to be dead. ಕೇಸ್ ಪೆಂಡಿಂಗ್ ಇರಬೇಕಾದ್ರೆ ತೀರ್ಕೊಂಡಿದ್ದಾರೆ.
Illa, father expired, reported to death on while
Before-
petition is there.
Okay.
Son during accident.
Correct. The parents, both parents had filed the petition.
Yes, ma'am.
ಅವರು ಒಬ್ರು ತೀರೋಗಿದ್ದಾರೆ.
Approved.
ಡಿಲೇ ಕಂಡೋನೇಷನ್
68 days.
Maybe condoned, you know.
She is a widow. ಒಬ್ಬರೇ ಇದ್ದಾರೆ ಪಾಪ. Heard accepting the reasons assigned to explain the delay, delay of 68 days in filing the appeal is condoned in the interest of justice. I number 1/2023 is disposed of accordingly. So admit call for TCS.
ಸ್ವಾಮಿ ಸೀರಿಯಲ್ ನಂಬರ್ 13 ಅಲ್ಲಿ ಕನೆಕ್ಟೆಡ್ ಮಾಡಿರೋ ಇದು ಸಿಂಗಲ್ ಬೆಂಚ್ ಮುಂದೆ ಪೆಂಡಿಂಗ್ ಇದೆ ಸ್ವಾಮಿ. ಅದು ಕನೆಕ್ಟ್ ಮಾಡ್ತಾನಲ್ಲ, ಅದು ಸಿಂಗಲ್ ಬೆಂಚ್ ಇಂದ ಅದು 15 lakhs ಗಿಂತ ಕಡಿಮೆ ಇದೆ ಸ್ವಾಮಿ. ಅದು ಎಲ್ಲಿ
ಕೇಸು ಮುಗಿದೋಗಿದೆ. Will not hear you now. Yes.
Seal number 15,
Copy of the appeal memo may be directed. Other side may kindly be directed to serve the copy of the appeal.
It is implied.
seal number 15, Raghu
He
R.
appears regularly. ಈ ತರ astral voices ಅಲ್ಲ.
Appellant for appellant, madam. There is a bill of 305, notice of insurance company. KSRTC also filed an appeal, madam. MF 43/23 ಅಂತ.
57.
Discolapta number.
Claimant's appeal.
Claimant appeal.
It is submitted that this matter is connected to MFA number.
43/23, madam.
List both the matters together. ಮುಂದಿನ ವಾರನಾ?
ಅದು BL ಸಂಜೀವ್ ಅಂತ ಅವ್ರಿಗೆ ಬೇರೆ.
ಅವರಕ್ಕೆ ಅಲ್ಲ ಬರ್ಲಿ ಪುಟ್ಟ ಎರಡು ಒಟ್ಟಿಗೆ ಲಿಸ್ಟ್ ಆಗ್ಲೇ ಇಲ್ಲ.
ಆಯ್ತು.
ಅವಾಗ ನೋಟಿಸ್ ಕೊಡೋಕೆ ಹೇಳ್ತೀನಿ. In the next week. Yes.
Seal number 16, B Pradeep.
For appellant in this case, my lord, challenging the liability on the ground that, my lord, the deceased was proceeding in a goods vehicle as an unauthorized passenger. The PW1, the cross examination admitted that his friends and deceased was proceeding in a goods vehicle as a passenger.
45 lakhs 12,000.
45 lakhs 12,700.
Issue emergency notice for correspondence. Interim stay of Interim stay of execution of the improved award till next hearing date, subject to the appellant depositing 50% of the award amount before the tribunal within 4 weeks from the date of the receipt of the copy of this order. List on
19-4. Seal number 17, Sharad Gowda GB.
Appearing for the opponent. Case of injury or lordship. 334 days delay this one.
ಯಾರು insurer ಯಾರು? United India, ಇಲ್ಲ ಇದ್ರಲ್ಲ ಅವರು ಬ್ರಾಂಚ್ ಮ್ಯಾನೇಜರ್ ಯುನೈಟೆಡ್ ಇಂಡಿಯಾ ಇನ್ಶೂರೆನ್ಸ್. ಎಸ್ ಯಾರಿಗೆ ಕೊಡೋಣ? ಹೆಗ್ಡೆ ಅವ್ರಿಗ ಮೇಡಮ್ಗ ಯಾರಿದ್ರು ಮತ್ತೆ ಯುನೈಟೆಡ್ ಇಂಡಿಯಾದವ್ರು ಯಾರು?
SV ಹೆಗ್ಡೆ ಮಾಡ್ಕೊಂಡು.
ಇಲ್ಲ ಅವ್ರಿಬ್ರು ಇರೋರು ಪೆನಲ್ ಮೇಲೆ ಇದ್ದವ್ರು ಇಬ್ಬರೇ ಇದಾರೆ. ಗೀತಾ ರಾಜು ಕೊಡೋಣ. ಈಗ ಇದಾರೆ ಇರ್ಲಿ ಅವ್ರು ಸಾಕಷ್ಟು ಇದಾರೆ ಪಾಪ ಹೆಣ್ಮಕ್ಳು ಇರೋದು. ಶ್ರೀಮತಿ ಗೀತಾ ರಾಜ್ ಮೆಡಲ್ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ರೆಸ್ಪಾಂಡ್ ಇಸ್ ರಿಕ್ವೆಸ್ಟ್. ಮಾರ್ಚ್ ತಿಂಗಳಿದ್ದೀವಿ. We are saying in the month of March, women's empowerment ಆಗ್ಬೇಕು. ಶ್ರೀಮತಿ ಗೀತಾ ರಾಜ್ ಮೆಡಲ್ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ರೆಸ್ಪಾಂಡ್ is requested to accept notice for respond to ಉಳಿದೆಲ್ಲ ಹಾಕ್ತೇವೆ. What about respond number 1?
ಅವರು contesting.
These are the copies on who? Respond number 1 here contested or not contested?
Contested.
ಲಾರಿ ಓನರ್ ರವಿ ಕುಮಾರ್ ಯಾರು ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ.
ಲಯಬಿಲಿಟಿ ಇಬ್ರು ಮೇಲೂ ಇದೆ ಸ್ವಾಮಿ.
ಅಲ್ಲಿ ನೀವೇನ ನೋಟಿಸ್ ಕೊಡ್ಬೇಕಾ ನಾವೇನ್ ಮಾಡ್ಬೇಕೀಗ?
ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗ್ಲಿ ಸ್ವಾಮಿ ಅವರಿಗೆ.
ಆಗ್ಲಿನಾ ಆಯ್ತು. ಬಟ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 ಶಾಲ್ ಇಂಡೆಮ್ನಿಫೈ ಅಂತ ಆಗಿದೆ. ಇಶ್ಯೂ ನೋಟಿಸ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1. List on
54. Seal number 18, B Pradeep.
For the appellant. This case challenging negligence and quantum. This was riding a motorcycle, Ooty, Ulpet main road. To Karmalad, he is also contributed some extent, not for home.
you have examined
8 lakhs, ಇಲ್ಲ examine ಮಾಡಿಲ್ಲ.
ಕಡೆ ಯಾರು
ಏನ್ ಮಾಡಿಲ್ಲ ಅವ್ರ police documents ಅಲ್ಲೇ sketch ಇದು ಪಂಚನಾಮ ಆಗಿರೋದು.
delay ಇದೆಯಾ? 15 days issue notice to the respondents. Interest on the execution of the improved award till next hearing date, subject to the appellant depositing 50% of the award amount before the tribunal within 4 weeks from the date of the receipt of the copy of this order. List on
19-4. Seal number 19, Kenchegowda BM.
Appear to appellate in this case, my lord. Case of death, my lord. Claimant appeal, my lord. 80 days delay.
you are only on quantum.
Quantum, my lord.
Quantum. HDFC
HDFC ಇರ್ಬೋದು.
ಪ್ರದೀಪನೇ ಇದೆ ಮತ್ತೆ ಮತ್ತೆ ಯಾರಿದ್ದಾರೆ?
ಲಿಂಗರಾಜ್, ಡಿ ವಿಜಯ್ ಕುಮಾರ್, ಉಮೇಶ್, ಪ್ರದೀಪ್, ಎನ್ ಕೃಷ್ಣಸ್ವಾಮಿ ಇಷ್ಟೇ ಜನ.
ಲಿಂಗರಾಜ್ ಅವ್ರಿಗೆ ಹೇಳಿ ಹಾಗಾದ್ರೆ ಅವ್ರು ಕೊಡೋದು. ಪ್ರದೀಪಿಗೆ ಕೊಟ್ಟಿದ್ದೀವಿ. ಶ್ರೀ HS ಲಿಂಗರಾಜ್ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 is requested to accept notice for respond number 2. ಉಳಿದಿದ್ದೆಲ್ಲ ಹಾಕ್ತೀವಿ. What about respond number 1 was
One is expert in the output, madam.
ಏನ್ ಮಾಡ್ತೀರಿ ಮತ್ತೆ?
Memo ಹಾಕ್ತೀನಿ.
ನಮ್ಮ ರಿಜಿಸ್ಟ್ರಾರ್ ಒಂದು ನೋಟಿಸ್ ಕೊಡ್ಬೇಕಾ?
ನೋಟಿಸ್ ಕೊಡಿ ಸರ್.
ಹಾ?
ನೋಟಿಸ್.
ಅಲ್ಲ ರೀ ಅವ್ರಿಗೆ ಲಯಬಿಲಿಟಿ ಅವ್ರಿಗೆ ಹಾಕಿ ಅವ್ರಿಗೆ ಚಾಲೆಂಜ್ ಮಾಡಿರ್ಲಿಲ್ಲ
I will file
ನೋಟಿಸ್
the
ಹಾಕಿ
memo.
ಹೋಗ್ಬೇಕು.
Memo ಹಾಕ್ತೀನಿ.
ಇಲ್ಲೇ ನಮ್ದೊಂದು ಪೇಪರ್ ಇಸ್ಕೊಂಡು ಬರೀರಿ 2 ಪೇಪರ್.
ಬರ್ರಿ.
ನನ್ನ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ಅಪೆಲೆಂಟ್ ಸಬ್ಮಿಟ್ಸ್ ಮೆಮೊ ಫಾರ್ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಆಫ್
ಸೊ ಇದರಲ್ಲಿ IT ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ. ಕಾಲ್ಫಾರ್ ರೆಕಾರ್ಡ್
ಮಾಡ್ತೀವಿ. 25 ಡಿಲೇ ಇದೆ ಅಲ್ಲ, ಡಿಲೇ ಕಂಡಕ್ಟ್ ಮಾಡೋದಕ್ಕೆ ಅವ್ರೊಂದ್ಸತಿ ಕೇಳ್ಬೇಕಾಗುತ್ತೆ.
80 days.
ಇಲ್ಲಿ ಇದ್ದವ್ರಿಗೆ ಯಾರಿಗಾರ ಕೊಡೋಣ ಹಂಗಿದ್ರೆ. ಅವ್ರು ಇದಾರೆ ಪ್ರದೀಪ್ ಇಟ್ಟಿದ್ದಾರೆ, ಹಂಗಂದ್ರೆ ಅವ್ರು ಪ್ರದೀಪ್ ಅಂತ ಮಾಡ್ತೀವಿ. ನೀವೇ ತಗೊಳ್ಳಿ. ಡಿಲೇಗೆ ಏನ್ ಹೇಳ್ತೀರಿ?
HS ಲಿಂಗರಾಜ್ ಅವರ ಹೆಸರಲ್ಲಿ ಸ್ವಲ್ಪ ಡಿಲೇ ಮೇಲೆ
ಡಿಲೇ ಕಂಡಕ್ಟ್ ಮಾಡ್ಬೋದು.
ಮಾಡ್ಬೋದು.
ಅಲ್ಲ ಅವ್ರು ಇರ್ಲಿಲ್ವಲ್ಲ ಅದಕ್ಕೆ
ತೊಂದರೆ ಇಲ್ಲ ಸರ್, ಇನ್ಫಾರ್ಮ್.
dispensation ಅಲ್ಲ. Then counsel for the appellant submits memo for dispensation of notice to respondent number 1. Under respondent number 1 had not contested the matter before the tribunal. Under the influent award, liability is fastened to respondent number 2, the insurer. Therefore, notice to respondent number 1 is dispensed with as per HSP. Orders and I1 of 2023 heard death case. Accepting the reasons assigned to explain the delay of 80 days in filing the appeal is condoned in the interest of justice. IA 1 of 2023 is disposed of accordingly. Admit call for TCS.
Please.
Or copy sir.
Cell number 20, Chandrasekharaya B.
Appellant, my lord. Death case, claimant appeal for enhancement. Insurance company also filed appeal. Also filed.
How's it connected number here?
4197.
City work for
Barkut.
it is submitted. This matter is connected to MF number.
Krishna Kishore appear for insurance company.
Yes.
Yes, Krishna Kishore. Yes,
Notice the
please.
Please put the matters together. After 1 minute.
Cell number 21, B. Srinivas.
Ella 1 minute.
But I appeal for appellant in this case. My lord, I challenge the decree of a restitution of conjugal rights, my lord. It's an ex parte decree where the the appellant was not served with the summons, my lord. Now, my lord, I have filed a petition seeking a divorce, decree of divorce. In the meantime, after service of summons, they have filed this restitution of conjugal rights. Now the matter has been transferred to Mysore, my lord. The petition filed by,
Petition is filed to Mysore.
earlier I filed a decree, seeking a decree of divorce in Bangalore because I am a resident of Bangalore. Now the matter is transferred to by virtue of a CP filed by the respondent, matter is transferred to Mysore. This is delay, yes, my lord, there is a delay, my lord. 51 days delay notice.
Notice the respondent. Yes,
My lord, I see, my lord, I sought for a stay of the decree, my lord. My lord,
Delay is, how can we grant stay?
22-3.
22.
much.
Cell number 22, Ravi Shankar S.
The appeal filed with the insurance company on the ground of liability. Fact,
Delay is, no?
but these are delayed.
Yes,
The
they are challenging.
he was traveling as an occupant in a tractor trailer, which was converted and said that he was walking as a pedestrian anta ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Pedestrian. 50% deposit.
Please, before the tribunal.
Notice to the respondents. Instead of execution of the impugned award till next hearing date, subject of claim depositing 50% of the award amount which was obtained within 4 weeks from the date of the receipt of the copy of this order. List on
19-4.
Apply.
Cell number 23, B. Pradeep.
For the appellant in this case. Case now the case of injury, my lord, the first respondent himself was driving the car and influence of alcohol, my lordship. It is forthcoming in the medical records.
Consumption alcohol or intoxicated?
Consumption of alcohol.
That itself is offense, alva? ಇನ್ನೊಂದು ಹೇಳಿದ್ದು ಸೇಮ್ ಮಾಡಕ್ ಬರುತ್ತಾ ಹೇಳ್ಬೇಕು. Notice and stay. Subject to deposit of 50% till next hearing date because it is delay. Stay till next hearing date.
19-4. Cell number 24, B.
Yes.
Pradeep.
Challenging liability and quantum.
ಗೊತ್ತಾಗುತ್ತೆ ತಾನೆ ಪ್ರೀವಿಯಸ್ ಕೇಸ್ ನಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ರು ಅದರಲ್ಲಿ ಇದ್ರಲ್ಲೂ ಮಾಡಿದ್ರು. ಇದರಲ್ಲಿ
Challenging quantum and negligence, liability, my lord, liability fastening against the insurer of the vehicle and directed the insurer to pay the compensation, recover the same from the owner of the vehicle. There is no permit, absolutely.
pay and recovery.
ಹೌದು.
ಇದರಲ್ಲೂ ಅಷ್ಟೇ ನೋಟಿಸ್ ಸ್ಟೇ.
19-4. Cell number 25, Ravi S. Samprati.
Here the appeal as on quantum. Blood, the deceased, the injured was working as a village accountant and he still continues to work as a village accountant in spite of the disability. In spite,
No functional disability.
no functional disability. The court has granted 31,53,000.
Accountant has to go from village to village ಅಲ್ವಾ ಅವ್ರಿಗೆ?
ಇಲ್ಲ ಇಲ್ಲ ಅಲ್ಲೇ ಕೂತ್ಕೊಂಡೆ ಕೆಲಸ
ಇಲ್ಲ ಅವ್ರಿಗೆಲ್ಲ ಸರ್ವೆ ಗಿರ್ವೆ
ಅಲ್ಲ ಆದ್ರೂ 31 ಲಕ್ಷ ರೂಪಾಯಿ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. He was getting the same salary. In fact, after the accident, the salary has been.
ಫ್ಯೂಚರ್ ಇನ್ಕಮ್.
Yes. 50% will deposit.
Same. Notice stay till next hearing date.
19-4.
Please.
Cell number 26, Ravi S. Samprati.
This is on liability money.
How much is awarded?
The amount, compensation of 32,54,000 is awarded.
32 lakhs, same, please stay. Notice and stay till next
Please.
week, subject to deposit.
Seal number, for admission, seal number 27, Akshay Kumar Jain.
27, Lord, I pray for a week's time, Lord, to file statement of objections and
Memo of appearance, you are not filed it.
ಇಲ್ಲ.
Finally,
I-
but a competent authority ಗೆ ಯಾರೋ advocate ಇರ್ತಾರಾ?
ಅಲ್ಲ ಇದರಲ್ಲಿ ಈ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್
Commissioner is the competent authority.
ಎಸ್ ಮೇಡಮ್
ಆದ್ರೆ ಆ ಪರ್ಟಿಕ್ಯುಲರ್ ಫೈನಾನ್ಷಿಯಲ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಗೆ ಒಬ್ಬರನ್ನ ಯಾರನ್ನೋ ಅಪಾಯಿಂಟ್ ಮಾಡ್ತಾರೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ರು. Advocate ಅನ್ನ, not officer.
ಪ್ಲೀಸ್ ಮೇಡಮ್
You can file memo of appearance.
ಐ ವಿಲ್ ಗೆಟ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಫ್ರಮ್ ದ ಡಿಪಾರ್ಟ್ಮೆಂಟ್.
ಮನಿ ಲಾಂಡ್ರಿಂಗ್ ಕೇಸಲ್ಲಿ ಅವರು ಒಬ್ಬರನ್ನ ಅಥಾರಿಟಿನ advocates ನ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ದಾರೆ. You just then verify.
What?
Take instruction whether you can appear.
ಪ್ಲೀಸ್ ಮೇಡಮ್ 1 week.
ನೋಡ್ಕೊಂಡು ಬಂದಿದ್ದು waste ಆಗುತ್ತೆ. As requested by learned HCP, list on ಒಂದು ವಾರ ಬಿಟ್ಟು ಅದರ next
14-3.
ಪ್ಲೀಸ್
Seal number 28, M. Sudhakar Pai, Pratima SK.
I beg to appeal for the appellant, my lord. This is husband's appeal.
In the
connected matter. The connected matter, you take notice. They also have filed an appeal.
Yes.
Notice awaited ಅಂತ ಇದೆ. ತಗೊಳ್ತೀರಾ, accept ಮಾಡ್ತೀರಾ?
If the court directs, I will let them serve me a copy, I will. But in respect of first matter, my lord, my matter, 77770,
My lord, senior is engaged in other court. It may kindly be passed over.
All. ನೀವು notice ತಗೊಳ್ಳಿ, will direct you to take notice in the connected matter.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಫಸ್ಟ್ ನನ್ನ matter ಅಲ್ಲಿ
Senior ಏನೋ ಬರ್ಬೇಕಂತೆ, ಪಾಸ್ ಅವ್ರು ಕೇಳ್ತಾ ಇದ್ದಾರೆ. Who is your senior?
SK Pratima, my lords. The connected matter, NFA 7.
Right. ಅವ್ರ ಕಾಪೀಸ್ ಕೊಡಿ connected case ಅಲ್ಲಿ.
I'll furnish.
may I make one submission, my lord?
ಮಧ್ಯಾಹ್ನ
ಅದೇ your lordship may have it on Tuesday, my lord.
ಹಾಗಾದ್ರೆ will direct.
Because there is, in my matter, there is I am pressing for stay because they have filed the execution.
She will come. ಎಷ್ಟೊತ್ತಿಗೆ? At what time she is coming?
ಅಲ್ಲ instead of passing over, my lord, your lordship may have it on Tuesday, my lord, 5th.
Okay.
Because there is some urgency for my matter, my lord. That's why I moved it yesterday.
Counsel M. Sudhakar, Lord Counsel, is directed to accept notice for the respondent in the connected matter. We shall file the wakalat in the registry. Next, ಅವರು ಇದೆ ಇಲ್ಲೇ ಇರೋರಾ?
ಅಲ್ಲ ಅದು ಅವರು ಉಡುಪಿಯಲ್ಲಿ.
The ವಕಾಲತ್ ಯಾವಾಗ ಹಾಕ್ತೀರಿ?
I get it, my lord.
We shall file the wakalat.
ಉಡುಪಿ ಉದ್ಯಾವರ್.
Correspond within 1 week. Okay. As requested, list on Tuesday.
5-3.
Grateful.
Published.
Seal number 29, Sachin BS.
Taking enhancement measures.
Enhancement.
Injury case.
Your owner,
Owner,
not insured, vehicle was not
ಇಲ್ಲ
insured.
insurance ಇಲ್ಲ.
Issue notice. What was the injury?
Injury by environment. Page number 25, Lordship.
ಕಡಿಮೆ ಆಗಿದೆ ಅಂತ.
80% ಕೊಟ್ಟಿದ್ದಾರೆ.
Disability taken is on the lower side.
ಹೌದು, ಹೌದು.
Third item, all parties here issue notice to the respondent. List on. Date, ಒಂದು 4 weeks ಇಂದ ಹಾಕೊಂಡಿರ್ತೀನಿ. Records ಬರ್ಬೇಕು.
8-4.
ಬಸ್ಸು.
Seal number 30, Shantraj K.
Liability has been fixed on the owner. On the ground, the police has not been covered under the policy. R3 is the Royal Sundaram, the Ravi Samprati may be direct take notice for R3. I will take out notice to 1 and 2.
Trial Sundaram, Sri Ravi Samprati, Learned Standing Counsel for respondent number 3, is requested to accept notice for respondent number 3. Delay ಏನಿಲ್ಲಲ್ಲ?
Delay ಇಲ್ಲ, in time ಇದೆ. ಇದು ರೆಕಾರ್ಡ್ಸ್ ಕಾಲ್ ಮಾಡ್ಬಿಡಿ 1 and 2 I will take notice, owners.
Case of death.
Death, ಓನರ್ ಮೇಲೆ ಮಾಡಿದ್ದಾರೆ.
What is the error? Owner will ಮಾಡಿದ್ದಾರೆ.
ಓನರ್ ಮೇಲೆ ಮಾಡಿ ಅವರು police is not covered ಅಂತ ಮಾಡಿದ್ದಾರೆ.
Call for TCRs. Issue notice to
Response 1 and 2.
1 and 2. 1 and 2. List on.
The
10-4.
records may be called.
ಆಯ್ತು.
Call ಮಾಡಿ. 10-4.
Huh?
10-4.
10-4.
Seal number 31, Ravi S. Samprati.
Here for the appellant, the appeal filed by the insurance company challenging quantum and negligence. My lord, the deceased was also charged for driving the vehicle without driving license. In spite of bringing it to the notice of the court, the tribunal has not considered the contributory negligence on the part of the deceased. And apart from that, he was an agriculturist,
What is madam?
50% before tribunal.
Call for TCRs. Issue notice to the respondents. Interim stay of execution of the impugned award. Subject to the appellant depositing 50% of the award amount received by tribunal. I have 1,024 is disposed of accordingly. List on.
22-4.
Apply.
Seal number 32, Sundresha H.C.
Has filed this appeal challenging the order of decree of divorce passed against. So the family court has passed a decree against the appellant. Is the wife, she is the wife. On the ground of 13(1)(a) and 1(b), cruelty and desertion. So in fact, madam, your lordship may kindly see, there is no evidence.
Now, what is the cruelty alleged?
The cruelty, the allegation is that the mental and physical harassment and suspecting the petitioner. So that is the cruelty.
Suspect.
On the other hand, my lord, on the other hand, these,
Physical cruelty ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ ರೀ ಲೇಡೀಸ್ ಅವ್ರಿಗೆ? Mental and physical cruelty ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, what are the allegations of cruelty?
allegation of cruelty has not been proved. Allegation of cruelty has not been proved.
What is the allegation of cruelty? ಅದನ್ನ
Cruelty,
ಕೇಳ್ತಾ
your lordship may kindly see the allegation.
of cruelty.
Yes. Your lordship may kindly see the order. It has been stated.
Correct, ನೀವು ಫೈಲ್ ಓದಿದಿರಿ ತಾನೆ?
ಹೌದು.
What were the allegations of cruelty against the wife?
Allegation against the cruelty against the wife is she is not cooperating with him. The following are the point number 5 ನಲ್ಲಿ 9 ನಲ್ಲಿ your lordship may kindly see point number 9.
Point number 9 ಅಂದ್ರೆ ಎಲ್ಲಿದೆ? ಯಾವ page ಅಲ್ಲಿ?
This is the allegation.
Page ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ? ಯಾವ page ಅಲ್ಲಿ?
Sorry, the reason ಅಲ್ಲಿ para number 9, para 9 reason. This is the pleading of the petitioner. Said to have a cruelty for the petitioner. 6 months from the marriage, the respondent ordered to pick up quarrel without any reason. And the respondent going out of the house without intimation, without any reason. Respondent was doubting the suspecting the petitioner, was insulting, abusing the petitioner and his parents. This is the allegations.
Admit, issue notice to the respondent. Third, admit call for TCRs. Issue notice to the respondent. Interim stay of the interim civil and execution. Interim stay of the interim judgment and order till next hearing. Said till further orders. I have 1,024 is disposed of accordingly. List on date here. Date quoted.
22-4.
22.
Please.
Seal number 33, Ravi S. Samprati.
Filed by the insurance company on the ground of quantum. Deposit 50%, madam.
Only on quantum.
Only on quantum.
ಲೋಕ ಅದಾಲತ್ನಲ್ಲಿ ಸೆಟಲ್ ಮಾಡ್ಕೋಬೇಕಿತ್ತ ಇಲ್ವಾ? ಅಲ್ಲೇ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇರ್ಬೇಕಾದ್ರೆ.
ಒಂದ್ಸಲ ಇಲ್ಲ, ಅವ್ರು ತುಂಬಾ ಎಕ್ಸೆಸಿವ್ ಡಿಮಾಂಡ್ ಇತ್ತು, ಅದಕ್ಕೆ ಮಾಡಕ್ ಆಗ್ಲಿಲ್ಲ. ದಿ ಬರೀ ಅಟೆಂಡೆನ್ಸ್ ಚಾರ್ಜಸ್ ಅಂತಾನೆ 10,80,000 ಕೊಟ್ಟಿದ್ದಾರೆ. ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ 2 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದಾರೆ. ಪೈನ್ ಅಂಡ್ ಸಫರಿಂಗ್ 3 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದಾರೆ. ಎಸ್, ಕೇಸ್ ಆಫ್ ಇಂಜುರೀಸ್ 80% ಡಿಸಬಿಲಿಟಿ ಹೇಳ್ತಾರೆ ಡಾಕ್ಟ್ರು, ಬಟ್ 100% ತಗೊಂಡಿ 50% ಡಿಪಾಸಿಟ್ ಮಾಡ್ತೀನಿ. ದೇ ಮೇ ಬಿ ಪರ್ಮಿಟೆಡ್ ಟು ವಿಡ್ರಾ ಆಲ್ಸೋ.
Call for TCRs. Injury case and vehicle. Call for TCRs. Issue notice to the respondent. Respondents. Owner do respond ಇದಾರಾ?
I'll file a memo for dispensation. Owner happy. I'll file it.
Call for TCRs ಆದ್ಮೇಲೆ ನಾನು counsel for the appellant submits memo for dispensation of notice to respond number 2. The insurer liability is not in dispute. Therefore, notice to respond number 2 is dispensed with as paid for. Issue notice to respondent number 1. Interim stay of execution of the impugned award. Subject to the appellant depositing 50% of the award amount before the tribunal. Within 4 weeks from the date of the receipt of the copy of this order. IA 1 of 2024 is disposed of accordingly. List on
22-4.
Obliged.
Cell number 34, Jayant Pujari.
Appeal by husband, my lord, he filed a petition for divorce. My lord, the respondent number 1 is the wife, my lord, after receipt of summons, my lord, she filed an objection and also, my lord, counterclaim, my lord, for restitution of conjugal right. My lord, my petition for divorce was dismissed and counterclaim, my lord, the very same petition, my lord, counterclaim was filed, that was allowed. Directed me to rejoin, my lord, the respondent number 1. My lord, allegation is of cruelty, desertion and illicit relationship, my lord, with second respondent.
Correct. There are 2 decree. Can you maintain one appeal officer?
ಅಲ್ಲ ಅವರು ಸಪರೇಟ್ ಪಿಟಿಷನ್ ಇಲ್ಲ ನಮ್ಮ ಪಿಟಿಷನ್ ಅಲ್ಲೇ ಕೌಂಟರ್ ಕ್ಲೇಮ್
Correct. ಅಲ್ಲಿ 2 decree ಇದೆ like suit to counter claim ಇದ್ದಂಗ ಆಯ್ತು. There are 2 decree. 1 decree for restitution of conjugal rights and 1 decree for dismissing one dismissal doesn't amount to anyway.
ಕಾಮನ್ ಡಿಕ್ರಿ ವಾಸ್ ಪಾಸ್ಟ್
We'll issue notice.
ಅಲ್ಲ ಕಾಮನ್ ಡಿಕ್ರಿ ವಾಸ್ ಪಾಸ್ಟ್ ಮರದ ಅದರಲ್ಲಿ ನೋಟಿಸ್ ಕೂಡ ಕೊಟ್ಟಿದ್ದಾರೆ ಈಗ
ನಾವು ಆಫೀಸರ್ ಮಾಡಿಲ್ಲ ಆದ್ರೆ we have to examine. ಆಮೇಲೆ ಅದರಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪಿಟಿಷನ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ.
ನೋಟಿಸ್ ಆಲ್ರೆಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಫೈಲ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ
ಎಕ್ಸಿಕ್ಯೂಷನ್ ಫೈಲ್
ಮಾಡಿಲ್ಲ.
ಮಾಡಿದ್ದಾರೆ. ಎಕ್ಸಿಕ್ಯೂಷನ್ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡ್ತೀವಿ ತಗೊಳ್ಳಿ.
ಟಿಲ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಮೈ ಲಾರ್ಡ್ ಅದರ್ವೈಸ್ ಮೈ ಲಾರ್ಡ್ ಟಿಲ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್
ನಿಮ್ಮ ಅಪೀಲ್ whether you can maintain one single appeal.
ಮೈ ಲಾರ್ಡ್ ಡಿಕ್ರಿ ಮೈ ಲಾರ್ಡ್ ಯು ಲಾಸ್ಟ್ ಮೈ ಕೈಂಡ್ಲಿ ಪೇಜ್ ನಂಬರ್ 33 ಮೈ
ಇದರಲ್ಲಿ ಏನ್ ಕೇಳ್ತಾರೆ?
ಐ ಆಮ್ ಫಾರ್ ಡೈವೋರ್ಸ್ ಐ ಫೈಲ್ಡ್ ಪಿಟಿಷನ್ ಫಾರ್ ಡೈವೋರ್ಸ್
Judgment is so and allow MC number 211 of 2021 and dismiss the counter claim.
ಹೌದು
ಹ್ಮ್.
ಕೌಂಟರ್ ಕ್ಲೇಮ್ ಅಂದ್ರೆ ಅವ್ರು ಸಪರೇಟ್ ಆಗಿ ಹಾಕೊಂಡಿಲ್ಲ ಅದರಲ್ಲೇ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲೇ
ಅದೆಲ್ಲ ಹಾಕಿದ್ರು ಡಿಗ್ರಿ ಬೇರೆ ಆಗುತ್ತಲ್ಲ ಅದು.
ಎಸ್
ಇಲ್ಲಾಂದ್ರೆ ಇನ್ನೊಂದ್ ದಿವಸ ಹಾಕ್ತಿವಿ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿ ಹೇಳಿ ನಮ್ಗೆ. But the records show that against 2 decrees, namely decree for restitution of conjugal rights and dismissal of the petition of the appellant for divorce. Single appeal is filed. The appellant's counsel shall clarify how the single appeal is maintainable. List on
Next week.
next one.
7-3.
Please.
Cell number 35, B. Pradeep.
Challenging the involvement of vehicle, my lord. 5 days delay in lodging complaint. My lord, initially has taken to hospital, RIK hospital, my lord, there is no MLC has been registered. You have summoned the CMO, you have stated that there is no medical legal case has been registered in their hospital.
Vehicle involved is ಏನದು?
My lord, tractor, my lord,
Driver of tractor.
tractor.
Issue notice to not admit all parties here. Issue notice to the respondents. Interim stay of execution of the impugned award. Subject to the appellant depositing 50% of the award amount before the tribunal within 4 weeks from the date of the receipt of the copy of this order. IA 1 of 2024 is disposed of accordingly. List on
22-4. For further hearing, cell number 36, O. Mahesh. SCS Sabur.
Appellant.
Yes, sir. Yes. ಅಮೌಂಟ್ ಬರ್ಬೇಕು. ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಕೌಂಟರ್ ಮಾಡಿಲ್ಲ. ಅರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ, ಇಬ್ರು ಮುಗಿದಿವಿ ಅಲ್ಲ ನೀನು.
Yes.
ಕಾಂಪನ್ಸೇಷನ್ ನಾವು ಮಾಡಿರ್ಲಿಲ್ಲ ಅಂತನಾ? ಸರಿ, ನಾನು ಅದನ್ನ ಮಾಡೋಣ. 15 multiplier 38 x. ಒಂದಷ್ಟೇ ಆಗ್ಬೇಕು, ಕಡಿಮೆ ಇದೆ ಅದನ್ನೊಂದೇ ಮಾಡ್ಬೇಕಂತ ಹೇಳಿದ್ರು. ಈ ಕೇಸಲ್ಲಿ ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅವರು ಚಾರ್ಜ್ ಶೀಟ್ ಇವ್ರ ಮೇಲೆ ಹಾಕಿದ್ದಾರೆ. ಚಾರ್ಜ್ ಶೀಟ್ ಇಸ್ ನಾಟ್ ರಿಪೋರ್ಟೆಡ್. ಹಾಗಾಗಿ ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಬೇಕಾದ್ರೆ ಪ್ರೂಫ್ ಇಲ್ಲ ಅಂತ ಬರೀಬೇಕು. ಪ್ರೂಫ್ ಇಲ್ಲ ಅಂತ ಬರೀಬೇಕು.
My lord, regarding consortium of
ಏನು
all
ಏಜ್ ವಾಸ್ ಎಷ್ಟು
40,000.
ಹಿಂದೆ ಇನ್ನು 2 ಅಲ್ಲ ಕಾನ್ಸೋರ್ಷಿಯಂ ಒಂದೇ ಹೆಚ್ಚಾಗುತ್ತೆ, ಉಳಿದೆಲ್ಲ ಸರಿ ಇದೆ ಅಂತ ಹೇಳಿದ್ರು. ಏಜ್ ಎಷ್ಟು 43 years
38 years, my lord.
38 years. ಪ್ರೂಫ್ ಏಜ್ ಪ್ರೂಫ್ ಯಾವುದು?
DL, my lord.
ಅದನ್ನ ಇನ್ನೇನೋ ಲೆಕ್ಕ
DL has been produced.
ಅಲ್ಲ ಅವ್ರು 40 years ಆಗುತ್ತೆ ಅಂದ್ರು ನಾವು ಕಂಪ್ಲೀಟೆಡ್ ಆಗುತ್ತೆ ಅಂತ.
DL produced before.
As per the DL ಇದೆಷ್ಟು?
38 years, my lord. At the time of death. My lord?
ಅದನ್ನ ಅವ್ರು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿಲ್ವಾ?
Illa, madam.
38 years. Income?
Income to actually 21,551.
Question. Police constable.
Police constable.
Particular
PF
tax
to
is-
be deducted only 200 rupees instead of 3.
Professional tax.
Professional tax, my lord.
ಟ್ಯಾಕ್ಸ್ ಡಿಡಕ್ಟ್ ಮಾಡ್ಬೇಕು 10% ಅಷ್ಟು ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್. ಯಾಕಂದ್ರೆ ಇದ್ರಲ್ಲಿ ಮಾಡಿರೋದಿಲ್ವಲ್ಲ
20.
ಅವ್ರದ್ದು ರೆಕಾರ್ಡ್ಸ್ ಎಕ್ಸಿಬಿಟ್ ಎಷ್ಟೊಂದು ಸ್ಯಾಲ್ರಿ ಕೊಟ್ಟಿಲ್ಲ. ಈ ಲೆವೆಲ್
21,551 minus 200.
ಎಕ್ಸಿಬಿಟ್ ಇಸ್ ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿ. ಯಾವ ಫೈಲ್ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ಅಡಿಷನಲ್ ಎವಿಡೆನ್ಸ್ ಅಪ್ಲಿಕೇಶನ್ ಏನಾದ್ರು ಹಾಕಿದ್ರೆ
ಇಲ್ಲ sir.
ಎಕ್ಸಿಬಿಟ್ P11. Last drawn salary was 21,541. 21,541.
Yes, ma'am.
ಅದರಲ್ಲಿ ಕೆಲವೊಂದು
200 rupees to be deducted as a professional tax.
ದಿಸ್ ಎಲ್ಲಾನು ಇದು ಸ್ಯಾಲ್ರಿ ಆಗೋದಿಲ್ಲ ಇದು. ಇಲ್ಲ ಒಂದು OA ಅಂದ್ರೆ ಏನು? OA ಅಂದ್ರೆ ಅದರ್ ಅಲೌನ್ಸ್ ಇರ್ಬೇಕು. OA ಅಂದ್ರೆ MA ಅಂದ್ರೆ ಮಿಸಲೇನಿಯಸ್ ಅಲೌನ್ಸ್, UA ಅಂದ್ರೆ ಯೂನಿಫಾರ್ಮ್ ಅಲೌನ್ಸ್, MA ಮೆಡಿಕಲ್ ಅಲೌನ್ಸ್,
Medical.
UA ಅಂದ್ರೆ ಯೂನಿಫಾರ್ಮ್ ಅಲೌನ್ಸ್ ಇರ್ಬೇಕದ. ಇವೆಲ್ಲ ವೆದರ್ ದೇ ಫಾರ್ಮ್ ದ ಸ್ಯಾಲ್ರಿ ಕಾಂಪೋನೆಂಟ್ 100 ಒಟ್ಟು ಅಷ್ಟು 325 ಆಗುತ್ತೆ ಅದು. 21,541 ಅದರಲ್ಲಿ 325 ಆಗುತ್ತೆ. 325 ಮತ್ತೆ ಪ್ರೊಫೆಷನಲ್ ಟ್ಯಾಕ್ಸ್ ಎಷ್ಟು?
200 rupees.
PT 200. ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಕಳೆದಿಲ್ಲ ನೋಡೋಂತ ಹೇಳಿದ್ರೆ ಇನ್ಕಮ್ ಮಾಡಿದಾಗ ಎಷ್ಟು ಬರುತ್ತೆ ಅಂತ. 200 ಅಂದ್ರೆ ಟೋಟಲಿ 525 ಕಳಿಬೇಕಾಗುತ್ತೆ. 21,541 minus 525 ಮಾಡಿ ಎಷ್ಟು? 21,016. 21,016 ಆಗುತ್ತಾ? Into 12 15. ಅಲ್ಲ ಅಂದ್ರೆ ನಾವು ಟ್ಯಾಕ್ಸಬಲ್ ಲಿಮಿಟ್ ಅಲ್ಲಿ ಬರ್ತಾರ ಅಂತ ನೋಡೋದಕ್ಕೆ. 21,016 into 12. 2,52,192. ಟ್ಯಾಕ್ಸಬಲ್ ಇದು ಲಿಮಿಟ್ ಎಷ್ಟಿದೆ?
Tax.
ಯಾವ ಇಯರ್ ಆಕ್ಸಿಡೆಂಟ್ ಇದು?
2016, my lord.
2016. ಟ್ಯಾಕ್ಸ್ ಲಿಮಿಟ್ ಎಷ್ಟಿತ್ತು ಅವಾಗ? ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಕಳಿಬೇಕಾಗತ್ತಾ?
It has already been deducted.
ಇಲ್ಲ
TDS has been.
ಇಲ್ಲ PT LIC ಅದನ್ನ ಕಳೆದಿಲ್ಲ. EGIS ಕಳೆದ ಅಂದ್ರೆ ಜನರಲ್ ಇನ್ಶೂರೆನ್ಸ್, ಅದು PT ಅಂದ್ರೆ ಪ್ರೊಫೆಷನಲ್, LIC, KZID, GPF ಇದರಲ್ಲಿ ಟ್ಯಾಕ್ಸ್ ಡಿಡಕ್ಟ್ ಮಾಡಿಲ್ಲ. ಅದು ಮಂತ್ಲಿ ಟ್ಯಾಕ್ಸಬಲ್ ಲಿಮಿಟ್ ನಲ್ಲಿ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಮಂತ್ಲಿ ಮಾಡೋದಿಲ್ಲ. ಮನೆಗೆಲ್ಲ ಕೂಡಿಸಿ ಯಾವ್ದೋ ಎಕ್ಸಸ್ ಬಂದ್ರೆ ಇದ್ರಲ್ಲಿ ಮಾಡ್ತಾರೆ. 2,52,192. 2,50,000. Any of you are aware what was the
Up to 3 lakhs.
up to 3 lakhs? ಆದ್ರೆ ಅದು ಮುಂದೆ ಜಾಸ್ತಿ ಎವ್ರಿ ಇಯರ್ ಜಾಸ್ತಿ ಆದಾಗ ಜಾಸ್ತಿ.
Income slabs up to 3 lakhs nil.
2,52,190. ಅಲ್ಲಿ ಎಷ್ಟಿತ್ತು ಅವಾಗ?
Up to 3 lakhs nil.
ನಿಲ್ಲ ಹೋಗ್ಲಿ. ಈಗ 2,52,000 ಎಷ್ಟು ಜನ ಡಿಪೆಂಡೆನ್ಸ್ ಎಷ್ಟು? 192.
2 members.
Dependents,
Dependents 3,
ಎಷ್ಟು
wife and 2 children.
ಎಷ್ಟು ಡಿಡಕ್ಟ್
Minor daughters, 2 minor daughters.
ಡಿಡಕ್ಷನ್ ಅವ್ರು ಮಾಡಿದ್ ಸರಿ
1/3. Correct, my lord.
ಸರಿ ಇದೆಯಾ?
1/3.
ಇದ್ರದ್ದು 2/3 ಎಷ್ಟಾಗುತ್ತೆ ನೋಡಿ? 2,52,192.
1,68,128.
1,68,128.
128.
ಇದು ಎಷ್ಟು? 38 ಅಂದ್ರಲ್ಲ? ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್
50% to be added.
50%. 1,68,128 50%.
84,064.
84,064. ಇದೆರಡು ಸೇರಿಸಿದ್ರೆ 1,68,128.
2,52,192.
1,68,128 plus 84,064.
2,52,192.
2,52,190.
192.
190 na?
192.
192.
92 multiplier 15
15, my lord.
into 15 ಮಾಡಿ
37,82,880.
37 lakhs
82,880.
880. ಅವ್ರು ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
38 lakhs.
ರೌಂಡ್ ಮಾಡಿದಾರಾ ಹೇಗೆ?
No, that has been up.
ಅಲೌನ್ಸ್ ಡಿಡಕ್ಟ್ ಮಾಡಿಲ್ಲ ಅವರು.
House.
ಓಕೆ ದೆನ್
Also consortium.
ಕನ್ಸೋರ್ಷಿಯಂ ಟೇಬಲ್ ಮಾಡಿದಾರಾ? ಟೇಬಲ್ ಮಾಡಿದ್ದಾರೆ. ಕನ್ಸೋರ್ಷಿಯಂ ದೇರ್ ಆರ್ 3 persons ಅಲ್ವಾ?
3 persons.
40,000 each.
Each 44,000.
With enhancement 44,000 each ಮಾಡ್ಬೇಕು. ಎಷ್ಟಾಗುತ್ತೆ ಅದು? Into
1
3.
lakh.
1,32,000.
1,32,000.
1,32,000. ಆಮೇಲೆ ಕನ್ವೆನ್ಷನಲ್ 30,000 ಆಗುತ್ತೆ. 15,000.
30,000. 34,000.
33,000
ಹ್ಮ್.
ಟೋಟಲ್ ಎಷ್ಟಾಗುತ್ತೆ? ತಗೊಳ್ಳಿ ಮಾಡ್ತೀರಿ ನಾನು. ಚಾಲೆಂಜಿಂಗ್ ಚಾಲೆಂಜ್ ಹರ್ಡ್ ಚಾಲೆಂಜಿಂಗ್ award dated award dated 8/3/2019 in MVC number 816 of 2016 passed by the Judge Additional Small Causes Court and the MACT alva Mysore. Judge Additional Court of Small Causes and MACT Mysore. The ನಿಮ್ಮದು ಅಪೀಲ್ ಮೊದಲ ಅವರ ಅಪೀಲ್ ಮೊದಲ? 8164. Claimant has preferred, claimants have preferred MFA number 3164 of 2020 and the insurer has preferred MFA number 6128 of 2019. The claimants are the wife. Claimant number 1 is the wife and claimants 2 and 3 are the minor daughters of victim Raju. Respondent number 1 Chikkanna child Sundaramma.
I am for the respond number. I am for the
He
respond.
responded.
ನಿನ್ನೆ ನೀವು ಇರ್ಲಿಲ್ವಾ? ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋದು ನೀವು ಇರ್ಲಿಲ್ವಾ ನಿನ್ನೆ?
ನಿನ್ನೆ ಇರ್ಲಿಲ್ಲ.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿದ್ದು ಗೊತ್ತಿಲ್ಲ. We were under the impression that you are representing Mr. Mahesh.
No, I am for
Wanted
the
to say
respond number.
something.
Lord, in this, my lord, the vehicle of the auto, there is no negligence, my lord. Everything which has been constable who is colluded with the department and he has created the
ವಿಟ್ನೆಸ್ ಬಾಕ್ಸ್ ನಿಮ್ಮ ಡ್ರೈವರ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದೀರಾ? ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ ನಿಮ್ಮ ಮೇಲೆ, ಡ್ರೈವರ್ ಅನ್ನು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ.
ಡ್ರೈವರ್ಗೆ
ಆಯ್ತು. Is the owner of car number K11 K9852. Respond number 1 is the registered owner and respond number 2 is one was the registered owner and respond number 2 was the insurer of car number KA11 A9852 at the relevant time. For the purpose of convenience, the parties are referred to henceforth according to their ranks before the tribunal. On 11/7/2016, please take your seats. At 9:30 AM, when Raju S was proceeding on his bike number KA45 E3934 near Pattegala Gate on BM Road, Hunsur, within the limits of Hunsur Rural Police Station. The said motorcycle met with an accident involving car number KA11 A9852. ಇದು ಅಲ್ವಾ spot death. Due to the injury suffered in the accident, Raju died on the spot. Regarding the accident, his colleague, Raju was working as a head constable. Regarding the accident, his colleague, one Basappa BN, Basappa, filed complaint as per Exhibit P2 before the P2 against the driver of the car before Hunsur Rural Police. Based on the same, Hunsur Rural Police registered FIR Exhibit P1 against the driver of the car in crime number 302 of 2016. ನಿಮ್ಮ crime number ಹಾಗೆ ಇದೆ ಅಲ್ಲ, 302. On investigation, the said police filed the charge sheet execution. Charge sheet as per Exhibit P7 against the driver of the car for the offenses punishable under section 279 and 304 AIPC and section 187 of the Motor Vehicles Act 1988 for short NV Act. The claimants filed, next paragraph, the claimants filed MVC number 816 of 2016 against the respondents, claiming that the accident and consequential death of Raju occurred due to the actionable negligence on the part of the driver of the car. They further contended that Raju was employed as a police constable in the police department, Karnataka Police Department, and earning rupees 23,500 per month, and they were dependent on his income. They were solely dependent on his income. They claimed that respond number 1 and 2, being the owner and insurer of the car, are liable to pay compensation of rupees 82 lakhs to them. First respondent ಕಾಂಟೆಸ್ಟ್ ಮಾಡಿದ್ರ ಬಗ್ಗೆ ಏನು ಬರದೇ ಇಲ್ಲ ಅಲ್ರಿ ಅದ್ರಲ್ಲಿ. ನೀವು ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದೀರಾ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ? ಅಡ್ವೊಕೇಟ್ ಹೆಸರು ತೋರಿಸಿದ್ದಾರೆ ಸುರೇಶ್ ಕುಮಾರ್. ಸೆಗ್ಮೆಂಟ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 ಮತ್ತೆ ಈಗ ಇಲ್ಲ. ಹೌ ಕ್ಯಾನ್ ಯು ಆರ್ಗ್ಯೂ ಹಿಯರ್?
Lord,
You have not filed the written statement before the tribunal.
Tribunal,
Respond number one.
respond number one in,
No appeared did not contest the matter. Respond number two. Alone contested the petition.
Respondent number one has not at all contested.
One, ಅವ್ರು
One.
contest ಮಾಡಿಲ್ಲ. ಅಲ್ಲಿ ಇವಾಗ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ರಲ್ಲ ಅದಕ್ಕೆ ಕೇಳಿದ್ವಿ. Respond number two, the insurer alone contested the petition denying the actionable negligence on the part of the driver of the lorry, the car, age, occupation and income of the deceased. It was, the second response further continued that the accident occurred due to the negligence of the victim himself. They also respondent to also denied its liability to pay the compensation. Next one. Before the tribunal, claimant number one was examined as PW1 and on behalf of the claimants exhibits P1 to 13 were marked. The official of respondent number two was examined as RW1 and on behalf of respondent number two, exhibit R1 the letter of authorization and R2 the insurance policy were produced. The tribunal on hearing the parties by the impugned award. The tribunal on hearing the parties on relying on exhibit P12, P7, P8, held that the accident P8 death certificate, P7 held that PM report. After producing the PM report, why did you produce the death certificate?
My lord,
After producing the PM report, why did you produce the death certificate exhibit P8? P1 to P7, P1 to P7, the police records held that the accident occurred due to the actionable negligence on the part of the driver of the car. Relying on exhibit P9 to 11, the Aadhaar card, driving license and salary certificate, the tribunal held that at the time of the accident, the deceased was aged 38 years and he was earning rupees 21,221. 21,541 by way of salary. On deducting the professional tax in the same, the tribunal considered his income as rupees 21,221. Added 50% to the same by way of future prospects. Applied. Just to multiplier. 15 multiplier. And deducted 1/3 out of the same for the personal expense of the deceased.
1/3.
And awarded compensation of this 38,19,780 by way of on the head of loss of dependency. The tribunal in all awarded compensation of this 39,19,780 on different heads as per the table below. Internal page 8 when is the start. Shri Sabur Leonard, the said award is challenged in the above appeals by the insurer and the claimants as aforesaid. Shri Sabur the council submits that the compensation awarded on the head of loss of dependency is on the lower side, and the tribunal should have awarded compensation to the children also on the head of consortium. Thus, he seeks the enhancement of the compensation. He further submits that the evidence adduced by the claimant sufficiently showed that the accident occurred due to the actionable negligence of the driver of the car. Thus, he seeks the enhancement of the compensation. Shri O. Mahesh, learned counsel, please take it. Yeah. O. Mahesh, learned counsel for the insurer. Submits that the internal reason possible motor vehicle inspector report that neither PW1 nor the complainant were the eyewitnesses to the incident. The IMV report. The IMV report exhibit P4 shows that the accident has occurred due to the negligence of the deceased himself. And at the time of the accident, the deceased was not wearing helmet. Therefore, the tribunal was not justified in holding that the accident occurred due to the actionable negligence on the part of the driver of the car. He further submits that the police and the claimants have not complied the provisions of section 134C and 158(6) of the Motor Vehicles Act. Therefore, the question of insurer rebutting the evidence of the claimant regarding the account of the accident does not arise. He disputes. He disputes something. He further claims that he further submits that the employer was not examined to prove the salary income of the deceased. Therefore, the compensation awarded on the head of loss of dependency is unsustainable. Thus, he seeks dismissal of the claim petition. Next, by allowing his appeal. She so and so learned counsel. ಎರಡರಲ್ಲೂ ಅಪಿಯರ್ ಆಗಿದ್ದೀರಾ ನೀವು ಒಂದರಲ್ಲೇ ಅಪಿಯರ್ ಆಗಿದ್ದೀರಾ
ಎರಡರಲ್ಲೂ
though the first respondent owner of the vehicle had not contested the matter before the tribunal, Shri so and so learned counsel appearing for him before this court submits that there was no negligence on the part of the driver of the car. But therefore, the award is unsustainable. Next one. Considering the submission of both sides and an examination of the records, the points that arise for consideration of the determination of number one, whether the finding of the tribunal that the accident occurred due to the actionable negligence accident and the consequential death occurred due to the actionable negligence on the part of the driver of car number KA11 A9852 is sustainable. Number two, whether the compensation awarded to the claimants, whether the compensation awarded under the impugned award is just one. Next, regarding point number one. None of the parties dispute that on 11/7/2016, at 9:30 a.m. PM.
PM.
21 ಅಲ್ಲೇನೋ ನಾವು ಮೊದಲು AM ಅಂತ
PM.
9:30 PM. So accident occurred near Pattegala Gate on BM Road, Hillsur Town. Involving motorcycle number KA45 E3934 and car number KA11 A9852. it was also not disputed that due to the injuries suffered in the accident, Raju died on the spot. The only dispute was with regard to the actionable negligence on the part of the driver of the car. It is no doubt true that PW1 and the complainant were not the eyewitnesses. However, on thorough investigation on the complaint against the driver of the car, the charge sheet exhibit P, as per exhibit P7 was filed against the driver of the car for the offenses punishable under section 279 and 304A IPC and section 187 of Motor Vehicles Act. In the proceedings before the MACT or the summary proceedings, in such cases, the charge sheet filed on investigation amounts to prima facie proof of actionable negligence on the part of the driver of the car, unless the same is rebutted. It is no doubt true that the charge sheet is not the conclusive proof. But once the charge sheet was filed, Evidence Act. Conclusive proof but as per section 114, 114E Evidence Act under section 114 of subsection 8 there is a presumption regarding the official acts. Presumption that the official acts are duly performed. Therefore, the charge sheet had the said presumption. By such document, the claimants discharged their initial burden of proof. Or correct, 114E. Further, then the burden shifted to the respondents to then burden shifted. Then the responsibility was on the respondents to discharge to rebut the said to rebut the said document or the fact with reference to the fact of occurrence of accident due to the actionable negligence on the part of the driver of the car. As already noted, respondent number 1 did not contest the petition at all. Even insurer did not choose to examine the driver of the car to rebut the evidentiary value of exhibit P. P7 charge sheet. P1 to P7. The IMA report, exhibit P4. Does not indicate that the driver of the, the victim himself was rash and negligent. Similarly, the plea that the deceased was not wearing the helmet was not taken before the tribunal. Driving license, he was, healthcare. Not substantial. Driver though the insurer contended that even the driving license the insurer contended before the tribunal in his written statement that the deceased was not holding a valid driving license and he was not wearing the headgear / helmet, and therefore he himself was responsible for the accident. However, the plea with regard to victim not possessing the driving license was falsified by Exhibit P10, the copy of the driving license. Neither the driver of the car nor any eyewitnesses were examined to prove that the victim was not wearing the helmet. Therefore, therefore the tribunal rightly rejected the said claim also. Having regard to the aforesaid facts and circumstances, the trial court was justified in holding that the accident occurred due to the actionable records ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ ಅಂತ ಅದೊಂದು ಪ್ರಕಾರ. So far as our application ಹಾಕಿರ್ತಾರೆ ನೋಡಿ ಅವ್ರದ್ದು ನಾವೇ ಮಾಡ್ತೀವಿ ಅಂತ. Whether in this case they have filed it?
My lord.
To take up all defenses ಅಂತ ಹೇಳಿ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಾರಲ್ಲ ಜನರಲಿ ಇನ್ಶೂರರ್, ಇದ್ರಲ್ಲಿ ಹಾಕಿದ್ರಾ?
ಇಲ್ಲ.
ನೋಡಿದಿರಾ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್? ಅವ್ರ ಅಪಿಯರ್ ಆಗಿರೋದ್ರಿಂದ ಹಾಕಿರದೇ ಇರೋ ಚಾನ್ಸ್ ಇರುತ್ತೆ. So far as the non-compliance of the provisions of section 134C and 158(6) of Motor Vehicles Act. ಇದೇನು ಅಲ್ಲೇನು ಯಾರಿಗೂ ಕೇಳಿಲ್ವಲ್ಲ, ಆದ್ರೆ ಪೊಲೀಸ್ ರೆಕಾರ್ಡ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿ ಕೇಳಿಲ್ಲ. ಅವ್ರು ಹೇಳಿದಾರ ಅವ್ರ ಎವಿಡೆನ್ಸ್ ನಲ್ಲಿ this RW1 ಹೇಳ್ತಾರೆ that I'm going to the motor vehicle inspector's card ಅಂತ ಕೊಡ್ಲಿಲ್ಲ ಅವ್ರು. The 134C is ಇವ್ರು ಕೊಡೋದು, ಇನ್ಶೂರರ್ ಕೊಡೋದು. ಆದ್ರೆ ಅವ್ರು ಇಲ್ಲಿ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಇದನ್ನು 158(6) ಕಂಪ್ಲೈ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿ. ಇಲ್ಲಿಯೂ ಪ್ರಶ್ನೆ ಮಾಡಿಲ್ಲ ಎಂದರೆ ಯಾರಿಗೂ ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ಸರಿ. Before the tribunal, ಇದ್ರಲ್ಲಿ ತಗೊಂಡಿದ್ರಾ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತ ಗ್ರೌಂಡ್ ತಗೊಂಡಿದ್ದಾರಾ? ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಬೈ ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇಲ್ಲೆಲ್ಲ 64B5 ತಗೊಂಡಿದ್ರು. 134C ತಗೊಂಡಿದ್ರು. Before the tribunal, the insurer's own witness did not whisper anything about the violation of section 158(6) of the Motor Vehicles Act or non-supply of charge sheet or police records. Further, ಏನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ನೀವು? ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ರಾ ಅಂತ ಇವ್ರಿಗೆ Motor Vehicles Act ನೋಡಿ?
Due to the lack of the helmet, my lord, he has not weared and
That has not been proved.
Hold
Cannot challenge.
134C ಒಂದೇ ಉಳಿದಿದ್ದಲ್ವಾ? Duty of the driver in case of accident or injury.
You come to the Mazar sketch also, my lord, you can find there. The negligent part of the,
The driver of the vehicle or the other person in charge of the vehicle shall give the following information that will be issued. So ಅವ್ರಿಗೆ against ಹೋಗ್ಬೇಕಷ್ಟೇ. So far as non-compliance of the provisions of section 134 C of the MA Act, if the insured did not give any certificates, furnish the certificates, etc., the insurer's remedy may be against him. However, since the insurance policy was not disputed, coverage of the vehicle under the insurance policy exhibit R2 another R2 was not disputed. Not disputed. Before the tribunal, full opportunity was given to the insurer to contest the matter, and the evidence of R1 shows that by the time they let in evidence, they were in possession of all the records. Therefore, that does not absolve the insurer of its plea. Under the circumstances, the trial court was tribunal was justified in holding that the accident and the consequential death of victim B. Raju was on account of actionable negligence on the part of the driver of Raju S. Raju S. On account of actionable negligence of the driver of the car number owner pickup ಇದು ಐಷಾ ಕಾರ್ ಅಂತ ಸಾರಿ ಐಷಾ ಲೆಮಿನ್ ನೋಡೋಣ ಐಷಾ ಅದು ಕಾರ್ ಅಂತ ಹೇಳಿದ್ವಿ ಪಿಕಪ್ ವ್ಯಾನ್ ಕರೆಕ್ಟ್ ಕಾರ್ ಇಲ್ಲಿ ಅದರಲ್ಲಿ ಕಾರ್
ಆಟೋ ಸರ್,
ಅದು ಎಲ್ಲದರಲ್ಲೂ ಪಿಕಪ್ ವ್ಯಾನ್ ಅಂತ ಇದೆ
ಆಟೋ.
ಇದನ್ನ ನೋಡಿ ಸರಿ ಎಲ್ಲೋ ರಿಸೀವ್ಡ್ ಅಲ್ಲ ಪಾಲಿಸಿನೂ ಇದೆ ಅಪಾರ್ಟ್ ಫ್ರಮ್ ದಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಕಾರ್ ಅಂತ ಬಂದಿತ್ತು ಕಾರ್ ನೋಡೋಣ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕುವಾಗ ಏನಂತ ಹಾಕಿದ್ರು
The goods auto.
ಆಪೆ ಗೂಡ್ಸ್
ಆಪೆ
ಸಾರಿ ಅದೆಲ್ಲಾನು ಎಲ್ಲಾನು ಬರೆದು ಆಪೆ ಗೂಡ್ಸ್ ವೆಹಿಕಲ್ ಅಂತ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ ಅಷ್ಟೇ. ಆಟೋ ಕರೆಕ್ಟ್ ಕೊಟ್ಟೆಲ್ಲ ಮಾಡ್ಕೊಂಡು ಕಾರಿಗೆ. ನೆಕ್ಸ್ಟ್ ರಿಗಾರ್ಡಿಂಗ್ ಪಾಯಿಂಟ್ ನಂಬರ್ 2 / quantum ಅಂತ ಹಾಕೊಳ್ಳಿ. The claimant's relationship with the deceased was not disputed. Their evidence coupled with ಅವರೇ ಸಜೆಷನ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಪೊಲೀಸ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ನಲ್ಲಿ ಇದ್ರು ಅಂತ. So far as the employment of the deceased in police department, ಅವರು ನೀನೇ ಹೇಳಿದ್ರು. Respond number 2, counsel for respond number 2 himself suggested to PW1 that on the death of Raju, PW1 got gratuity and other benefits amounting to 5-6 lakhs. He himself suggested that though she got a huge amount from the department to claim, to make exorbitant claim, she is saying that she received only 5-6 lakhs as terminal benefits. It was further suggested to her that she is getting pension of rupees. I'm sorry, her statement, her evidence that she is getting pension of rupees 10,000 was not disputed. It was suggested to her that her husband and complainant Basappa, Ravi andre yaru master witness idavra yaru? Ravi ಅನ್ನೋರ್ನ ಸಜೆಸ್ಟ್ ಮಾಡ್ತಾರಲ್ಲ. Complainant was Basappa. ಆ ರವಿ ಅನ್ನೋರು ನನ್ಗೆ ಹೇಳಿದ್ರು ಅಂತ ಬಸಪ್ಪ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. ಎಕ್ಸಿಬಿಟ್ P1 ಅಲ್ಲಿ ರವಿ ಅನ್ನೋರು ಅದಕ್ಕೆ ಹೇಳ್ತಾರೆ ಅಂತ. ನಾನು ಈಗ ಅವ್ರು ಫೋನ್ ಮಾಡಿ ಜೊತೆಗೆ ಇನ್ನೂ ಅವ್ನು ಕಂಪ್ಲೀಟ್ ಆಗಿಲ್ಲ. ನಮ್ಮ ಠಾಣೆ ನಾನು PC ರವಿ ಅವರು ಹೋಗ್ತಿರುವಾಗ ಹೋಗ್ತಿದ್ದಾಗ ಲೋಕೇಶ್ ಫೋನ್ ಮಾಡಿ ಹೇಳಿದ್ರು ರವಿ ಅನ್ನೋನು ಬಹುಶಃ ಚಾರ್ಜ್ಶೀಟ್ ವಿಟ್ನೆಸ್ ಅವ್ರ ಜೊತೆಗೆ ಇರ್ತಾರೆ. ಪ್ರೊಬೆಬ್ಲಿ ಇನ್ವೆಸ್ಟ್ ಮಾಲ್ಸರಲ್ಲಿ ಅಲ್ಲಿ ಇಲ್ಲೇ ಅನ್ನೋ ಅಪಿಯರ್ ಆಗಿರ್ತಾರೆ. ದಿಸ್ ಇಸ್ ಚಾರ್ಜ್ಶೀಟ್ ಅಲ್ಲ ಇಲ್ಲಿ ಹುಡುಕೋಣ. ರವಿ CW4 ಏನ್ ಮಾಡಿದವ್ರು ಇವರು ಸಾಂದರ್ಭಿಕ ಸಾಕ್ಷಿ ಕೃತ್ಯ ಏನಂತಾರೆ ಇಬ್ರು ರವಿ ಇದಾರೆ ಪ್ರತ್ಯಕ್ಷ ಸಾಕ್ಷಿ. ಇದು ಫಾರ್ಮರ್ ಇಲ್ಲ ಫಾರ್ಮರ್ ಪೊಲೀಸ್ ಆಫೀಸರ್ and Ravi who is cited as charge sheet witness number 4 ಒಂದೇ ಇಲಾಖೆಯವರಿಂದ ಕೂಡಿ ಮಾಡಿದ್ದೀರಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಏನ್ ಬರ್ತದೆ ಡಿಪೋಷನ್ since her husband complaint Basappa and charge sheet witness Ravi belong to the same department. All of them together have filed a false complaint. ಅವರು ಇದ್ರಲ್ಲಿ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿದ್ದಾರೆ. RW1 ಇಲ್ಲ ಆದ್ಮೇಲೆ RW1 even in the evidence of RW1 nothing was elicited to disprove the employment of Mr. Raju in the police department. Therefore, there was no reasons to disbelieve his employment or his salary particulars exhibit P11. As per exhibit P11, in the month preceding the date of accident, the salary drawn by the victim was rupees 21,541. Out of that, a sum of rupees 100 plus 100 plus 125 were some allowances which were not the part of the salary. Therefore, that has to be deducted. Further, a sum of rupees 200 has to be deducted towards professional tax as statutory deduction. Therefore, thus his salary comes to, monthly salary comes to 21,016. ಅದೆಷ್ಟು ಕಳೆದಿದ್ವಲ್ಲ ಅಷ್ಟು ಡಿಡಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಪ್ಲಸ್ 200 ಅಂತ ಮಾಡ್ಕೊಂಡ್ವಿ. therefore his monthly salary 525 ಆಗುತ್ತೆ total. monthly salary comes to rupees 21,016 and ಹೀಗೆ ಮಾಡೋಣ. annual salary comes to rupees 21,016 into 12 2,52,192. and nothing was produced to show that during the year 2016 alla the The said salary, annual income of the deceased was within the taxable limit. Therefore, the entire income has to be taken for the purpose of computing the compensation. The deceased left behind him 3 dependents. In view of the judgment of the Supreme Court of in Sarala Verma's case, 1/3 has to be deducted towards his personal expenses. Therefore, his contribution to the family comes to 2,52,192 into 2/3 lakh. 1,68,128. As per the judgment of the Supreme Court, and having regard to the age of the deceased, 50%. 50% has to be superadded to the income of the deceased by way of future prospects. Therefore, his annual income comes to bracketly 1,68,128 plus 84,064. 2,52,192. As per the judgment of the Supreme Court, the applicable multiplier to the age of 38 is 15. Therefore, the compensation payable on the head of loss of dependency comes to 2,52,192 into 15 is equal to 37,82,880. As per the judgment of the Supreme Court in Pranay Sethi's case and Magma Corporation case, the compensation is of ₹40,000 each is payable to the wife and children with escalation at 10%. Therefore, the same comes to 44,000 into 3 multiplied is equal to 1,32,000. As per the judgment of the Supreme Court in Pranay Sethi's case, the compensation payable on the conventional heads of loss of estate and funeral expenses. Funeral expenses is 15,000 plus 15,000 with escalation of 10. 15,000 with escalation of 10%, which comes to 16,500, 16,500. 33, total 33,000. ಅವ್ರು ಏನ್ ಮಾಡಿದ್ದಾರೆ, ಲವ್ ಅಂಡ್ ಅಫೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ. On awarding compensation on the head of consortium, no other compensation is payable again on the heads of ಇನ್ನೊಂದು ಯಾವ್ದೋ ಕೇಸ್ ಟ್ರಾನ್ಸ್ಪೋರ್ಟೇಷನ್ ಲವ್ ಅಂಡ್ ಅಫೆಕ್ಷನ್. Therefore, the just compensation payable, interest ಬಗ್ಗೆನೂ ಹೇಳಿದ್ರಲ್ಲ, payable is as follows. ಇಂಟ್ರೆಸ್ಟ್ ಬಗ್ಗೆ ಏನಾದ್ರು ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ವಲ್ಲ ನಿನ್ನೆ.
9%
ಅಲ್ಲ, ಅವರು 9% ಕೊಟ್ಟಿದ್ ತಪ್ಪು ಅಂತ ಹೇಳಿದ್ರು, 6% ಕೊಡ್ಬೇಕಾಗಿತ್ತು ಅಂತ. ಬೇರೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ 9% ಕೊಟ್ಟಿದ್ದಿದ್ದೆ ತೋರಿಸಿ ಅಂತ ಹೇಳಿದ್ವಿ, ನೀವು ತರ್ಲಿಲ್ಲ.
ಇಲ್ಲ
ತರ್ತೀನಿ ಅಂತ ಇವತ್ತು ಹೇಳಿದ್ರಿ.
ಇಲ್ಲ, I had to search.
Pedestrian matter.
ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ, prevailing ಇದು ಬ್ಯಾಂಕ್ ರೇಟ್ ಎಷ್ಟು ಅಲ್ಲ, ಅದ್ರ ಬಗ್ಗೆ ಅವ್ರು ಏನ್ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿದ್ರು. ಇನ್ ಸೆಬಾಸ್ಟಿಯನ್ ಲೆಟರ್ ಇಸ್ ಅಬೌಟ್ ಪೆನ್ಷನ್. ಆಯ್ತು ಅಲ್ಲ, ಇದರಲ್ಲಿ ಸ್ವಲ್ಪ ಎಷ್ಟಾಯ್ತದು ಅವರು ಟ್ರಯಲ್ ಟ್ರಿಬ್ಯುನಲ್ ಅವ್ರು ಕೊಟ್ಟಿದ್ದು ಎಷ್ಟಿತ್ತು?
39 lakh.
What would be the enhanced? ಬರ್ಕೊಳ್ಳಿ, ಹೇಳ್ತೀನಿ. Loss of dependency 37,82,880. Consortium 1,32,000. Then loss of estate, funeral plus funeral expense and transportation 33,000. Total 39,42,000. 47,880. Round 5 done. 48,000. 49. ಅಲ್ಲ, ನಾನು 47 ಇದ್ದದನ್ನ 48,000 ಗೊತ್ತಾಗಿರ್ತಾರೆ. ಇಲ್ಲ ಅಂದ್ರೆ ಹೋಗಿದ್ರು ಅಲ್ಲಿ ಅವ್ರು 7 ಇದು ಕೊಟ್ಟಿದ್ದಾರೆ. 39,19,780 ಕೊಟ್ಟಿದ್ದಾರಾ?
ಹೌದು.
What will be the difference? 100. 26,100 ಜಾಸ್ತಿ ಆಗುತ್ತೆ ಅಷ್ಟೇ.
26,000.
ನೀವು ತರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಾವು 6% ಕೊಡ್ತೀವಿ ಇಂಟ್ರೆಸ್ಟ್.
I'll produce Monday.
ಯಾರು ಇಲ್ವಾ ಇಲ್ಲಿ? ಬರೀ ಮತ್ತೆ ಕ್ಲೈಮೆಂಟ್ಸ್ ಅಡ್ವೊಕೇಟ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಇನ್ ಒನ್ ಜಜ್ಮೆಂಟ್. ಬಟ್ ಫ್ಯೂಚರ್ ಎನ್ಹಾನ್ಸ್ಡ್ ಅಮೌಂಟ್ ಮೇಲಂತೂ ಅಷ್ಟೇ ಕೊಡೋದು. ಅದಕ್ಕೆ ಏನ್ ರೀಸನ್ ಹೇಳಿದಾರ? ಟ್ರಯಲ್ ಕೊಟ್ಟವ್ರು ಹೇಳೋದ್ರಲ್ಲಿ ಹೇಳಿದಾರ 9% ಕೊಡೋದಕ್ಕೆ ಏನೋ ರೀಸನ್ ಹೇಳ್ದಂಗಿಲ್ಲ ಅವ್ರು. ಅದನ್ನೇ ಅವ್ರು ನಿನ್ನೆ ಹೇಳಿದ್ದು. minus awarded by the tribunal 39,19,780. Enhancement 26,100. So far as the rate of interest. We don't find ಅಂತ ಅಷ್ಟೇ ಮಾಡ್ತೀವಿ. There is one judgment, so Supreme Court 1 or 2 judgments ಇದೆ, ಒಂದೇ ಇಲ್ಲ. ನೀವು ಕ್ಲೇಮೆಂಟ್ಸ್ ಅಡ್ವೊಕೇಟ್ಸ್ ಏನು ತರೋದಿಲ್ಲ. ನೋಡಿ, ರೇಟ್ ಆಫ್ ಇಂಟ್ರೆಸ್ಟ್ ಏನು ಕ್ರಾಸ್ ಇದೆ. ಅದು ಜಡ್ಜ್ಮೆಂಟ್ ನಾವು ಆಮೇಲೆ ನಾವೇ ಬರ್ಕೊಳ್ತೀವಿ ಅದರಲ್ಲಿ. The claimants who are the young aged widow and minor children lost their breadwinner. There was nothing to show what was the response also did not produce anything to show what was the prevailing rate of interest. However, that considering the peculiar facts of the present case and the cost of living and prevailing cost of living at the relevant time, it cannot be said that the tribunal granting the interest at 9% per annum was arbitrary. However, the enhanced compensation, interest at 6% can be awarded on the enhanced compensation. ಇಬ್ಬರದು ಅಪೀಲು ಪಾಟ್ಲೆ ಎಲ್ಲ ಆಗುತ್ತೆ. ಅಲ್ಲೊಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ, ನೀವು ಕೊಡಿ ಅಂದ್ರೆ ಕೊಡ್ತಾ ಇದ್ದಾರೆ.
Monday.
ನಾವು ಹಿಂದಿನವೆಲ್ಲ ನಮ್ಮ ಜಡ್ಜ್ಮೆಂಟ್
Monday I'll.
ನಾವೇ ಹುಡುಕ್ಕೊಳ್ತೀವಿ. ಇನ್ನಾದ್ರು ಈಗ ಹುಡುಕಿಸ್ಕೊಡಿ, ನೋಡ್ತೀವಿ, ಅದ್ರಲ್ಲಿ ಹಾಕ್ತಿವಿ. ಈಗ ಕೊಡಕ್ಕಾಗತ್ತೆ. ನೀವು ಇದನ್ನ ಚೆಕ್ ಮಾಡಿದ್ರೆ ಸಿಗುತ್ತೆ, ನಿಮ್ಮ ಮೊಬೈಲ್ ಅಲ್ಲಿ ಚೆಕ್ ಮಾಡಿದ್ರೆ. ಅಲ್ಲ, hence both the appeals deserve to be allowed in part. ಅದಕ್ಕಿಂತ ಮೊದಲು, since the insurance policy was in force, the insurer is liable to pay the said compensation, though the liability of the insurer and the owner is joint and
Monday I'll.
several, joint and several. Hence the following order. ಎರಡು ಈಗ ಅವ್ರ ಇಂಟ್ರೆಸ್ಟ್ ರೇಟ್ ಇಲ್ಲಿ ಡಿಸ್ಕಸ್ ರೀಅಸೆಸ್ ಇಲ್ಲ, ಹೆಚ್ಚೆ ಮಾಡಿದ್ವಿ. ರೀಅಸೆಸ್ ಮಾಡಿದ್ರೆ ಎಲ್ಲದ್ರಲ್ಲ. MFA number 6128 of 2019 is dismissed. MFA number 3164 of 2020 is partly allowed. The claimants are awarded compensation of this 26 enhanced the compensation awarded under the impugned award is enhanced by rupees 26,100 payable with interest at 6% per annum on the same from the date of the petition till its realization. The second respondent insurer shall deposit the said amount before the tribunal. ಅವ್ರದ್ದು ಇಲ್ಲಿ ಕೊಟ್ಟಿದ್ರಲ್ಲಿ 25,000 ಆಗೋಗುತ್ತೆ ಅದು. Before the tribunal within 4 weeks from the date of the receipt of the copy of this order. The award, the impugned award with regard to the apportionment and investment is maintained. That registry shall transmit the amount in deposit and the TCS to the tribunal for. Justice Gavai ಅವರು welfare registration. Next.
For final hearing, seal number 37, M.R. Narayan, Gurraj Joshi, for R1, Nikhilesh Shah.
I appear for the respondent number 3 and 4. But we are in the process of filing NOC. We have not received we have received client instructions. We have placed out a complaint.
Argument ಮಾಡ್ಬೇಕು ಯಾರು MR ನಾರಾಯಣ್
I'm ready.
ನೀವು ಮಾಡಿ ಇದರಲ್ಲಿ contesting party would be the KSFC ಅಲ್ವಾ
Yes.
I am the personal guarantors in the matter, my lord. So until they file, until the new council enters appearance.
This is of the year 2012.
Yes, my lord.
ನೀವು NOC ಕೊಟ್ಟಿದ್ರೆ then why are you worried about your client?
No, my lord. We are in the process of giving you.
To argue the matter? No, sorry. 2012 matter time ಕೊಡಕ್ಕಾಗಲ್ಲ. Yes. You are the principal borrower.
I'm the guarantor, not the principal.
ನೀವು guarantor.
I'm the guarantor.
He said he is also guarantor.
Yes.
Yes. ಶಿವಮೊಗ್ಗ ಕಾಸ್ಟಿಂಗ್ ಅಂತ ಶಿವಮೊಗ್ಗ ಕಾಸ್ಟಿಂಗ್ ಅಂತ ಹೆಸರು ಇಂಡಸ್ಟ್ರಿ ಹೆಸರು. ಎಸ್ ಎಸ್
The appellant is the respondent number 2 is before the trial court. And the respondent number 1 is the petitioner before the trial court. The respondent 1, Karnataka State Finance Corporation, filed a miscellaneous petition under section 31(1)(a) of the State Finance Corporation Act for enforcing the personal guarantee executed by the appellant and other guarantors. The principal amount due is 1.5 crores plus interest of 17 crores 83 lakh 81,719, and thus in all about 19 crores 33 lakh 81,719. That was as on 10/3/2010. The principal borrower is Shimoga Castings Private Limited. That is the respondent number 2.
Yes.
The Honorable Trial Court has held that corporation has rightly invoked the personal guarantee and directed the appellant to pay the sum. The difference in nutshell are, first is the respondent corporation did not demand payment from the principal debtor, that is R1, Shimoga Castings Private Limited, before invoking the personal guarantee as appellant and other guarantors. And therefore, the proceedings are void ab initio. Second is, the respondent corporation has not bothered to demand payment from the guarantors before filing the petition under section 31(1)(a). If this honorable court were to hold that they have invoked the guarantee properly and they have demanded the payment from the principal creditor before invoking bank guarantee, then my alternative submission would be the proceedings are hid by law of limitation. Then the fourth difference is,
The first contention is that because they did not proceed against the principal borrower.
no, they did not, they did not demand payment from the principal creditor, and principal creditor it is not the case that he has neglected to make the payment.
Correct, that's creditor and debtor.
The principal debtor.
Debtor.
Ah,
They did not demand from him first. First, they should have proceeded against him and then.
Not proceeded against.
Yes.
The law of guarantee comes into effect if only the guarantor, if the principal debtor fails to make the payment.
Therefore, there should be default.
So no default on his, unless he becomes defaulter, you can.
Yes, unless they demand, I demanded, he has not paid, therefore we are invoking the bank guarantee, that should be the notice.
That means the same thing, Alva.
I will, when I read the notices, I think I'll be able to convince your lordships.
Yes.
No.
Second one was that it was not demanded from you also.
Oh, from the guarantors also, they are demanded, they straight away file the matter. The only thing is, both the matters, both these grounds revolves around the tone and tenor of the notice given by them. Alternatively, it is hit by limitation. Fourth condition is, on account of the laches and negligence on the part of the respondent one finance corporation, I am not liable to pay the money. They cannot invoke my guarantee because laches and negligence on the part of the. And the fifth is, the respondent corporation has played fraud on the guarantors and obtained the guarantee. Therefore, guarantee is not invocable. Before I could,
Guarantee is taken by fraud and.
fraud and this.
Yes.
Before.
Yes.
Before I could elaborate my argument, the petition is only 2 pages. The entire argument is based on the averments made in the petition. Therefore, I may be permitted to read the petition. May I read it?
Yes.
Para 1, 2, 3, 4 are general in character, no relevance to the case on hand. Therefore, I skip that paragraph. From para 5 onwards, it has got the relevant facts to the case. Therefore, I read it. It is submitted by the petitioner corporation that the respondent one company, namely Shimoha Castings Private Limited, hereinafter referred to as SCPL, has made an application to KSFC on 22/11/1995, seeking financial assistance by way of term loan of rupees 150 lakhs to establish a foundry industry at plot number 279, Ebbal Industrial Area, Woothalli, Mysore. The term loan of rupees 150 lakhs was sanctioned by the board of KFCC on 29/12/95, and the terms of the loan sanction was communicated to the respondent company via letter dated dated 10/1/96. The respondent company had proposed to establish the industry at the above address on the land and building belonging to Shimoga Steels Limited. My lord, I pray your lordship to underline this point because this has got a relevance elsewhere. On the land and building belonging to Shimoga Steels Limited. The land and building does not belong to me, belong to the principal borrower.
Shimoga Steels is the principal borrower.
Yes, my lord.
Shimoga Steels was the principal borrower.
Castings Private Limited is the principal borrower. They have started the industry in Shimoga Steels Limited.
They are different.
2 different companies are. One is Shimoga Steels Limited. Another is Shimoga Steel Castings Private Limited. The principal borrower is Shimoga Castings Private Limited.
Yes. Shimoga Steels was a Sikh industry, no?
Both are Sikh. My subtle point, what I want to impress is, the principal borrower started the industry in the land and building belonging to another company. And that company is also borrowed money from the KSFC. Therefore, whatever the loan they have given, whatever I spent on the building, The KSFC knows very well that it is not recoverable. It is because addition to the land. I'll come back to the point. This is the point. What I am trying to is the KSFC was knowing
To say that whatever he had borrowed from the KSFC had invested in that building.
in that land and building.
So to that extent, there should be set off.
I am not asking that set off. I am not asking set off. I'll come back to the later. What I am trying to say is the KSFC is aware, whatever the loan they are giving, that loan, they can recover it from the machineries hypothecated, not on the land and on the building constructed by the borrower. To that extent, the KSFC is aware that the loan was fully not secure. Why they have given it, I'll come back 2 minutes later. The next question. On the land belonging to Shimoga Steels Limited, Mysore, Shimoga Steels Limited had purchased the property of a Sikh industry, namely NN Castings Private Limited, sold by KSFC under deferred payment liability basis. Later, Shimoga Steels Limited entered into a licensing agreement with the respondent company, and the said licensing agreement was approved by the petitioner corporation. According to the agreement, the licensee was required to pay monthly license fee fixed by the licensor directly to the KSFC towards the deferred payment liability of the licensor. It was also set out in the terms and conditions of the license agreement that the petitioner corporation has right to proceed against the licensor's asset in the event of default payment by the licensee. License fee by the licensee. The licensor had secured the land and building and machineries to KSFC by way of mortgage to discharge its own liability under deferred payment agreement, and so also collateral security to the repayment of the loan of rupees 150 lakhs availed by the respondent company.
Yes.
What emanates from this paragraph itself is one NN Industries was a Sikh industry. It was funded by KSFC. When they become Sikh, they sold that industry under section 29 of the CH-3 Act to Shimoga Steels. Shimoga Steels Private Limited. Shimoga Steels again became Sikh. They asked these people to start on leave on license on the land and building owned by them. They are given assurance that Shimoga Steels Limited has mortgaged their property, land and building towards the repayment of their own loan, as well as towards the repayment of the loan availed by the principal borrower here. That is Shimoga Steels. Therefore, the principal borrower, the guarantors who are the directors, were given to understand that I am no way responsible for the losses because I am investing on the land belonging to Shimoga Steels Limited, and they are giving the mortgaging the property. I have to pay the license fee. They will pay that. If anything goes wrong, the Shimoga Steels Limited will do it. Only thing is I have to put my effort and see that the industry is profitable. As far as the financial risk is concerned, the entire risk is on the shoulder of the Shimoga Steels Limited. That is what the KSFC has promised. That is what the sentence also says like that. But that has not come to. We'll see.
No, you said you are the owner of Shimoga Steels, these guarantors.
I am from the Shimoga Castings Private Limited.
Steels, castings.
I am an engineer.
No, you purchased the Sikh unit, that Shimoga Steels.
No, Shimoga Steels, the other company, my parents.
Steels purchased from NR.
And they are giving it on license to me after they could not successfully run it.
So you are only an operator.
I am only an operator.
You are not liable to pay the.
No, I am not trying to say, it is not that way. What I am trying to say is, I am taken on leave on license basis. Therefore, therefore the Karnataka State Finance Corporation is aware of it. Whatever the loan they are given to me, whatever the improvement I am making to the building will not accrue to me. It will go to them. That is why they made them also to be They have made them to mortgage the property towards my loan.
Those and ಅವ್ರಿಗೆ.
The Simova Seals Limited mortgage their property, land and building on which I am operating towards the repayment of my loan
To the KSFC.
to the KSFT. To the KSFT. Therefore, I was under the impression, my liability is limited. Whatever the capital I have invested, about 36 lakhs or whatever it is, either I will get it or it will go. I will not be asked to pay further. That is what the persons were saying that. They said again, I'll come back to them.
So you mean to say that you borrowed 36 lakhs only for plant and machinery or development of the building?
Yes, only plant and machinery, only whatever the 1.15 crore they are given, only the plant and machinery is the asset. Other asset is not my asset. That KSFC knows it.
That is already mortgaged to them.
That is mortgage to them. That is
Mortgaged to them by Shimoga Steel.
Steels. That Simona Steels Limited itself. No, my lord. No, my lord. That Simona Steels.
Got your point. Yes.
Yes, ma'am.
We got your point.
Yes. And that steel itself has purchased a Sikh industry from NN Industries without paying any amount, only book transfer under section 29. The whole thing boils down to the fact that the misdeeds of Karnataka State Finance Company while financing NN Steels Private Limited, when they could not recover it, when they did not treat as bad debt, instead of that, they have transferred to Sima Steels Private Limited, and Sima Steels again gave the permission to run the industry. There are, however, stripe.
So this recovery is regarding the loan advance to Shimoga Steels or Shimoga.
This 150 lakhs was given to me.
So it was transferred along with the loan.
No. See, after taking the premises of the industry on leave and license basis, to run it, they have given further capital to me, 150 crores, 1.5 crores, towards plant and machinery and erection of the improvement in the building.
So total loan borrowed was 150 crores.
Not 150 crores, 1.5 crores, 150 lakhs.
150 lakhs.
150 lakhs, 1.5 crores.
So 1.5 lakhs crores ಇದ್ದದ್ದು ಈಗ 19 crores ಆಗಿದೆಯಾ?
No.
ಜೋಶಿ ಅವ್ರು ಯಾವಾಗ್ಲೂ ನಿಮ್ದು ಭಾರಿ ಜಾಸ್ತಿ ಇರುತ್ತಲ್ಲ KSFC ಅವ್ರದ್ದು. ನಿನ್ನೆ ಒಂದು ನೋಡ್ತಾ ಇದ್ವಿ. What was sanctioned was 31 lakhs. ಎಷ್ಟಾಗಿತ್ತು ಅದು? More than 8 times, 8.5 times ಹೆಚ್ಚಾಗಿತ್ತು. 24% interest.
Because 22%, which they have agreed.
No, 24% interest on quarterly interest, quarterly resting. It is not 24 interest simple. 24% compound interest rest on quarterly. Every 3 months, the loan will be, the interest will be added to the capital.
Today,
with open eyes ತಗೊಳ್ತಾರಲ್ಲ ಲೋನ್ ತಗೊಳ್ಳೋರು.
ಅಲ್ಲ ಅವತ್ತು ಬೇಕಾಗಿತ್ತು ತಗೊಂಡ್ರು. ಇವತ್ತಿನ ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ ಇವತ್ತಿನ FD ರೇಟು ನಾವು ಕಂಪೇರ್ ಮಾಡಕ್ ಬರಲ್ಲ. ಬಿಕಾಸ್ ಅವತ್ತಿನ ದಿವಸ ಅಷ್ಟಿತ್ತು.
ಇಲ್ಲ, ಎಲ್ಲರಿಗಿಂತ KSFC ಜಾಸ್ತಿ ಇರುತ್ತೆ. ಬ್ಯಾಂಕ್ ಲೋನ್ಗಿಂತ KSFC ಲೋನ್ ಜಾಸ್ತಿ, ಇಂಟ್ರೆಸ್ಟ್ ಜಾಸ್ತಿ ಇರುತ್ತೆ ಯಾವಾಗ್ಲೂ.
ಮೊದಲಿಂದ ಇದು 92.
Not only in this case. ಎಲ್ಲ ಕೇಸಲ್ಲೂ we see generally 24% interest ಇರುತ್ತೆ. ಹೌದು, ಅವ್ರು ಹೇಳಿದಾಗೆ ಕ್ವಾರ್ಟರ್ಲಿ ರೆಸ್ಟ್.
ಸ್ವಾಮಿ, ಇನ್ನೊಂದು ಪಾಯಿಂಟ್, ಇವತ್ತು KSFC ಇಂದ ಲೋನ್ ತಗೊಂಡು ಮರ್ಸಿಡೀಸ್ ಬೆಂಚ್ ಕಾರ್ ತಗೊಂಡು ಮಗಳಿಗೆ ಪ್ಯಾಲೇಸ್ ಗ್ರೌಂಡ್ ನಲ್ಲಿ ಮದುವೆ ಮಾಡಿ ಈ ಸದಾಶಿವನಗರದಲ್ಲಿ ಮನೆ ಮಾಡಿದ್ರೆ ಲಾಸ್ ಆದರೆ ಯಾರು? Who is responsible?
We are not trying to get us, we are not asking with reference to this case.
Yes.
ಏನ್ ಯಾಕೆ ಆ ರೀತಿ ಅಂದ್ರೆ ಅವ್ರದ್ದು
That was system. It's a government.
ಲೆಂಡಿಂಗ್ ಇದು ಈಸಿ ಇರುತ್ತೆ ಅಂತ.
ಇಲ್ಲ, ಲೆಂಡಿಂಗ್ ಪಾಲಿಸಿ ವಾಸ್ ಲೈಕ್ ದಟ್ ಆಸ್ ಎಟ್ ದಟ್ ಟೈಮ್.
ಈಗ ಬ್ಯಾಂಕ್ ನಲ್ಲಿ ಆದ್ರೆ 108 ಕೇಳ್ತಾರೆ, ಈಸಿಯಾಗಿ ಲೋನ್ ಸಿಗೋದಿಲ್ಲ. ಆದ್ರೆ KSFC ಲೆಂಡಿಂಗ್ ಪಾಲಿಸಿ ಈಸಿ ಇದೆಯಾ?
ಹೌದು.
ಅದಕ್ಕೆನಾ 24%?
ಹೌದು.
Yes.
Out of the subject, only one sentence.
And this particular appellant is no more in India. He already ಪಾರಲ್ಲಿದ್ದಾನೆ, ಪಿಟಿಷನ್ ಅಲ್ಲೇ ಹೇಳಿದ್ದಾನೆ.
ಕೇಳಬೇಕಾಗಿತ್ತು ಅಂದ್ರೆ
ಅಲ್ಲ, ನಾವು ಹೇಳ್ತೀವಿ, we are in the hands of my lordship.
ಯಾಕೆ ಅಂದ್ರೆ ಯಾಕೆ ಜಾಸ್ತಿ
ಇಟ್ಸ್
ಇರುತ್ತೆ?
ಪಬ್ಲಿಕ್ ಮನಿ.
ಒಂದೇನಾದ್ರೂ ಅಡ್ವಾಂಟೇಜ್ ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ರೆ ಅದ್ರ ಇಂಟ್ರೆಸ್ಟ್ ಜಾಸ್ತಿ
ಕೊಟ್ಟಿದ್ದೀವಿ.
ಇರುತ್ತೆ. ಅದೇ ಅಡ್ವಾಂಟೇಜ್ ಏನು ಅಂದ್ರೆ ಬ್ಯಾಂಕ್ನವ್ರಿಗಾದ್ರೆ ದೇ ಸೀಕ್ ದ ರಿಕವರಿ ಅಪರ್ಚುನಿಟಿ ಅದೆಲ್ಲ
Yes.
ತುಂಬಾ ಸ್ಟ್ರಿಂಜೆಂಟ್ ಇರುತ್ತೆ ಅವ್ರದ್ದು.
ಹೌದು.
ಸ್ಯಾಂಕ್ಷನಿಂಗ್ ಪಾಲಿಸಿ ಇಸ್ ವೆರಿ ಸ್ಟ್ರಿಂಜೆಂಟ್. ನಿಮ್ದು ಹಾಗಿರೋದಿಲ್ಲ ಅಂತಾನ ಯಾಕೆ ಅಂತ.
ಇದೆ, ನಮ್ಮಲ್ಲೂ ಇದೆ, ಸ್ಟ್ರಿಂಜರ್ ಪಾಲಿಸಿ ಇದೆ. ಅವ್ರದ್ದು ಪ್ರಾಜೆಕ್ಟ್ ರಿಪೋರ್ಟ್ ಎಲ್ಲ ನೋಡ್ತೀವಿ, ಅವನ್ನೆಲ್ಲ ಔಟ್ಲೈನ್ ನೋಡ್ತೀವಿ, ರೀಪೇಮೆಂಟ್ ಶೆಡ್ಯೂಲ್ ನೋಡ್ತೀವಿ ಎಲ್ಲ.
Question is, in spite of you charging such a heavy rate of interest.
Yes.
Why do the borrowers come and take a heavy loan at that point of, at that rate of?
Because they don't
Is there some
meet out
relaxed-
their targets. They don't meet out their market targets. ಇವತ್ತು ರಿಲಯನ್ಸ್ ಧೀರುಭಾಯ್ ಅಂಬಾನಿ 2 ಮಕ್ಕಳು, ಒಬ್ಬ ಮಗ ಸಕ್ಸಸ್ಫುಲ್ ಆಯ್ದ, ವರ್ಲ್ಡ್ ನಂಬರ್ 2, ನಂಬರ್ 3, ಇನ್ನೊಬ್ಬ ಮಗ ಲಾಸ್ ನಲ್ಲಿ ಇದ್ದಾನೆ. ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ ಅಂದ್ರೆ? ಸೊ ಇಟ್ಸ್ ಆಲ್ ಬಿಕಾಸ್ ಬೇಸ್ಡ್ ಅಪಾನ್ ದೇರ್ ಮ್ಯಾನುಫ್ಯಾಕ್ಚರಿಂಗ್ ಸಿಸ್ಟಮ್ಸ್ ಆರ್ ಮಾರ್ಕೆಟಿಂಗ್ ಸಿಸ್ಟಮ್ಸ್. ರಿಲಯನ್ಸ್ ಕಮ್ಯುನಿಕೇಶನ್ ಹೋಯ್ತು.
ಆಯ್ತು, ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಲಿ. ಅದು ವಿ ಆರ್ ಅವೇರ್ ಆಫ್ ಇಟ್. ನಿಮ್ದು ಬಹಳ ದೊಡ್ಡದು ಲೋನ್ ಏನು ಬೇಡ, ನಾವು ನೋಡ್ತೀವಿ. ಈ ಸ್ತ್ರೀ ಶಕ್ತಿ ಗ್ರೂಪ್ ನಲ್ಲಿ ಪಾಪ ಹೆಂಡಂದ್ರ ಹತ್ರ ಸಾಲ ಮಾಡಿಸ್ತಾರೆ. ನೀವು ಮರ್ಸಿಡಸ್ ಬೆಂಚ್ ಕಾರ್ ಬೇಡ. ಸ್ತ್ರೀ ಶಕ್ತಿ ಗ್ರೂಪ್ಸ್ ಲೆಂಡ್ ಲೋನ್ ಟು ದೀಸ್ ವಿಮೆನ್. ಹಸ್ಬೆಂಡ್ಸ್ ಏನ್ ಮಾಡ್ತಾರೆ ಅಂದ್ರೆ ಮೋಟರ್ ಸೈಕಲ್ ತಗೊಳ್ತಾರೆ, ಟಿವಿ ತಗೊಳ್ತಾರೆ, ಆಮೇಲೆ ಲೋನ್ ಬಂದಾಗ ಇವ್ರಿಗೆ ಬಂದಿರುತ್ತೆ.
ಹೌದು.
ಅಲ್ಲ, ಅದ ಒಂದೇ ಬರೀ ದುಡ್ಡು ಜಾಸ್ತಿ ಸಿಕ್ತು ಅಂತಲ್ಲ, ಕಡಿಮೆ ಸಿಕ್ಕಲ್ಲೂ ಇದೆ ಆ ಟೆಂಡೆನ್ಸಿ.
ಮಾಡ್ತಾರೆ.
No, only one sentence out of the way. The institution has been promoted to develop industries, small scale industries and small scale entrepreneurs. This is the interest. I don't want to say further. I am bound by that. I am not questioning the rate of interest. I am not questioning the rate of interest. I am bound by that.
It was, I mean, this was a doubt in our mind. ಅಷ್ಟು ಹೈ ರೇಟ್ ಅಲ್ಲಿ ಇದ್ರು ಯಾಕೆ ಈಸಿಯಾಗಿ ಲೋನ್ ತಗೊಳ್ತಾರೆ ಅಂತ.
The whole thing boils down when government does business. Para 6. It is submitted by the petitioner corporation that the first respondent agreed to the terms and conditions set out in the loan agreement letter dated, a copy of which is enclosed herewith. The respondent agreed compound interest 14%, and I am not going that. Further, the first respondent, you not got it, about last 4 lines from paragraph 6. Further, first respondent hypothecated the machineries installed in the premises of plot number 279, KIDB, Ebbal Industrial Area, Mysore, accord of the term loan of 150 lakhs sanctioned by the petitioner corporation. In addition to this, licensor namely Shivaga Steels Limited has mortgaged the land and building at plot number 279, KIDB, Industrial Area, Mysore as collateral security for the repayment of 150 lakhs availed by this fund. Therefore, as far as the case is concerned, it is a secured loan. Secured loan is given by Shivaga Steels Limited. Now, at this point, I will later demonstrate that as on that day, Shivaga Steels Limited was not the owner of the building. They have executed a sale deed, it's a fast sale deed. And even today, after doing all these things, the Shivaga Steels Limited, after all these things, they have become the owner. As on this day, today,
whose favor they have executed the sale?
Shivaga Steels Limited mortgaged the property in favor of KSFC. Therefore, they should have been the owner on that day. They were not the owner. That sale deed was a fair sale deed.
Which sale deed?
Sale deed between the KSFC and Shivaga Steels Limited.
The sale deed and the mortgage deed.
No. See, first they sold it, then they got the mortgage. What they sold it from NN Industries, they have sold the entire property to them under Section 29. At that point of time itself, NN Industries was not the one of the land. They are only the lessees of the KIDB land. So what they did is, in order to make this loan secure, they made a fire sale deed in favor of Shivaga Steels Limited. Again got a mortgage deed. Once the original deed is passed, the mortgage deed also passed. That is the reason why they are not foreclosed the mortgage deed. Instead of that, they have come to the guarantors. I will demonstrate later just for the how relevant at this stage. That is why I am trying to say. Then para 7. The guarantee deed executed on such and such and day, there in para 5, that I am not disputing it, therefore I am missing it. Para 7, the first respondent turned out to be a chronic defaulter in repayment of the loan, and therefore the petitioning corporation was constrained to issue notices for payment dues to the respondent 1 to 5. The respondent's company is under liquidation, and the assets of the first respondent company is in the custody of the official liquidator, Honorable High Court of Karnataka. The petitioner corporation has filed an application to the Honorable Court of Karnataka to permit them to sell the secured assets standing outside the winding up part and also dealing the assets of the first company. Here itself, the case of corporation admits they are secured creditors. The winding up the company by the High Court of Karnataka will not come in the way of repossessing these assets and selling it because they are secured creditors. And they say they have filed the application. Now I will come later. When they have filed the application, what has happened to the application? Now, para 8. The balance outstanding is so much, then your lordship gets the table. The table does not say what is the opening balance, when it starts, what is the interest, what is the penal interest, nothing, and what is paid, nothing. It simply says that. And little going back to paragraph 7. The first respondent turned out to be a chronic defaulter in repayment of the loan, and therefore petitioning corporation was constrained to issue notices for the payment of the dues to the respondent number 1 to 5. Notices demanding payment from respondent, that means from the principal creditor as well as the guarantors. In other words, they treat the guarantor and the principal borrower in the same footing. And they did not say when they issued the notices, when it was served. Because the period of limitation starts from the issue of notice. Again, para 10. The last 3 lines, the same was also brought to the notice of the respondent notice by the corporation by causing several notices and reminders. Again, they say lot of notices were issued, reminders were given, dates are not given. And the dates of the notices and reminders are important because limitation starts from there. Having regard to the default committed by the respondent, the corporation decided to invoke the personal guarantee given by all of them under the deeds of guarantee referred to earlier, and in pursuance of the said decision, the corporation invoked the personal guarantee given by all the respondents in respect to the loan amount referred to above, and in terms of the above said deeds, guarantee caused the notice to the respondent number 1 to 2 to 4 on 21/7/2007. This date is important. And respondents 5 on 13/2/2010. They say the cause of action arose on para 14. The cause of action arose on when they issued the notice to them.
Yes, according to you, the land belongs to Shimoga Steels.
Shimoga Steels Limited.
And the building and the machinery which has been put up is by.
No, land and building belongs to Steels Limited. Additions made there.
Only the additions made is by the.
By the
castings.
principal.
That is Shimoga casting. Loan was obtained by the Shimoga castings to the extent of the.
1.5 crores.
Renovate,
To improvement the land and building.
Development of the building.
So only of the development of the building.
And run the, in the,
Mortgage was to the extent of, mortgage was to the extent of,
full loan. The loan would due by them.
from the Shimoga.
Ah,
They brought it up under section 29. Even I Shimoga still not purchased. Shimoga still not purchased, but by again that industry has created default. And the default ಆಗಿಲ್ಲ ಅವ್ರು ಅವರಿಂದ ಮೊದಲೇ ಶಿವಮೊಗ್ಗ ಸ್ಟೀಲ್ಸ್ ಮಾರ್ಟ್ಗೇಜ್ ಮಾಡಿಬಿಟ್ಟಿದ್ರು ಲ್ಯಾಂಡ್ ಅಂಡ್ ಬಿಲ್ಡಿಂಗ್ ಅನ್ನು.
Steels had already done this.
Land and building already it was mortgage.
Their liability is limited to the loan taken by Shimoga Castings only. ಆ ತಪ್ಪು ಹೇಳಿದ್ರೆ it is my duty to assist the court. Guarantee deeds are like that.
That's
my lord, let me give an hypothetical examination, explanation for this. Suppose the Shimoga Steels Limited had a loan amount of 7.5 crores. And KSFC has given 1.5 crores to us. 7.5 plus 1.8, 9 crores. For the entire 9 crores, the building, the land and building was mortgaged by Shimoga Steels Limited in favor of KSFC. Therefore, the value of the building, land and building as on that date must have been much more than or 75% of the value of the loan given by them.
right next. But they take so many conditions in that guarantee letter. Absolving other principal debtor, etc. That will not, you cannot question that on that ground. Anta. A guarantee agreement alla class irtave.
My lord, what happens, the judicial thinking for a long time is once you have signed it, you are agreed by that. And equity is not applicable because public money. Equity is not applicable, public money. Now, after the end of the hearing, it is my conviction, I have been rubbed on the wrong side. Not I have been rubbed on the wrong side, not as an individual. The institution is working on the wrong side. The target, wherever the target is there, it is the worst enemy. The bank manager has to lend loan, bank manager has to give the Gramina loan also, whether there is a borrower or not. If see somebody and gives it and put topi and the other fellow does not understand it. And what my friend says is I go by Benz car, his car and that thing. No, what I'm trying to, it is not the case. What they should do, what every corporation should see, every banker should see, before applying for the loan to me, you please give me your wealth. You give me your assets. Then when you become a defaulter, what is your asset? If there is an increase in the asset at the cost of the borrowing. But if I am going in the Benz car for 3 generations, I have taken the loan, I have sold the Benz car. No, no, this public notion.
You are telling that their policies are wrong. They
No, we cannot.
they lure the borrowers ಅಂತ ಹೇಳ್ತಾ ಇದ್ರಲ್ಲ. Lure them to furnish the wealth, so you will buy the bench car.
No,
ಅವ್ರೇನೋ ಹಬ್ಬ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ಅದಕ್ಕೆ ಹರಕೆ ಕುರಿ ನೀವ್ಯಾಕೆ ಆಗ್ಬೇಕು? If they want to make celebration.
That is what they say. See, out of only one sentence, Bajaj Finance and other finances, they are giving loan for purchase of TV, EV and I think 9.5% without any security they are collecting. They give all the securities, all the documents and everything, they become default.
Correct, now come to your
Okay,
point.
now I'll come back to you. Now, 126 of the contract.
By permits, I was in Saudi Arabia for a period of 2 years in 93. I deposited 1 lakh rupees as a NRNR account on a non-repatriable, non-resident, non-repatriable. What is the interest I was getting? 18% from SBI. I have a certificate copy. Copies.
ಅದು ಯಾವಾಗ? ಯಾವ period?
93. It is when they have taken the loan 92, 93.
ಅಲ್ಲಲ್ಲ.
So lending rate was higher than what they were offering the FD rate. So ಇವತ್ತಿನ 9% ಅನ್ನ
ಅದು ಯಾವಾಗ ಬಂತು ಅದು ಲೋನ ಮೇಳ?
loan ಮೇಳ is different.
Some banks ಯಾವಾಗ ಅದೇನೋ ಒಂದು ಲೋನ್ ಇದೆ ಪೂಜಾರಿ ಅಂತಿದ್ರಲ್ಲ, some ministry ಯೂನಿಯನ್
ಬೇರೆ ಬೇರೆ ಸ್ಟೇಜ್ ನಲ್ಲಿ ಬೇರೆ ಬೇರೆ RBI ಗೈಡ್ಲೈನ್ಸ್ ಮೇಲೆ ಬರ್ತದೆ. ನಮಗೂ RBI ಗೈಡ್ಲೈನ್ಸ್ಗೂ ಇದಿಲ್ಲ.
ನಿಮ್ದೇನೋ ಸೆಬಿ IDBI ಅಂತ.
Yes. Yes.
They lend you and you lend it.
ಅಲ್ಲ ನನಗೆ 18% I was getting. 18% I was getting for my FD.
ಆಯ್ತು.
ಇವತ್ತು
Come to the point, ನಮ್ದು ಇದು ಮುಗಿಸ್ಬೇಕು.
ಇವತ್ತು ನಾನು ಸೀನಿಯರ್ ಸಿಟಿಜನ್ ಆಗಿ ಓನ್ಲಿ ಐ ಆಮ್ ಗೆಟಿಂಗ್ 8.22 ಫ್ರಮ್ ದ ಸೇಮ್ SBI.
ಅದಕ್ಕೆ ಕೇಳಿದೆ ಯಾವ ಇಯರ್ ಅಲ್ಲಿ ಅಂತ. ಯಾಕಂದ್ರೆ ಯಾವಾಗ ಇದೆಲ್ಲ ಬಂತು ಅವಾಗ.
ಅದೇ ಇವ್ರು ತಗೊಂಡ್ ಪೀರಿಯಡ್.
ಎಸ್.
126 is the Contract Act. 126 defines contract of guarantee, surety, principal, debtor, and creditor. A contract of guarantee is a contract to perform the promise or
Where are
discharge.
you reading?
120 Contract Act.
They are reading contract
One-
act.
126. Section
Contract
126.
act. Contract act. Already you can read it. ಓದಿ ನೀವೇ ಓದಿ.
No, I will pass it on. I have got the,
ನಮ್ದು ಇರುತ್ತೆ, ನೀವು ಹೇಳಿ ಸೆಕ್ಷನ್ ಅಷ್ಟೇ ಹೇಳಿ ಬರ್ಕೊಳ್ತೀವಿ. ಸೆಕ್ಷನ್ ವೇರ್ ಆರ್ ರೀಡಿಂಗ್? ಸೆಕ್ಷನ್
126. Well, I have the extract here.
ಇದೆಯಾ? ಆಯ್ತು, ನಮ್ದು ಬಂತು. ಎಸ್.
A contract of guarantee is a contract to perform the promise or discharge the liability of a third party in case of his default. The person who gives the guarantee is called the surety. The person in respect of whose default the guarantee is given is called as the principal debtor. And the person to whom the guarantee is given is called as the creditor. A guarantee may be. So in case of his default, the guarantor is liable to pay the liability or discharge the third party in case of his default. Therefore, condition precedent is there must be a default. The default arises only when the creditor makes a demand and the principal debtor neglects or refuses to pay. Till the default happens, the status of creditors and the guarantors are totally different.
Yes.
Now, your lordship may see exhibit P11, page number 109 of the paper book.
Is it notice?
109, notice, exhibit P11 is the notice.
Yes.
It is given by one advocate by name, Mr. T.K. Bank. Vedamurthy. It is addressed to, first, it is addressed to the principal debtor himself, that is Simova Castings Private Limited. Next, also registered office. Second, Subramaniam, that is the appellant. Then Samir's Surendra Gupta, one of the guarantor, the other guarantor. Rakesh Gupta, another guarantor. Under instruction from my client. So it treats, this notice treats, all of them are on the same board. Jointly and severally, it looks as if the guarantor is also jointly and severally liable for the liabilities. Under the instruction from my client, Karnataka State Finance Corporation, head office at 1 Timmaya Road near Cantonment Railway Station, Bangalore, issue this notice. It is represented my client that at the request of the first of you, represented by its director, Sri Subramaniam, Sri Rakesh Gandhi, Sri Samir Gandhi, and 2 to 4 of you have given personal guarantee in favor of my client, standing guarantee by all of you for a total sum of rupees 1 crore 50 lakhs has been sanctioned and disbursed to the first of you on 10th. Void loan number dated for the purpose of expansion of the existing medium scale industry at plot number 279, whatever it is. Upon execution of the security document, hypothecation of plant and machinery, in addition to that, all of you have executed personal guarantee in favor of my client. In addition to that, all of you have mortgaged hypothecated plant and machinery. In the document, all of you have agreed to guarantee the loan amount lent by corporation wide account number dash. If any default made by the first of you in repayment of the loan amount with interest, commitment charges of any other money guarantee should by all of you shall pay the corporation or the whole principal amount or interest or commitment charges as mentioned above therein. All of you have executed deed of guarantee dated that. In spite of agreed terms and conditions, as well as pre-installment notice, as post-installment demand made by the corporation, all of you have failed to comply with the agreed terms and conditions of repayment of the installments now due. Now all of you are still due, which was not cleared by all of you in spite of the repeated reminders. Hence, the corporation suspects the bona fides of repayment from your end. Hence, this notice invoking personal guarantee all of you as per the guarantee deed dated. Now, it treats the guarantors as the principal debtors. Then it says it works. And in the note, as I already stated, the first person is the principal debtor. Can they invoke on the bank guarantee as the first principal debtor? Therefore, this notice misses the niceties of law. The difference between the principal debtor and the guarantor when the guarantor comes into play. Therefore, my lord, this notice is invalid. Now, your lordship may kindly see the statement of objection, para 11, 324 of the case.
Same paper book?
324.
Adhe paper book or next paper book?
Same paper book.
Huh?
Same paper book.
Next
Same paper book, only one paper book.
ಇಲ್ಲ ಎರಡಿದೆ ಇದರಲ್ಲಿ
Here so 324 is first volume 1.
295 it ends at 295.
324.
Yes.
Para 11.
Para 11 is on 325.
Para 6, my lord. The averments are denied. The averment made in the para 11 of the petition that they have served the notice and that thing, it has been denied. The averments are denied and the petitioner may be put to strict proof for the same. It is submitted that the petitioner issued notice referred to therein only to only for the purpose of saving the Provisions of Limitation Act. It is another matter. Notice has not been served as stated therein. And they have not produced any acknowledgement for having served it. Not only that, they are not even produced even the postal receipt for having posted the notices. Now, let us see the deposition of PW1 in this regard. Page number 123 of the paper, first volume.
We'll continue on some other day. Not the one. 2:30 ಗೆ. ಅಲ್ಲ, ಬೇರೆ ಇನ್ಯಾವ್ದು day sir? Tuesday.
We continue to it will be better and
Monday we have already.
I understand. I am understanding. What the only thing is the line of argument should not be missing.
Correct.
Anyhow,
Or if you can file your synopsis if you.
I have filed.
Yeah.
Detailed I have filed it. Page number, reference, everything I have filed.
Monday
Detailed
we have
synopsis.
Tuesday ಹಾಕೋಬಹುದು. Tuesday at 2:30.
Tuesday, what? Tuesday, what is the date?
5/3.
5th, I am going out of station. 5, 6, 7, I am out of station.
ಆಯ್ತು ಬಿಟ್ಟಲ್ಲಿ ಸರ್.
10th only. 10th or 11th.
Counseling.
12th, any day.
For further hearing as requested, please stand one. The notes of the record. ಉಳಿದಿದ್ದು ಎಲ್ಲಾನು ಕರ್ಸೇ ಬಿಡೋಣ.
File number 38. Chandrasekhar B. Pula Nemi Chandra.
38. ಆದ್ರೆ ಪಾಸ್ ಓವರ್ ಆಗಿತ್ತು. 38 ಇದು ಇವತ್ತು ಆಗೋದಿಲ್ಲ. ಆಫ್ಟರ್ನೂನ್ ವಿ ಹ್ಯಾವ್ ಯಾರು ಚಂದ್ರಶೇಖರ್ ನೀವು ಆಫ್ಟರ್ನೂನ್ ಆಗೋದಿಲ್ಲ. ಮಂಡ್ಯ
Monday 4th.
ಮಾಡೋದಂತೂ ಮಾಡ್ತೀವಿ ನೋಡಿ. ಮಂಡೇ ಆಯ್ತು. ನೀವು ಅವತ್ತೊಂದ್ ದಿವಸ ಮೆನ್ಷನ್ ಮಾಡಿ ಅಷ್ಟೇ.
File number 39.
Monday.
4/3. Ramya HN.
My lords, I beg to appear for appellants in this matter, my lordship.
Is it that case, your lordship, the claim, I am appealing for the claimant respondent.
All right, but today it's not possible because afternoon we have special benches.
That's Wednesday, my lords.
Any date may be fixed.
13/3.
List on 13.
Grateful.
File number 40.
My lord, in this case, I appear for the appellant, my lord. It's a case of paraplegia, my lord. Hence, there is urgency in this matter. Kindly a short date may be given, my lord.
ಹೇಳಿ ಯಾವ್ದು ಒಂದು
6/3.
Much obliged.
List on 6.
File number 41. Kundika Ishwar Bhatt.
I will not be able to take up this matter. List on Tuesday or Wednesday.
21/3.
ಯಾವ್ದು ಶಾರ್ಟ್ ಡೇಟ್ ಅಂತ ಹೇಳಿ ನಾವು ಕುತ್ಕೊಳ್ಳೋದಷ್ಟೇ. ನೀನು ರೀಚ್ ಆದ್ರೆ 18/3.
File number 42. For the Rajeshwara PN.
For the appellant.
For R6, my lord.
Any date in the next week.
ಡೇಟ್ ಹೇಳಬೇಕು. As requested list on 2012 RFL
5/3.
5/3.
Much obliged.
File number 43.
42.1 ಅಲ್ಲಿ ಕಂಪ್ಲೈನ್ಸ್ ಇದೆ ಅಲ್ಲ ಅದರಲ್ಲಿ.
Malats, ಅದು ಕಾಮನ್ ಪೇಪರ್ ಬುಕ್ ಫೈಲ್ ಮಾಡಿ.
No, that is R4 is not served. ಅದರಲ್ಲಿ ಬರ್ತದೆ. At request 42.1 ಅಲ್ಲಿ ಬರ್ತದೆ. Request finally 10 days time is granted to do the needful, failing which the appeal against R4 shall stand dismissed. ಅಂದ್ರೆ 10 days ಬಿಟ್ಟು ಹಾಕೊಳ್ಳೋದು.
We have filed common paper book, my lord. So
It's not paper book process.
R4, we will take.
ನೋಡಿ 10 days time. Okay.
File number 43.
For the respondent, my lord.
ಏನ್ ಮಾಡೋದಿದೆ?
7th or 11th.
ಯಾವ ಡೇಟ್ ನಮ್ಗೆ
7th is not possible, my lord.
7th not possible. On date ಹೇಳಿ ಒಂದು 7th ಆದ್ಮೇಲೆ
14th.
14. As requested list on
Court officer, Bangalore bench. Okay. Okay.
Hello, sir, Kalburgi bench,
Hello?
ಕೇಳಿಸ್ತಾ ಇದೆಯಪ್ಪ?
ಹಾ
ಕೇಳಿಸ್ತಾ
ಮೇಡಮ್,
ಇದೆಯಾ?
ಮೇಡಮ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? ಕಲಬುರ್ಗಿ ಬೆಂಚಿಂದ?
ಫಸ್ಟು ರಾಚಯ್ಯ ಸಾಹೇಬ್ರ ಜೊತೆ ಒಂದ್ ಬೆಂಚ್ ಇದೆ.
ಹೌದಾ ಮೇಡಮ್?
ಅದಾದ್ಮೇಲೆ ಒಂದೇ ಒಂದ್ ಮ್ಯಾಟ್ರ್ ಇದೆ. ಅದಾದ್ಮೇಲೆ ಜೋಶಿ ಸಾಹೇಬ್ರ ಜೊತೆ.
ಹೌದಾ ಮೇಡಮ್?
ಹೌದು.
ಅಂದ್ರೆ ಸಾಹೇಬ್ರಿಗೆ ಒಂದ್ 5 ನಿಮಿಷ ಲೇಟ್ ಅಂತ ಹೇಳೋಣ ಮೇಡಮ್, ಮತ್ತೆ ಬಂದಿಲ್ಲ.
ನಾ ಹೆಂಗ್ ಹೇಳಿ ಮೇಡಮ್?
ಅದೇ ಮತ್ತೆ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ ಇವಾಗ. ಒಂದ್ ಮಾತು ಹೇಳಿರ್ಲ, ಫಸ್ಟ್ ರಾಜಾಯ್
ಫಸ್ಟ್
ಸಾಹೇಬ್.
ರಾಚಯ್ಯ ಸಾಹೇಬ್ರ ಜೊತೆ ಒಂದ್ ಬೆಂಚ್ ಇದೆ,
ಹಾ.
ಆಮೇಲೆ ನಿಮ್ದು ಅಂತ ಹೇಳಿ. ನೋಟಿಫಿಕೇಶನ್ ಪ್ರಕಾರ ಅದೇ ತರ ಇರೋದು.
ಹೌದಾ ಮೇಡಮ್? ಸರಿ ಮೇಡಮ್, ಹೇಳ್ರಿ.
ಓಕೆ.
What up, sir?
Sir, O Mahesh sir.
ಮೇಲ್ಗಡೆ ನೋಡ್ತೀನಿ.
Sir, O Mahesh sir. O Mahesh sir. Mahesh sir. Sir, ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಮಹೇಶ್ ಸರ್? ಉಪೇಶ್ ಅದೆಲ್ಲ ಆನ್ ಮಾಡಿ ಅದನ್ನ. ಓ ಮಹೇಶ್. ಅವ್ರಿಗೆ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ ಅವ್ರಿಗೆ. ಪ್ರಭು ಒಂದು ಫುಲ್ ಡಿಕ್ಟೇಷನ್ ಆಯ್ತು. ಸರ್ ಮಹೇಶ್ ಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
What up, sir?
ಹಾ ಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಸರ್?
What up, sir?
ಸರ್ ಕೇಳಿಸ್ತಾ ಇಲ್ವಾ ನಿಮ್ಗೆ? ಅಯ್ಯೋ ಎಂತಕ್ಕೆ ಇವ್ರು ಕೇಳಿಸ್ತಾ ಇಲ್ಲ? ಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? ಫ್ರೈಡೆ ಅಲ್ಲ, ಇದು ಫ್ರೈಡೆ ರಜಾ. ಓ ಮಹೇಶ್ ಸರ್, ಏನು ಅಂತ ಅರ್ಥ ಆಗ್ತಿಲ್ವಲ್ಲ. ಮಹೇಶ್ ಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? ಬೇರೆಯವ್ರಿಗೆಲ್ಲ ಕೇಳಿಸ್ತಾ ಇದೆ, ಇವ್ರಿಗೆ ಯಾಕೆ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ ಅಂತ. ಹಾ? ಏನೋ ಪಾಪ ಅವ್ರದ್ದೇ ಡಿಕ್ಟೇಷನ್ ಆಗಿದ್ದು.
What of sir?
ಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? ಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ನಿಮ್ಗೆ? ಅಯ್ಯೋ, ಯಪ್ಪನ್ ಫೋನ್ ನಂಬರು ಇಲ್ಲ ನನ್ನ ಹತ್ರ.
What of sir?
ಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆ ನನ್ಗೆ, ನಿಮಗ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಭಾಳ ಐತಿ ಸರ್, ಲೈಟ್ ಆಗಿ ಕೇಳ್ತದೆ.
ಲೈಟ್ ಆಗಿ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? ಸರ್ ಇಲ್ಲಿ ಜೋರಾಗೆ ಬರ್ತಿದೆ.
ಸೀರಿಯಲ್ ನಂಬರ್ 36 ಏನಾಯ್ತು?
36 ಸರ್ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಮ್ಯಾಟರ್ ಅಲ್ವಾ
ಹಾ,
ಸರ್? ಅದು
ಡಿಕ್ಟೇಷನ್ ಆಗ್ಬೇಕಾಗಿತ್ತು.
ಆಯ್ತು ಸರ್, ನಿಮ್ಮ ಅಪೀಲ್ ಡಿಸ್ಮಿಸ್ ಟು ಕ್ಲೇಮೆಂಟ್ಸ್ ಟು ಪಾರ್ಟ್ಲಿ ಅಲೋಡ್.
ಪಾರ್ಟ್ಲಿ ಅಲ್ಲೋಡಾ?
ಟೋಟಲ್ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಆಗಿದ್ದು 39,47,880.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಓಕೆ ಸರ್. ಅಲ್ಲ, ಇಷ್ಟು ಕೊಡ್ಕೊಂಡಿದ್ದೀನಿ, ಕೇಳಿಸಿಲ್ಲ ಅನ್ಸಲಿಲ್ಲ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್.
ಹಾ ಸರ್, ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಹಾ, ನಾನ್ ಕೇಳಿಸ್ತಾ ಇದೆ.
ಹಾ
ನಮ್ದು ಚೈತನ್ಯ ಹೆಗ್ಡೆ
ಹಾ ಸರ್, ನಿಮ್ದು ಜೋಶಿ ಸಾಹೇಬ್ರ ಜೊತೆ ಫಸ್ಟ್ ರಾಚಯ್ಯ ಸಾಹೇಬ್ರ ಜೊತೆ ಒಂದೇ ಒಂದು ಮ್ಯಾಟ್ರ್ ಇದೆ, ಅದಾದ್ಮೇಲೆ ನಿಮ್ದು.
ಓಕೆ, ರೈಟ್, ಥ್ಯಾಂಕ್ ಯು.
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು. Frauders. Still number 1. Manjunath S.
Kindly pass for me. I have engaged.
Huh?
Kindly pass.
Pass over in the first.
ಇರೋದೇ ಒಂದ್ ಬೆಂಚ್ ನಮ್ದು.
Okay, I have
How
engaged.
about RP is filed when the council who filed the above RP is not on record in MFA number 6941 of 2013?
Observation already.
Huh?
Observation already complied.
Office subsection is regarding how you could file the office subsection, I mean this review petition, because you were not there on record in the main matter. ಅಲ್ಲಿ ನಿಮ್ ಸಲುವಾಗಿ ಕುತ್ಕೋಬೇಕಲ್ರಿ, ನಮ್ಗೆ ಬೇರೆ ಏನು ಕೇಸ್ ಇಲ್ಲ. ಯು ಆರ್ ದ ಅಡ್ವೊಕೇಟ್ ಆನ್ ರೆಕಾರ್ಡ್ ಆರ್ ಯುವರ್ ಪ್ರಾಕ್ಸಿ? ಮತ್ತೆ ಹೇಳಿ ನೀವೇನೇ ಈಗ. ನೀವು ರೆಡಿ ಇಲ್ಲ ಅಂತ ಬರ್ಕೋಬೇಕಾಗುತ್ತೆ ಅಷ್ಟೇ.
ಅಲ್ರಿ ಈ ತರ ಇದ್ದಾಗ ಇಲ್ಲಿ ಬರ್ಬೇಕು ಅವ್ರು ಫಸ್ಟ್.
ಇಲ್ಲಿ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ವರ್ಚುವಲ್ ಈಗ ನಿಮ್ ಸಲುವಾಗಿ ಬೇರೆ ಎಲ್ಲಾ ಬಿಟ್ಟು ನಾವು ಮತ್ತೆ ಅವ್ರಿಗೂ ನೆಕ್ಸ್ಟ್ ಬೆಂಚ್ ಇರುತ್ತೆ, ನಮಗೂ ನೆಕ್ಸ್ಟ್ ಬೆಂಚ್ ಇರುತ್ತೆ. ವಾಟ್ ಕೈಂಡ್ ಆಫ್ ದಿಸ್ ಸಬ್ಮಿಷನ್ಸ್ ಆರ್ ದಿಸ್? ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ಪಿಟಿಷನರ್ ಏನ್ ನಾಟ್ ಪ್ರಿಪೇರ್ ಟು ಆರ್ಗ್ಯೂ ಅಂತ ಹೇಳ್ಬೇಕಾ? It's time to submit on the office subsections list after 1 year. Next week.
ಸರ್ ನಮಸ್ತೆ ಸರ್, ಬರ್ತಾ ಇದ್ದಾರೆ ಸರ್.
Okay, okay.
ಓಕೆ. Number 1, Chaitanya Hegde, G.R. Mohan.
Yes, I, Lordship, appear for the respond 1 to 9. I'm filing a memo, Your Lordship. Appeal has been filed before the Honorable Supreme Court.
You are filing memo.
Appeal, Monday it is listed, Your Lordship, before Supreme. I have sent the message to his colleague.
Is there online?
Online.
I have sent it to his colleague, I have sent a message already. Lord, I appear for the appellants.
Oh. So, it's still SLP.
SLP, yes.
Yes.
I have sent it to the colleague.
Yeah, send
Lord,
it
I
to-
appear for the appellants.
Correct, he's filing a memo.
I got it. Now,
My
so far
brother
as,
has no.
no, I mean, so far as that memo is concerned, I have nothing to say. But the thing is. No, I sent
No,
a message to his colleague who has served the copy to me.
Correct.
No, I got it.
Monday.
Whether I am audible, your
This
lordship.
memo is not with our.
No, he has not come
brother.
today.
ಅವರಲ್ಲ ರೀ ನಮ್ಮ ಬೆಂಚ್ ಮೇಟ್
ಜೋಶಿ ಸಾಹೇಬ್ರಿ. ಜೋಶಿ
ಇದೆ
ಸಾಹೇಬ್ರಿ.
ಇದೆ
ನೀವು ಮೆಮೊ ಕಳಿಸಿದಾರಾ?
ಮೆಮೊ ಇಲ್ಲ ಇಲ್ಲಿ.
ಮೆಮೊ ಕಳಿಸಿದಾರಾ ನಿಮ್ಗೆ?
ಅಲ್ಲ, ಇವತ್ತು ನಿನ್ನೆ ಲಿಸ್ಟ್ ಆಗಿರೋದು ಮ್ಯಾಟರ್ ಅದು. ಇವತ್ತು ಬಂದಿರೋದು ಕೋರ್ಟ್ ಮುಂದೆ.
ಇಲ್ಲ.
R1 to 9. R1 to 9.
Filing a memo 1 to 9 saying that SLP is
This is the
preferred and that is order to be listed. ಯಾವಾಗದು? 4/3. It is order to be listed on 4/3.
Millards, may I make a submission?
Yes.
Printout your lordship.
ನೋಡೋಣ ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ
Yes, sir.
Yes, ಹೇಳಿ
Yes.
Mr. Shekhar.
May I make a submission?
Yes, ಹೇಳಿ.
No, I mean, the memo says that SLP has been filed and it is being listed on 4-3.
ಹಾ
That is so far as the merit of this one concerned. My application today before your lordship is pertaining to the enquiry order about the receivers. Now, I mean, whatever happens so far as the merit is concerned, this is an independent proceeding about the receivers. All the three receivers, your lordship has ordered enquiry has to be held. Now, major portion of the papers pertaining to the third receiver is in this RFA, which will be relevant for the enquiry before the lower court, and I have given the list of those documents which also may be sent to the lower court because that will be relevant for the enquiry. That's all.
Now TCS have gone back.
No, Monday it is coming up. Kindly refer this matter for a week, your lord.
No, I mean, that has nothing to do with
No,
this.
Because we have sought for a stay of the matter. It is coming up on Monday because we have a 90 days appeal time. I'm requesting to,
ರೆಕಾರ್ಡ್ಸ್ ಹೋಗಿದ್ಯಾ ನಮ್ಮ ಹತ್ರನೇ ಇದೆ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀವಿ.
I am requesting your lordship to adjourn this matter for a week so that if no stay is there, the court can consider this application. That's why. And printout I am also sending.
Look, trial court records are concerned that have been transmitted.
We can defer it for a week. We'll list it in the next 4th ಏನಾಗುತ್ತೆ ಅಂತ ಗೊತ್ತಾಗುತ್ತಲ್ವಾ? We can have it in the next week. Yes,
I
please.
have no objection so far as that is concerned, but I am only pointing out.
We got
that-
your point. You say that it is not about the merits, but
Yes.
if they have questioned this also, and now he says that it is ordered to be listed on 4th. We'll defer it till next week.
What I mean.
No, as your lordship pleases, sir, because I mean, lower court records have already been transmitted, and only portion of the high court.
Justice Joshi, what do you say? They say.
ಮಾಡ್ಬೋದು ಅದಕ್ಕೆ can defer it by a week, there is no problem. But some of the documents, I think he is seeking transfer. Even his own documents, if you want, it can be the documents which you had produced may be returned to him.
This is, I mean, the report submitted by the receiver.
Receiver ಇದೆ, receiver
ಹೌದು.
ಇದೆ.
ಅದು ಯಾಕಂತಂದ್ರೆ that contains about 20 annexures, and his reply to the show cause notice, all those things are.
Even next Thursday list ಮಾಡೋಣ. Because Friday is holiday. ಕೇಳಿಸ್ತಿರ್ಲಿಲ್ವಾ? Council for responding.
Next Thursday.
Submits memo.
Next Thursday, your lordships.
Reporting that, yes, reporting that against the judgment of this court, the said response have preferred SLP number 5228 of 2024, and the same is order to be listed on 4/3/2024. He seeks to defer the matter. List on 7/3.
I am also passing on the printout. Yesterday night I taken.
ನೀವು ಹೇಳಿದ ಸುಳ್ಳು
Because he is disputing, that's why.
He did not dispute, Papa. Dispute badly. What he said is, it is not about the merits of the case, it is about the receiver's action.
It can.
He said it is not about the merits of the case. Even if we have preferred appeal, if these
Yes, yes.
records are sent, nothing is going to happen ಅಂತ ಹೇಳಿದ್ರು.
Please.
But anyway, because you say no, all right, we'll have it on Thursday. Thursday we'll have.
7/3.
Okay,
Okay.
brother, you can resume your work. Now,
Yes, madam, okay.
Single bench matter pertains to Bangalore bench. For order seal number 1, M. Krishnegowda, HCGP.
Responded.
Appeal number 1 and 2 are granted bail.
You have produced that copy?
Page 24, madam.
Page 20.
after release it.
Your petition was rejected on what ground?
It was not rejected, my lord. It was- In fact, your lordship has granted him bail,
ಅಲ್ಲ. Oh, absconding.
absconding.
But how are you entitled?
Now,
So where is that earlier order? Because he said.
Earlier order, my lord, is at page number 24, my lord.
ಹಿಂದೆ ಬಂದೋಗಿತ್ತಲ್ಲ.
24 of my petition.
No, 24, sorry. There are 1 and 2 are granted bail ಅಂತ. ಕೃಷ್ಣಮೂರ್ತಿ, ಇದ್ರಲ್ಲಿ 2 ಕೃಷ್ಣಮೂರ್ತಿ ಇದೆ, ಇಬ್ರು
Guru
ಕೃಷ್ಣಮೂರ್ತಿ.
Krishnamurthy. He is accused number 2, my lord.
Last week, A1 is granted bail from this honorable court. madam.
ಕೃಷ್ಣಮೂರ್ತಿ ಅಂತ, whose name was also ಕೃಷ್ಣಮೂರ್ತಿ ಅಂತ ಬರ್ದಿತ್ತು.
ಹೌದು.
ಬಟ್ ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕಲ್ಲ ಮತ್ತೆ ಹಾಗಿದ್ರೆ. We only have to memorize.
ಕೊಟ್ಟಿದ್ದೀನಿ.
ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ? ಈ ಕೊಟ್ಟು.
Last week ಅಲ್ಲಿ ಇದೇ ಕೋರ್ಟಲ್ಲಿ ಆಯ್ತು ಮಾಡಿ.
Copy.
ಅವ್ರಿಗೆ ಕೊಡ್ಬೇಕಲ್ಲ ನೀವು.
ಕೊಟ್ಟಿದ್ದೀನಿ.
ಇಲ್ಲ ನೀವು.
Copy.
We remembered because we had written the who was also other accused was also Krishnamurti ಅಂತ.
Please pass. By imposing 10,000 per cost melody allowed appeal number 1. Is appeal number 2.
ಅಲ್ಲಿ ಆ ಕೇಸಲ್ಲಿ his advocate did not appear.
Page 18, my lord, para 9.
Previous bail bond ಇದು ಆಗಿದೆ ಅಂತ 10,000 ರೂಪಾಯಿ ಫೈನ್ ಹಾಕಿ ಕೊಟ್ಟಿದ್ದೀವಿ. ಮಾಡ್ಬೋದಾ ಸೇಮ್ ಗ್ರೌಂಡ್ ಅಲ್ಲಿ? Because of him another accused suffered ಅಂತ ಏನೋ ಬರ್ದಂಗಿತ್ತು. film ನೋಡ್ತೀನಿ.
Here his explanation is that phone was silent. His explanation is that he lost the phone and he could not contact the lawyer.
ಎರಡೇ ಕೊಟ್ಟಿದ್ದೀರಾ ಕಾಪಿನ? This is 13,150. 2 ಕಾಪಿ ಯಾಕೆ ಕೊಟ್ಟಿದ್ದೀರಾ ಇದರಲ್ಲಿ? ಡಿಪೋಸಿಷನ್ ಏನೇನೋ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಒಂದು ಡಿಪೋಸಿಷನ್ಸ್ ಕೊಡ್ತೀವಿ. ಒಂದೇ ಒಂದು ಡಿಪೋಸಿಷನ್ ಆಗಿದೆ ಇದುವರೆಗೆ ಅದು ಕೂಡ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಇಂದ ಮೊಬೈಲ್ ರಿಕವರಿ ಅವನು.
ಕೋರ್ಟಿಗೆ ಅಪಿಯರ್ ಆದ್ರೆ ತಾನೇ ಅವ್ರು ಡಿಪೋಸಿಷನ್ ರೆಕಾರ್ಡ್ ಮಾಡೋದು.
This presentation was in judicial custody for a period of 3 years ಮೇಲೆ ಆ ಟೈಮಲ್ಲಿ ಚಾರ್ಜ್ ಕೂಡ ಆಯ್ತು. 3 ವರ್ಷ ಇದ್ದಾಗಲೂ ಒಂದೇ ವಿಟ್ನೆಸ್ ಬಂದಿರೋದು.
ಅದು ಬಂದಿರ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ you should take appropriate steps. ಅದ ಗ್ರೌಂಡ್ ಮೇಲೆ ಬೇಲ್ ಹಾಕೊಂಡು ಬರ್ಬೇಕು. ಬಟ್ he was already on bail, ಕಸ್ಟಡಿಯಲ್ಲಿ.
ಹೌದು.
He was on bail and then COVID happened and then he did not appear.
This was after year 2021 SC.
ಹೌದು.
ಆಯ್ತು ಮೇಡಮ್ ಬಸ್ ಏನೋ ಕೇಳ್ಬೇಕು ಹಾಗಿದ್ರೆ ಅದೊಂದು ರಿವಿಷನ್ ಹೋಗೋದು. ಇಲ್ಲ ಇದರಲ್ಲಿ one was some others were in custody.
This is what accused them.
Accused were involved.
Only 2 appeal.
Only 2 accused them.
Since how long he absconded?
1 year 9 months madam.
ಆ ಕೇಸಲ್ಲಿ
ಆ ಕೇಸಲ್ಲಿ he was absconded for a period of 4 years 9
4
months.
years ಅಂತ ಬರ್ದಿದ್ದೀವಿ.
4 years 9 months madam.
ಅವಾಗ ಡಿಸ್ಕಷನ್ ಮಾಡುವಾಗ ಹೇಳಿದ್ವಿ ಅಂತ ಕಾಣಿಸುತ್ತೆ. Because of him the other accused was also.
That is not.
What is his job?
ಕೂಲಿ ಕೆಲಸ ಮಾಡಿ ಡ್ರೈವರ್ ಕೆಲಸ ಮಾಡಿ.
ಎಲ್ಲಿ ವಾಸ ಇರೋದು?
ಇದು ಮಾಗಡಿ ತಾಲೂಕಲ್ಲಿ.
ಹುಡುಗ ಹೋಗಿ ಮಾಗಡಿ ತಾಲೂಕ್ ರಾಮನಗರ.
ವೆಂಕಟಯ್ಯನ ಪಾಳ್ಯ.
Trial is going on in which court? Nelamangala Road, sorry, SC number pending before 8th additional session judge, Bangalore Road. ನಾವು ಒಂದ್ ವೇಳೆ ಅವ್ರ ವಿಟ್ನೆಸಸ್ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಡ್ರಾಪ್ ಮಾಡಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಕ್ಲೋಸ್ ಮಾಡಿ ಅಂತ ಇನ್ಸಿಸ್ಟ್ ಮಾಡಬೇಕು ಸೆಷನ್ ಜಡ್ಜ್ ಮುಂದೆ. ಅಬ್ಸ್ಕಾಂಡ್ ಆಗೋದಲ್ಲ ಅದರಿಂದ ವಿಲ್ ಕನ್ಸಿಡರ್ ಅಂತ heard. bail order illiದೆ, earlier bail order.
That is page number 24, madam. ಅದು ಜಾಯಿಂಟ್ ಬೇಲ್ ಆರ್ಡರ್, ಇಬ್ಬರಿಗೂ ಒಂದೇ ಆರ್ಡರ್ ಆಗಿದೆ.
ಕಾಮನ್ ಆರ್ಡರ್.
ಕಾಮನ್ ಆರ್ಡರ್ 24 ಮೇಡಮ್ ಪೇಜ್.
ಇಬ್ಬರ ಹೆಸರು ಒಂದೇ ಇದೆ ಅಲ್ಲ?
ಹೌದು, ಇಬ್ರು ಹೆಸರು ಒಂದಿದೆ, ತಂದೆ ಹೆಸರು ಮಾತ್ರ.
ಇವ್ರ್ಯಾರು? Petitioner is accused number 2 in SC number 164. He was being tried with accused number 1. That is Krishnamurthy, son of Chinnaya. Chinnaya for the charges for the offences punishable under section 302, 201 IPC. The allegation that on 21/4/2017, between 9 PM and 10 PM, they murdered one slave Khalil near Mallara Banawadi Cross and robbed him of rupees 5,570 and his mobile phone. This court by order dated 20/12/2018 had granted bail to both the accused. On certain conditions. After granting bail, both the accused jumped the bail conditions and absconded. The present petitioner, ಇವರು abscond ಯಾವಾಗ ಆಗಿದ್ರು ಅನ್ನೋದು ಆರ್ಡರ್ ಅಲ್ಲಿ ಇದೆಯಾ? Where do we find that? ನೀವು ಹೇಳ್ತಾರೆ.
ಆರ್ಡರ್ ಶೀಟ್ ಇದೆ ಸರ್.
ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ?
ಆರ್ಡರ್ ಶೀಟ್ ಇದೆ. 11/1/2022 abscond ಆಗಿ 17/10.
ಪೇಜ್ ನಂಬರ್ ಹೇಳಿ. Where do we find it? ಪೇಜ್ ನಂಬರ್ ಹೇಳಿ.
ಅಲ್ಲ, ಇಲ್ಲ ಆರ್ಡರ್ ಶೀಟ್ ಕೋಡ್ ಕೊಟ್ಟಿದೆ ಸರ್.
ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ರೆಫರ್ ಮಾಡಿರ್ಬೇಕಲ್ಲ. ರಿಜೆಕ್ಟ್ ಮಾಡುವಾಗ ಈಗ
ಅದರಲ್ಲಿ ಏನು ಬರ್ದಿಲ್ಲ, ಅದರಲ್ಲಿ ಏನು ಬರ್ದಿಲ್ಲ.
ಈ ಲಾಸ್ಟ್ ಮೊಬೈಲ್ ಫೋನ್ ಅಂತ ಹೇಳ್ತಾರೆ 9/12. ಇವರು ಬಿಕಾಸ್ ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ 4 ವರ್ಷ ಅಂತ ಇದೆ, ಇವ್ರು ಹೇಳ್ತಾರೆ 1.5 ವರ್ಷ ಅಂತ.
1 ವರ್ಷ 9 ತಿಂಗಳು.
ಅದಕ್ಕೆ ಎಲ್ಲಿ ವೇರ್ ಡು ವಿ ಫೈಂಡ್ ದ ಮೆಟೀರಿಯಲ್?
ಲೋಯರ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಶೀಟ್ ಇದೆ ಸರ್.
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಯಾವ ಆರ್ಡರ್ ಏನು ಅಂತ
He is absent from 11/1/2022.
Yes, madam.
11/1/2022.
2022.
Yes.
ಮತ್ತೆ 1.5 ವರ್ಷ ಹೇಗಾಗುತ್ತೆ?
Secured on
Now he is arrested on which date?
17/10/2023.
17/10/2023.
10/2023.
ಕರೆಕ್ಟ್ ನೋಡಿದ್ರೆ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ
17/10/23.
ಯಾಕಂದ್ರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಅಲ್ಲಿ those dates are not being seen.
It's not there, madam, in that trial court order. We place this, madam.
It is submitted that so far as the petitioner, he failed to appear before the trial court between 11/1/2022 and 17/10/2023. Since he absconded, issued focus notice to keep the witness. ಅಲ್ಲ, ಇದು 18/10/2021. That is only.
ಅಲ್ಲ, ಹಿಂದಿನ ಪೇಜ್ ಅಲ್ಲಿ ಅಲ್ಲಿ ಕೆಳಗಡೆ
ಇಬ್ಬರದು ಹೆಸರು ಯಾರು A1
is A2, madam.
is A2.
A2.
ಅಲ್ಲ, abscond ಆಗಿದ್ದವಾಗ
Finally, he was traced.
mission to A2. ಇಲ್ಲಿ A2 present issue focus notice ಅಲ್ಲ ಆಯ್ತು. A2 absent 11.
Yes. Yes.
A2 absconded from 11/1/2022.
ಕರೆಕ್ಟ್. ಅದು ಇಲ್ಲಿ
ಅಲ್ಲಿ ಕೆಳಗಡೆ ಕೈ ಹ್ಯಾಂಡ್ ರೈಟ್ ಅಲ್ಲಿ
ಕೆಳಗಡೆ.
ಹೌದು. ಕರಿಯಪ್ಪ.
Admitted, no? Recently absconded, warrant and proclamation were issued against him. Proclamation issue ಮಾಡಿದ್ದಾರೆ. And ultimately he was secured on 17/10/2023. Appellant contends, petitioner contends that he could not contact his advocate and collect the case to the hearing dates. As he lost his cell phone, again a talk and bull story ಅಷ್ಟೇ. No, the same said explanation is not convincing. The fact remains that the case was based only on circumstantial evidence. Accused number 1, who similarly absconded, has been granted bail by this court on 16/2024 in criminal section number 13,115/2023. This petition also deserves to be allowed on the same grounds. This is a following order. The petition is allowed. Same idರಲ್ಲಿ ಏನು grounds ಇದಾವೆ ಇದನ್ನೆಲ್ಲ ಹೊರಗಡೆ ಹಾಕ್ತಾರೆ. Yes, on the same terms. ಇದು ಕೊಟ್ಬಿಡಿ.
Hearing on
circumstantial evidence ultimately acquittal ಆದ್ರೆ ಅನ್ನೋ ಕನಿಕರಕ್ಕೆ ಬಿಡ್ಬೇಕಷ್ಟೇ.
Please.
Hearing on A, serial number 2, Latif B, Manjunath K for R2.
Yeah, Farah.
But case law on merit law, the application was rejected. Successive bail application filed. Change circumstance law that appellant has been undergone 6 years, 1 month imprisonment from the date of arrest. Secondly, Lord, the accused number 2 was also convicted.
What is the earlier order? Earlier suspension.
Was rejected.
Date here. Oh, got it.
That is on
That 11/2/2020.
yes. Now, Lord, the accused number 2 of the mother was also convicted for 6 months. The 8 of section
6.
21. And she was no more now, Lord, on 12/12/2023 was fired. Now, Lord, the appellant is only the son, and the father already deserted the mother before her death. And he has undergone 6 years, 1 month imprisonment out of 10 years. And there is no other criminal antecedent.
Paper books ready ಆಗಿಲ್ವಾ? Paper books ready ಇಲ್ಲ ಮೇಡಮ್. ಯಾವಾಗ ಅಡ್ಮಿಟ್ ಆಗಿದ್ದು?
11/2/21.
11/2/21.
But the regular roster bench plots, now the 2012 matters are getting posted for final hearing.
ನೀವು early hearing ಹಾಕೊಳ್ಳಿ ಅಲ್ಲಿ.
But the lordship has directed, Lord,
ನಾವೇ ಡೈರೆಕ್ಷನ್ ಕೊಡ್ಬೇಕು ನಿಮ್ಗೆ if you want early hearing.
Lord,
Because sometime we only sitting for criminal roster.
Lord, I filed the citation, Lord, the recent affairs court held. While considering the suspension application, the huge pendency of the appeal is concerned, Lord, the honorable affairs court.
ಇದರಲ್ಲಿ reason is you only had not implemented respond number 2 first. ಅದರಿಂದ ಡಿಲೇ ಆಗಿದೆ ನೋಡಿ.
Implete ಮಾಡಿದ್ರು ಮೊನ್ನೆ last date.
ಕರೆಕ್ಟ್. ಇದು ನೀವು ಮೊದಲೇ ಮಾಡಿದ್ರೆ ಆಯ್ತು.
Implete and last date.
12/1/24.
Delay has occurred. You did not implement the victim first. ಅದಕ್ಕಾಗಿದೆ.
But the appeal is in the year 2020.
Police inspector. Under to the effect that respond.
24 application.
on the date, not while filing the appeal, not there was no, the office was not raised the objection for with regard to the pleading of the complainant.
Office will not do the advocacy.
In fact, the BBI judgment this court has held in 2021 itself, 2020 itself, that
The appeal is of the year.
this Honorable High Court in a PAL with respect to POXO cases, the matter was taken in a PAL where this Honorable Court had directed that the complaint should be made as party.
This appeal is of the year 2020.
20 ಅದು 20 BBI.
Lord, I placed the judgment, not the,
Right, sir.
the apex court in Saudar Singh case.
Sorry. This one, judgment. Very important. ಮೊದಲ you had filed it earlier or ಇದನ್ನ ಈಗ ಕೊಟ್ಟಿರೋದಲ್ಲ ಯಾವಾಗ ಕೊಟ್ಟಿದ್ದೀರಿ
Filed on,
ಅದು ರಿಸರ್ವ್ ಆಯ್ತು.
it's there in the file.
ಹಿಂದಿನ ಅಪ್ಲಿಕೇಶನ್ ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೇಕಾದ್ರೆ
Separate compilation ಕೊಟ್ಟಿದ್ದೀವಿ.
18/12/23 ma'am.
23 that was previous application time that the consent.
ಹೌದು.
Not in this case either.
ಇದ್ರಲ್ಲ.
This is 16/8/2023 all right. ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ 16/8/2023 ಇಂದ ಇದನ್ನ ಪೆಂಡಿಂಗ್ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ?
Not subsequently changed the money mother has expired on 12. Therefore, not I made him to file an application to move the application, to press the application. Initially, I thought for not increase bail also in the open court. Not meanwhile, the party was, the respondent was not the party. Therefore, I pleaded them. Now, Lord, I relying with three judgments, Lord, the apex court. The recent judgment, Lord, the last judgment, in Saudar Singh case.
You have not given any page initiation for the case.
Page number, Lord, 11, Saudar.
ಏನು ನೀವು ಮಾಡಿಲ್ಲ. Yes.
Para 4, we are also conscious in scenario where the appeal comes for a hearing and appellant may be seeking adjournment rather than during arguing the appeal. That case certainly would not be one for the grant of bail as the court is willing to bestow consideration for the merit of the appeal. We are also the agreement that the convict must approach the High Court first, as otherwise this court is being unnecessarily burdened. But then there must be a mechanism to see that if the approach of the High Court, those bail applications are promptly. In the context of our broad observation, incumbent on the High Court to place before us as to how the proposed to see that cases mentioned aforesaid are taken up for consideration for the bail. We may note that there may be even conviction in custody in cases other than life sentence cases. In those cases, again, the broad parameter of 50% of the actual sentences undergone can be basis for the grant of bail. Just 4 weeks time to the High Court to place before us their policy strategy in this behalf. By considering this proposition, what the coordinate bench also consider the bail application and granted bail. You kindly see the page number 4. In NDPS case.
You have not made any page initiation in this.
Criminal appeal, not the order in criminal appeal 1861/2021. The application was allowed on 28/11/2023. The coordinate bench, by considering the all other 2 more judgments, Lord, and by relying this judgment, granted bail by Saudar Singh versus Suitability. The Honorable Office could observe there in cases other than life sentences, broad parameter of 50% of the actual sentence undergone can be basis for grant of bail. And two more judgments, Mullah, on the page number 1 also, even though there is a rigor of section 37 there in the NDPS on the basis of conviction which was undergone for a 50% of the sir, the Honorable Appellate Court considered the bail application and granted bail.
Where are you reading this?
That is the first judgment, Ramni Singh versus intelligence.
ಏನಾದ್ರೂ ರೇಷಿಯೋ ಇದೆಯಾ ಅದ್ರಲ್ಲಿ?
ಇದೆ. The third paragraph, not the appellant was tried for offence number 21 of NDPS Act. The trial court by order date 2010 has passed an order of conviction and sentence for a period of 10 years and a pay a fine of rupees 1 lakh. 1 lakh in default shall undergo for a 1 year. Being aggrieved by the first aforesaid order passed by the trial court, appellant has filed an appeal. Appeal is pending before the High Court for consideration and decision. During the pendency of the appeal, appellant has filed an application on the suspension of sentence. That application was rejected by the High Court by its order, by its impugned judgment and order. Of course, that order is called in question by the appellate court before us in the appeal. The appellant has produced the certificate, the custody certificate issued the superintendent of jail on 30th and 2012. Perusal of the certificate indicates that appellant has already served sentence of 5 years, 4 months, 7 days as on the date of issuing certificate by the competent authority. The learned counsel for appellant submitted, since appellant has been custody more than half of the sentence passed by the trial court, High Court ought to have considered the request made by the appellant for suspension of sentence. P.P. Malhotra learned ASB submits that since the matter is under NDPS Act, the appellant is not entitled for discretionary relief of this court in granting the bail to the appellant, particularly in view of section 37 of the NDPS Act. We have carefully perused the order passed by the High Court. We have also seen that custody certificate is the appellant. In our opinion, since appeal is pending before the High Court, possibility of appeal is taken up for hearing the near future remote. Appellant is entitled for suspension of sentence during the pendency of the appeal before the High Court. The result, we allow the appeal to suspend the appellant during the pendency of the appeal before the High Court. Direct appellant shall be released on subject to satisfaction of the trial. The next judgment plot in conviction for 304B and 498A. There is sentence for 7 years. And Honorable Appellate Court, considering that he has undergone for half of the period and sentence was suspended and granted. And subsequently, this is the recent the 2021 judgment. It was followed by the coordinate bench. And this Honorable Court Lord consistently followed the dictum that Lord half of the sentence wherever is undergone, sentences were suspended. Not in the other than life sentences. Even life sentence is also concerned, Lord. The Honorable Appellate Court in Chintu Saini versus State of UP. In that case also, Lord, the Honorable Appellate Court, when the appellant was undergone for 9 years, in the case of life imprisonment, the Appellate Court has considered the bail application and sentence was suspended.
Yes, what do you say?
This is
ಆಫೀಸ್ ಸಬ್ಸೆಕ್ಷನ್ ಅಲ್ಲೇ ಹೋಗಿದೆ ಇದು ಟೈಮ್ ಎಷ್ಟು ಸರ್? It was admitted on 11/2/2021. Paper book ಮಾಡಕ್ಕೆ things are admitted. ಅದಾದ್ಮೇಲೆ ಪೇಪರ್ ಬುಕ್ ಮಾಡೋದಕ್ಕೆ ಪೇಪರ್ ಬುಕ್ಸ್ ಮಾಡೋದಕ್ಕೆ ಅವಾಗಲೇ ಆರ್ಡರ್ ಆಗಿದೆ.
ಬಿಡ್ತಾ ಇದೆ ಎಕ್ವಿಪ್ಮೆಂಟ್ ಇದೆ ಬೀಳ್ತಾನೆ
11/2/2021 ಲಿಸ್ಟ್ ಮಾಡಿದ್ದು 22 ವರೆಗೂ ಲಿಸ್ಟ್ ಮಾಡಲಿಲ್ಲ. When did you file? You had filed another application.
But prior to that, one more.
ಅಲ್ಲ IA1 of 2000.
ಎರಡು application ಇತ್ತು last date ಅಲ್ಲಿ not press ಮಾಡಿದೀನಿ.
ಮತ್ತೆ ನೀವು ಈ ತರ ಒಂದ್ರ ಮೇಲೆ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಾ ಇದ್ರೆ ಅವ್ರಿಗೆ
ಅದಾದ್ಮೇಲೆ
ಪೇಪರ್ಸೇ ಹೋಗೋದಿಲ್ಲ ಪೇಪರ್ ಬುಕ್ ಮಾಡೋದಕ್ಕೆ.
ತಾಯಿ ತೀರಿ ಹೋದ್ರು ಆಮೇಲೆ press that application.
Appellant's counsel has filed memo reporting that appellant.
Funeral ಗೂ ಹೋಗಿಲ್ಲ. But a report was filed from the jail authority to confirm that death also.
ನೀವು ಡೆತ್ ಆಫ್ ದ ಅಪೆಲೆಂಟ್ ಅಂತಾನೆ ಒಂದ್ಸರಿ ಮೆಮೊ ಹಾಕಿದ್ರು. Appellant's counsel has filed a memo reporting that appellant died.
Appellant, second appellant. That appellant, correct. That accused number 1 was also prepared an appeal. It was tagged together. ಆಮೇಲೆ lordship has passed an order of abatement.
That second.
ಹೌದು.
ಅದು ಡೀಲಿಂಗ್ ಆದ್ಮೇಲೆ ಒಂದೇ ಹೋಗ್ತದೆ.
ಹೌದು. ಜೈಲಲ್ಲಿ ಮಗನನ್ನ ನೋಡಕ್ ಹೋಗಿ ಅಲ್ಲೇ ಬಿದ್ದು ಸತ್ತಿರೋದು.
ಏನ್ ಮಾಡೋದು ಪಾಪ ತಾಯಂದ್ರಿಗೆ ಅಷ್ಟೇ ಕಷ್ಟ.
And major case, my lord, that it depends on the victim statement and doctor medical evidence.
No, what do we say about this? Merits, it's already rejected. What is proposition?
The proposition, my lord, that ultimately, my lord, if he is interested, the paper book can be prepared and then matter can be heard.
How he is in custody since when?
He has never been released.
January.
During trial he was in the custody.
He is in custody.
23/1/2018.
ತೋರಿಸಿದ್ದಾರೆ. Accused arrested on 23/1/2018.
18.
6 years 2 months ಆಗಿದೆ.
ಈಗ 2024. ಮಾರ್ಚ್ಗೆ ಬಂದಿದೆ. 6 years ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ.
5 years.
He is sentenced for 10 years.
10 years. Your lordship may see there are minimum imprisonment for POCSO offences. It is not that in a regular.
ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ವಲ್ಲ ಅದನ್ನ.
ಅಲ್ಲ ನಾವು ಮಾಡಿಲ್ಲ.
It has not preferred.
No, we are not.
Challenge the.
I am not seeking the acquittal.
Sentence.
Alla, we are not challenged, my lord, that in other offences, there is a discretion in giving imprisonment, not necessarily if the life imprisonment, 10 years imprisonment, 10 years has to be confirmed. Well,
High Court has sentenced him for 10 years.
10 years, that's the minimum imprisonment.
Correct, minimum, maximum ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ.
ಹೌದು.
There is, you have not prepared appeal.
We have not prepared.
That this was disproportionate.
Alla, the judgment which my learned friend is relying on.
No, rigor of 37 is there in the.
This was not a case of penetrative sexual assault.
He has inserted a finger, my lord.
Before amendment, 2018 amendment ಮೊದಲು 7 years ಇತ್ತು minimum. 2000 before amendment.
ಇಲ್ಲ ಸೆಂಟೆನ್ಸ್ ಬಗ್ಗೆ ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಇದು ಕೊಡಿ.
Sentence, my lord, is that.
Why, what were the mitigating circumstances? 376(2)(1 ಅಂತ.
Yes.
10 POCSO Act should not be
Page
less than
48, 49, madam.
6 there was. Then note 49. 376 rigorous imprisonment for a period which shall not be less than 10 years ಅಂತಾನೆ ಇದೆ.
ಹೌದು.
7 years ಅಲ್ಲ. The judge has discussed.
Now it has become 20 years.
POCSO ಅವರು 6, 8 ಅದು ಆಗಿಲ್ಲ ಅದು.
That is aggravative and penetrative. Section 4.
ಕರೆಕ್ಟ್ ಅದನ್ನ ಸೆಕ್ಷನ್
Special Act ಪ್ರಕಾರ conviction ಕೊಟ್ರೆ section 4 ಮೇಲೆ.
ಅದರಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ ರೀ ಅದು ಯಾವ given under section 376.
376.
POCSOದಲ್ಲಿ section
6, madam.
6 ಕೊಟ್ಟಿದ್ದಾರೆ.
shall be punished with rigorous imprisonment which shall not be less than 10 years.
Yes, madam.
6 ಬಂದ್ರೆ.
ಅಲ್ಲೇನು 10 years.
4 ಇದ್ದಾಗ ಅವಾಗ 7 ಇತ್ತು.
376 2 10 years.
ಹೌದು.
10 ಗೆ 5 years. 21.
4 ಬಂದ್ರೆ 7 years.
ಮದರ್ಗೆ ಅಂತ ಕಾಣಿಸುತ್ತೆ. 21 is
abatement ಅಂತ.
abatement.
ಹೌದು.
But she was acquitted.
No, she is convicted for 6 months. 6 months. Why not 6 ಗೆ ಮತ್ತೆ 21 ಗೆ she is been convicted for 6.
Correct, ಅವ್ರದ್ದು appeal ಇತ್ತು.
ಹೌದು.
ಹೌದು. It is lesser ಬಂದ್ರು 4 years, but section 4 ಬಂದ್ರು 7.
Trying to see why how the trial court analyzed that minimum sentence shall be granted.
ಅದ್ರ ಬಗ್ಗೆ ಇಲ್ಲ, ಡೈರೆಕ್ಟ್ಲಿ section 6 ಗೆ ಬಂದಿದ್ದಾರೆ penalty, aggravative penalty.
ಏನು ಡಿಸ್ಕಷನ್ ಮಾಡಿಲ್ಲ.
ಏನ್ ಡಿಸ್ಕಷನ್?
ಬರೀ ಯಾವ offense ಗೆ ಎಷ್ಟು ಸೆಂಟೆನ್ಸ್ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
Except one para, my lord, on behalf of the prosecution, no material is produced.
ಪ್ರೊಡ್ಯೂಸ್ಡ್ ಆಯ್ತು ಅದ್ರಲ್ಲಿ.
ಹೌದು.
ಫೈನಾನ್ಷಿಯಲಿ ಸೌಂಡ್ ಅಂತ ತೋರಿಸೋದಕ್ಕೆ ಏನು
ಹೌದು.
ಕೊಟ್ಟಿಲ್ಲ. To impose substantial fine.
In fact, your lordship, when you are imposing a minimum sentence, question of technically hearing sentence does not arise.
ಅಲ್ಲ, section 6 or 4
If
ಅಂತ
you're- if you're hearing on a maximum sentence, question of hearing the,
Trial court has to hear both of you and give some reasons.
yes,
Why it is giving this much of sentence ಅಂತ.
yes,
ಏನಾದ್ರು
there's,
reasons
there's no discussion.
There's no discussion. He was aged, ಎಷ್ಟು 42.
He is, my lord, on that,
ಅಪೀಲ್ ಹಾಕುವಾಗ 44.
ಹೌದು.
the girl is, my lord, 12 years old, less than 12 years.
ಅಲ್ಲ ಈ ತರ ಇದ್ರೆ their cravings relapse. ಅದು we have to hear them appeal there. That is correct. One disturbing thing is our registry has not prepared the paper books, though we have directed them to prepare the paper books in the year 2021 itself.
Your lordship can take up, my lord, with ultimately the evidence, my lord, is the victim's evidence and the doctor evidence.
Single
If my learned friends,
Yes, it will go before roster bench.
2012 ಅಂತ ನಮಗೆ ಗೊತ್ತಿಲ್ಲ.
Because of
ಯಾವ appeal ನಡೀತಾ ಇದೆ
2012 ನಡೀತಾ ಇದೆ.
ಕೇಳ್ಬೇಕು ನಾವು ನಮ್ಮ ರಿಜಿಸ್ಟ್ರಿ ಅವ್ರನ್ನ.
ಅಲ್ಲ, ಲಿಸ್ಟ್ ಅಲ್ಲಿ ನಾನೇ ಅಪಿಯರ್ ಆಗ್ತಾ ಇದ್ದೆ 2012.
ಅವ್ರದ್ದು explanation call for ಮಾಡೋಣ ಮೊದಲು. Why they have not prepared the paper books ಅಂತ.
Yes, Lord,
ಮತ್ತೆ check
meanwhile,
ಮಾಡ್ಬೇಕು.
Lord, my
Check
house,
ಮಾಡ್ಬೇಕು.
Lord,
ಅಲ್ಲ,
is
correct
not.
Mr. ಲತೀಫ್, ನೀವು ಹೇಳೋದ್ರ ಮೇಲೆ ನಾವು 2012 ನಡೀತಾ ಇದೆ ಅಂತ ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ. 2012 ವೆದರ್ ಕಸ್ಟಡಿ ಅಕ್ಯೂಸ್ಡ್ 2012 ಕಸ್ಟಡಿ ಅಕ್ಯೂಸ್ಡ್ ನಡೀತಾ ಇದೆ. ಇನ್ನು ಹಿಯರಿಂಗ್ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಒಂದು ಸಿಂಗಲ್ ಜಡ್ಜ್ ಎದುರಿಗೆ 2012 ಕಸ್ಟಡಿ ಮ್ಯಾಟರ್ಸ್ ನಡೀತಾ ಇದಾವ.
ಅಷ್ಟೇ ಅಲ್ಲ, ನಾರ್ಮಲ್ ಕೇಸ್ 2012.
ನಾರ್ಮಲ್ ಅಲ್ಲ, ಕಸ್ಟಡಿ ದೇ ಹ್ಯಾವ್ ಟು ಟೇಕ್
Will verify.
ರೆಫರೆನ್ಸ್.
will verify.
Verify, but this this is the second successive petition of appellant for seeking suspension. The ground that there is delay in hearing the Learned counsel for the appellant submits that presently 2012 criminal appeals are being taken up. ಬೇಲ್ ನಲ್ಲಿರೋದ ಕಸ್ಟಡಿಯಲ್ಲಿರೋದ ಗೊತ್ತಿಲ್ವಾ? ಕಸ್ಟಡಿಯಲ್ಲಿರೋದ ಬೇಲಲ್ಲಿರೋದ 2012 ಅಂದ್ರೆ ಕಸ್ಟಡಿ ಅದಕ್ಕಿಂತ ಪ್ರಿಫರೆನ್ಸ್ ಕೊಟ್ಟಿರ್ತಾರಲ್ಲ. ಸೆಪರೇಟ್ ಡೆಸ್ಪೈಟ್
ಅವ್ರಿಗೆಲ್ಲ ಗೊತ್ತಿರ್ತದೆ.
Will secure, my lord, I have.
learned HCP 6 time.
Additional
SPP.
Additional SPP.
Additional SPP 6 time to verify and submit. Despite this court directing on 11/2/2021 itself to prepare the paper books for 22, 23, 24 for more than 3 years. The registry has not prepared the paper books. ಏನ್ ಪ್ರತಿ ಸರಿ ಬರ್ದು ನಮ್ಗೆ ಸಾಕಾಗ್ಬಿಟ್ಟಿದೆ. ಪ್ಲೇಸ್ ದ ಮ್ಯಾಟರ್ ವಿತ್ ಆನರಬಲ್ ದ ಚೀಫ್. ಈ ಪಾಪಿ ಇಷ್ಟು ಸಣ್ಣ ವಿಷಯಕ್ಕೆ ಅವ್ರ ಒಂದು ಪ್ಲೇಸ್ ಅಂತ ಮಾಡೋದು. ಬಟ್ ಅಲ್ಲಿ ಇವ್ರಿಗೆ ಹೇಳಿದ್ರೆ ಒಂದ್ ಏನಾರ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ತಗೊಂಡ್ಬಂದಿರ್ತಾರೆ, ಅದನ್ನೇ ಒಂದ್ ಕೆಲಸ ನಾವೇ ಮಾಡ್ತಿರ್ಬೇಕು. ಯಾಕೆ ಪೇಪರ್ ರೆಡಿ ಮಾಡೋದಿಲ್ಲ 3 ವರ್ಷ? ಅಲ್ಲ ಕಡೆಗೆ ಅವ್ರಿಗೆ ಹಾಕಂತ ಹೇಳ್ತೀವಿ, ಇವ್ರಿಗೆ ಆಗೋದಿಲ್ಲ ಅಂತಂದ್ರೆ ಹ್ಯಾಂಡ್ಸ್ ಕಡಿಮೆ. ಯಾವ್ದು ಕಸ್ಟಡಿಯಲ್ಲಿ ಇರ್ತಾರೆ ಅದನ್ನ ಮೊದಲು ಮಾಡ್ಬೇಕಲ್ಲ. ಇದು ಒಂದೇ ಇಲ್ಲ, ಎಲ್ಲದ್ರಲ್ಲೂ ಹೀಗೆ. ಇದು ಬೇಲಲ್ಲ, ಇತ್ತು ಬೇರೆದ್ರಲ್ಲ. Concern shall submit their explanation. ಅವ್ರದೇ ಕನ್ಸರ್ನ್ ಅಂದ್ರೆ ಯಾರು ಅಂತ ಗೊತ್ತಿಲ್ಲ. Registrar judicial shall submit his explanation regarding the same. ಇಲ್ಲಿ ಮಾಡಿದ್ರೆ ಬರೀ ಅದನ್ನ ತಂದು ಕೊಡ್ತಾರೆ, ನಾವು ಅದ್ರ ಮೇಲೆ ಮತ್ತೆ accepted taken on record ಇದೇ ಆಗುತ್ತೆ. ಹಾಗೆ ಬೇಡ, place the matter before Honorable the Chief Justice for needful action. List on it. ಆಯ್ತು, next week ಅದು submit. Submit.
ನಮ್ಮ ಪ್ರೆಸೆನ್ಸ್ ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ದೀರಿ ಅಷ್ಟೇ.
If
ಪರವಾಗಿ
which year's appeals, custody appeals are being taken up presently. List next week ಅವ್ರು ಹೇಳಿದ್ಮೇಲೆ ಮಾಡೋಣ. Next week. Wednesday 15th Thursday ಹಾಕೊಂಡಿದ್ವಲ್ಲ ಅದ್ರ ಜೊತೆಗೆ 7.
Madam, my presence, I am for art to HCLS I am for.
Is appearing for victim in this case.
ಕರೆಕ್ಟ್, ಏನಾರು ಹೇಳೋದಿತ್ತ ನಿಮ್ಗೆ?
ಇಲ್ಲ, my presence may be.
ಪ್ರೆಸೆನ್ಸ್ ನೋಡಿ ಅಲ್ಲ, ಅಬ್ಜೆಕ್ಷನ್ ಏನಾರು ಹಾಕೋದು ಏನಾರು ನೋಡೋದಿತ್ತ?
Next year.
ಯಾರು ಸಪೋರ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಬರ್ದಿದ್ದೀವಿ ನಾನು.
If you are supporting.
ಯಾರು ಶ್ರೀ ಸೋನ್ಸೋ
ಮಂಜುನಾಥ.
seeks time to submit his objections to I number 1 of 20. The file counter to I 1 of 20. ಅದು ಬರದ ಮೇಲೆ ಮುಂದಿಂದೆಲ್ಲ ಲಿಸ್ಟ್ ಏನ್ ಹೇಳ್ತಾರೆ ಹೇಳಿ, ಒಂದು ಅಪಾರ್ಚುನಿಟಿ ಇರುತ್ತಲ್ಲ ನೋಡೋಣ. ನೀವು ಅವ್ರು 3 ವರ್ಷ ಇಟ್ಕೊಂಡು ಕುಂತ್ರೆ ಸುಮ್ಮನೆ ಇರ್ತೀರಿ. ನಿಮ್ಗೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ದಾಗ್ಲೇ
ತಾಯಿ ಡೆತ್ ಆದಾಗ
ಅವ್ರದಲ್ಲ ರೀ, ರಿಜಿಸ್ಟ್ರಿಯಲ್ಲಿ 3 ವರ್ಷ ಪೇಪರ್ ಬುಕ್ ರೆಡಿ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅವಾಗ ಬಂದು ನಮ್ಮ ಮುಂದೆ ಕಂಪ್ಲೇಂಟ್ ಮಾಡೋದಿಲ್ಲ. ನಿಮ್ಗೆ ಬೇರೆ
HCLS report.